So there we go. We're going to need to unmute. Perfect. Okay. Mr. President, good morning. We have the witness in the waiting room ready to go. I'll go off camera and wait to hear from you on when to bring him in.
Yes, thank you very much. There's one item of housekeeping. Mr. Cowley, you were going to produce names of witnesses that you would wish to cross-examine on the new TINCO material.
Yes, Your Honor. The new exhibits that this relates to are C208 and 209. And I will identify now both Mr. Ivo Imena and Mr. Guattari. I think it's unlikely that I would question both about it, but at this point, I'm not, we're at a stage where the cross-examination is still going to change.
Quite understand. Thank you. Is there any other matters of housekeeping before we continue? His reaction. Well, we haven't got it yet, I think. Yeah. Well, we can give them a longer for that. No, very well then. Yes,
Your Honor. I thought the respondent was raising with us this morning. I received an email from the respondent demanding a production of metadata regarding one of the additional documents you had asked us to send over, and that we were supposed to produce it before this hearing. Now, obviously, that's physically impossible for a couple of reasons. I received that email at 4 o'clock this morning when I woke. But we would like to address the issue of a demand for metadata being produced for these new documents. We will undertake to work with an IT professional at our firm who only after we work with them could we make a representation about how much metadata is preserved when we take it out of somebody else's, I believe it's a Yahoo email account. And we could work with that, and we'll confer with respondents' counsel. But as a reminder to the respondents and the tribunal, we had requested metadata regarding 3 documents the respondents produced, which we questioned when they were created and challenged the authenticity of. And the respondents took the position it's completely irrelevant to have metadata and not reasonable to ask to produce it. And the tribunal upheld that. We would like it to be mutual, and we would like to revisit and have the respondents undertake the same obligation to produce the metadata regarding those 3 documents that we asked for many months ago.
Yes, Mr. Hill.
We haven't yet made an application to the tribunal. We have requested metadata from Mr. Cowley's side. If he has a difficulty in producing it, he can identify that to us. We will consider, and then if there's an application to be made to the tribunal, we will make it. I hadn't anticipated spending time now when I want to get on with cross-examining Mr. Marshall on this.
Yes, well, there was a second point. There was a second point. Mr. Cowley said he's made a similar request to you in relation to 3 documents whose authenticity is challenged. I don't expect you to deal with that off the cuff, but
no, I can't. I have no idea about it. I don't know if it's reasonable. I just don't know. I will make inquiries.
Yes, very well. Thank you. Then we'll have the witness back, please.
Okay, we're bringing him in now.
Mr. Marshall, we were dealing on yesterday with the cooperation agreement. And can we look at the claimant's application to introduce additional facts, which was submitted late last week? If FTI could bring that up. And this is an application to adduce what your side explained was an email from Mr. Ehlers attaching the cooperation agreement. And can we look at paragraph 17? So this document says, claimant's request leave submit as evidence, email correspondence from Anthony Ehlers attaching a copy of the cooperation agreement. The version of the cooperation agreement was exhibited as C122, and the signature line for Mr. Ehlers was entered by Tom Gray on or about March 30th, 2011, months after the cooperation agreement was signed, because of a need for a wet ink and stamped version, which did not yet exist. And then a little lower down, in paragraph 18, in the second sentence, it says, the email communication claimants were able to obtain calls into serious question the veracity of Mr. Ehlers' statement. Claimants acknowledge that Mr. Ehlers' personal signature is not on the version exhibited at C122. Instead, that copy bears a signature entered by Tom Gray for the purposes of creating a properly stamped company record. But the email and attachment which claimants have now obtained establish that Mr. Ehlers did in fact receive and sign the cooperation agreement, the content of which is identical to version submitted at C122. Now, presumably what's said in these paragraphs came on instruction from you, is that correct?
I'm sorry, say it again.
Well, you must have given your attorneys the information for what's said in these paragraphs, yes?
I think generally, but are you referring to something specific?
Well, the two sections I've just read out, need for a wet ink and stamped version, Mr. Gray entering signature for the purpose of creating a properly stamped company record, these agreements being the same. That's all come from you, hasn't it?
Well, no, I mean, the document came from him. As I recall, it was signed in counterparts. You were drawn, or he, in his affidavit, as I recall, had claimed that he'd never seen the agreement before and we were never in a cooperation agreement.
Just trying to establish with you how what's said in these paragraphs came to be said. And presumably you gave instructions to your attorneys on the basis of which this was said. They can't have got it from anywhere else, can they?
Yeah.
I would like to ask the tribunal for instruction that the witness does not need to disclose and should not be disclosing attorney-client communications. If the question is simply, did he provide the document or did he provide the actual information, but not what was said with attorneys?
No, I'm not asking for details of legal advice. I'm just, as exactly as Mr. Cowley says, did he provide the information?
I provided my attorney with that email, yes.
And the information that creates this representation. Yes?
Again, I can make...
Sorry, no, you need to be more specific when you say this representation.
Well, what this statement says is that there is an identical version of this agreement.
Yes.
And that Mr. Gray put on this signature to create a wet ink and stamped version of this agreement. And that came from you, presumably.
That's all true.
Well, those representations were untrue, weren't they?
No, those representations are true.
And you must have been aware that it was false to state that the content of this agreement, the content of the document attached to Mr. Ehlers, is the same as the cooperation agreement that had previously been exhibited, and that what was said about Mr. Gray must also be false.
I'd like to object. Hold on, Rod. I'd like to object to and ask the tribunal to please, despite the statement that he's not asking for communications with counsel, he is, and he continues to ask, and he's saying that these are representations of Rod. I can make a representation to the tribunal, given the timing, and Rod never saw this before it was submitted. So to suggest that he's not asking about communications when the simple question that he's refusing to ask is whether he even saw the document before it went out, he refuses to ask. And instead, he's trying to suggest, this is what Rod said. This is what we wrote.
Mr.
And
Cowley,
I think it's grossly unfair.
Mr. Cowley, the cross-examination on this point has first of all sought to establish whether the facts pleaded were facts supplied by the witness, and he said yes. It's now being put to the witness that those facts were not true. That is not trying to establish client-attorney communications. It's a question of fact, and it's a perfectly proper question.
But he's tying me, maybe I'm misunderstanding, but isn't he trying to tie me to language that I've not seen before?
Well,
I agree.
don't worry about what your counsel just said. Just listen to my questions, please, Mr. Marshall. Now,
before you ask the question, are copies of the email in question, of the document in question, available?
Yes, Mr. President, I'm about to look at the document, the contract in question, and put it side by side with the other one.
Very well.
Now, can we look at C122, which is the version that was already in the trial bundle? And if FTI can put that up and put up C210 beside it. Then scroll down into 10, so we have the agreement. So I want the two versions of the agreement. So don't worry about the covering email FTI. I just want C122 and exactly. Thank you very much. Now, C210 is the version that bears Mr. E on its face, bears Mr. Ayler's signature, and which your side provided us with yesterday.
Yeah.
And this draft agreement is not the same, is it? Not identical, as was represented to the tribunal, not identical to the version in C122, which was in the trial bundle. That's correct, isn't it?
I think there are two things going on here, if my memory serves me right. That this was to be able to show confirming, and I don't know what wet ink means, but that this agreement continues.
Mr. Marshall,
Yeah.
I wonder if you could help us, because we want to save as much time as possible. A very simple question was put to you. Will you listen to the questions and try to answer them? The question was whether the two documents were the same. It was put to you they were not. That's susceptible to a single word answer.
That's right. I see that there are differences. One looks longer without reading the text of the document. I can agree.
Thank you very much. Yes.
And you knew there were differences, didn't you, before the application was made to adduce this document?
Before the application was
Before
made.
the application was made at the end of last week to adduce this document, you knew there were differences between the two versions of a document, didn't you?
No.
Well, let's look at some of these differences. And just while I'm doing this, I'm just going to make clear, for the purposes of the questions I'm about to give, I'm going to assume in favor of the claimants that what we have on the left-hand side is in fact an authentic document from Mr. Ayler's. But I just want to make clear that even that is currently not accepted on our side. Let's look at paragraph 1.
How can it be authentic and not accepted?
I'm just assuming for the purposes of these questions, with your side's submission, that there is something that's authentic from Mr. Ayler's, but I'm just not accepting that. So, but don't worry about that. I'm just making it clear for the record. Let's look at paragraph 1 of the cooperation agreement that Mr. Ayler signed. So that's at C, that's the one on the left-hand side. You can see that in his version, NRD are to manage the operation of the concessions for BVG. Do you see that? During the period of this agreement, NRD shall manage the operations of a concession for BVG.
Yes.
In the version that does not bear Mr. Ayler's signature, but which someone's added his name to, we have a different obligation on NRD in that they are to manage the concessions at the direction and instruction of BVG. Yes?
I see that.
So it's a different obligation. It moves from being a discretionary operation to one where they're obeying the instructions of BVG. Yes?
I see the difference in language.
Paragraph 3 provides for an obligation on NRD to loan equipment, and just in parentheses, the costs of that operation are then to be split. So this is a cost to NRD. Under Mr. Ayler's version, NRD has to loan enough machinery and equipment for minerals to be processed at Big Argu. Yes, do you see that?
Yes.
Under the version Mr. Ayler's did not sign, NRD's obligation is wider than that. It has to loan enough to enable minerals to be processed at other sites too. Yes?
I see the language is different.
Paragraph 4. This provides, under Mr. Ayler's version, another obligation on NRD to create a program of cooperative artisanal miners, supervisors and security on Bisesero. Do you see that? Under
Yes.
your version, not signed by Mr. Ayler's, NRD is under a new obligation to operate at the direction of BVG.
Yes, I see a difference.
Down to, and I'm just to be clear, I'm not taking all the differences to you, I'm just taking some of them. Down to the bottom, paragraph 8, under Mr. Ayler's version, if it is his, this agreement shall be governed by English law and any dispute shall be resolved in the UK. Under the version not signed by him, the agreement should be governed by United States law and any dispute shall be resolved in the USA.
Yes,
So different law, different jurisdiction, yes?
I see there's difference in the language.
And that last point, quite material, given that on your case, which we don't accept, there was a significant liability and claim that BVG had against NRD on the according to your case. So rather important to know where you're going to
I
litigate.
think your mistake is that this document, as far as I know, was never presented to start. This was a record-keeping exercise within NRD.
Well, just to make sure I understand that, this isn't a document which you say was a cooperation agreement you say arrived at in November 2010, when Stark were still the owners of NRD.
I'm sorry, say the question again.
This is a document an agreement you say was arrived at in November 2010, when Stark were still the owners of NRD.
Yes, it was written at the instruction of, I would guess Tony Ehlers had written it in to memorialize what had been happening between the companies from August, early September until he wanted it documented as of November 1st.
You haven't produced any document, have you, showing any actual agreement between the parties as to, for example, the law or jurisdiction applying to this arrangement? Correct?
I'm sorry?
You haven't produced any document showing any actual agreement between the parties, for example, as to the law or jurisdiction applying to this arrangement.
I have no recollection of when or why this second confirmed agreement was signed. To my recollection is it's this agreement with Tony Ehlers and that it was signed in counterparts. Do you have any document to suggest that there was a different scenario? Because I don't recall.
Do you have any document to suggest there was any meeting of minds between NRD and BVG on the specific terms of any cooperation arrangement?
My recollection is that it was signed in counterparts, and it's this document on the left.
Well, there's in fact no completed agreement in which the parties mutually agreed the terms of any cooperation, was there?
It was signed in counterparts. Yes, there was.
Well, let's go back again to the claimant's request to introduce additional facts and look again at what was being said on instruction from you. Paragraph 17. You say a version of the cooperation agreement was exhibited as C122, and the signature line was entered by Tom Gray on or about March 30th, months after the cooperation agreement was signed, because of the need for a wet ink and stamped version. And then, as we saw before in paragraph 18, it came to acknowledge Mr. Ayler's personal signature is not on the version. Instead, that copy bears the signature entered by Tom Gray for the purposes of creating a properly stamped company record. And then, as we saw the stamps on that version of C122. We saw the stamp from both NRD and from BVG. And so this is saying that the version at C12 had this signature added by Mr. Gray, so there could be a properly stamped company record. In other words, it was included in the company's records as being a genuine binding agreement, wasn't it?
It was a company record. Did the terms, we purchased the company in December 23rd, 2010. And were there additional terms that were reflected and that made the difference? I don't know.
Well, this was included in the company's records as being a genuine binding agreement, wasn't it?
I'm sorry?
This was included in the company's records as being a genuine binding agreement. That's why the stamps are put on it, as is explained in these.
Yeah, but did it reflect additional changes? I don't recollect that. Remember, Bayview Gump as a company was already gone at this point. What the purpose of this document was to restamp it in March when the company was already out of business and was not even allowed to be operating in Rwanda. I don't know I don't have any recollection of what that was.
But although the stamps have been put on this document, it didn't reflect the agreement, the meeting of minds that the parties had in fact reached, did it?
At that point, it was a relationship between NRD and Bayview Group, both owned by us.
But it's still got a November date and Mr. Ayler's name written into it.
I don't dispute that. I don't recollect what the scenario was. The point I'm trying to make is that, as far as I know, I can't even imagine a scenario where a company which is defunct and has no business, what they were thinking when this was drafted.
It's a false document in your company's records, isn't it?
I'm sorry?
It's a false document in your company's records.
False document. No, it is not a false document.
And you put it forward in this arbitration as being a cooperation agreement actually arrived at in the terms of this document.
I fully recognize that there are two versions of it. Which one is binding? Why it got to a point where there was some additional negotiations, I don't know. This says confirmed as of, I don't have it in front of me now, but confirmed as of a date in March when Bayview Group did not exist anymore.
I suggest you're also aware that submissions being made to the tribunal as recently at the end of last week were also false.
Oh, nothing is false.
Now, Mr. Ehlers explained in his evidence that he did recall discussing a joint venture between BVG and NRD in broad terms, and that you did want, as BVG, to be using NRD's equipment to start mining operations.
Are you leaving these? Sorry, are you leaving these two documents?
So,
Mr. Hill?
yeah. So I'm sorry.
Just, I'd like to know whose the signature is under confirmed 30th of March.
No, let's go back to them. If FGI can pull them back up again. Yes. So, Mr. President, this is the signatures under
Confirmed. Perhaps Mr. Marshall can tell us whose signature that is.
I'm sorry, I missed the question.
Yeah, you drew attention to the fact that the stamped version has added to it, confirmed, 30th of March 2011. There is a signature underneath that. And
Right.
I would like to know whose signature that is.
That's Thomas Gray. He's the same initials next to A. Ehlers above that.
Thank you.
So he signed on behalf. Thomas Gray was our then operations manager.
Yes, thank you.
The other signature, William Quam, is also an American. He was there in a variety of consulting roles.
So I was just going back to what Mr. Ehlers says about all this. He explained in his evidence that he did recall discussing a joint venture between BBG and NRD, and that you did indeed want, as BBG, to be using NRD's equipment to start mining operations. What he says is that NRD did not in fact do anything at Bisesero prior to your acquisition of NRD, and NRD certainly did not receive.
He's a liar.
And the reality is that there was discussion of a joint venture, but nothing was ever actually done, correct?
That's untrue, completely untrue.
And there wasn't even any actual agreement.
Very bad falling out with Anthony Ehlers. He committed unspeakable crimes, and he has a lot to be trying to get back whatever shred of credibility he has.
Well, that's just an example of something we're about to see a lot of in this arbitration in correspondence from you, of wild exaggeration and slurring the name of any person who disagrees with you. That's fair, isn't it, Mr. Marshall?
No, that is definitely not fair.
And there wasn't even any actual agreement as to terms between NRD and BVG, and we can see that even from the material that you've now put forward to rely on. Correct?
No. I'm sorry?
Simply untrue.
No, we addressed this yesterday, and my statements have been true.
Now, I'm going to go back to where we were yesterday evening when we broke. We were looking at the contract, which is at bundle C017, if that could be pulled back up. And you'll recall that I was saying, suggesting to you that the guarantee or assurance that you say existed as to long-term licenses is not reflected in the contract. And I just want to look at an answer you gave yesterday. It's in yesterday's transcript, if that could be pulled up, at page 234, line 1 to 2.
My apologies. I will need 1 minute for that transcript.
That's no problem. So it's page 234.
Can you put it on the other screen, please?
So perhaps we look at the bottom of 235 as well, just so Mr. Marshall remembers how this arose. Sorry, 233, I mean. So I say, just to be clear, is it your evidence you knew at the time this guarantee of a long-term license was not in the contract? You say it's not in this contract document, but we understood it to be in other documents.
I don't have anything I can look at yet.
I'm sorry. I'll just tell me when you have. So, Mr. Marshall, you don't have a screen that's showing this in a way that you can read it. Is that the problem?
They're working with both screens at once and not yet.
Mr. Marshall, you should see it now on the screen on the left, which you can, that is the full-size version that I just enabled on your screen on the left that you should be able to see in bigger text, and you can scroll up and down.
Can I change the size of the text?
Yes, you can just click the plus sign, make it bigger.
So there's a question at the bottom of page 233. I say, just to be clear, is it your evidence you knew at the time that this guarantee of a long-term license was not in the contract? You say it's not in this contract document, but we understood it to be in other documents.
No. Perhaps I misspoke. The word, as I understand the conversation, I don't see it here, but the conversation was about whether the word guarantee was here. And as which I agreed with you, the word guarantee is not here. But that is
Come
not.
on, Mr. Marshall. Are you suggesting that the substance of this guarantee obligation is in the contract?
Am I suggesting what?
That the substance of this guarantee obligation is to be found in this contract?
Yes.
But we'll go back and look at the contract then. That wasn't your evidence last night, was it?
Come on, Mr. Hill, let's be polite.
It wasn't your evidence last night, was it, Mr. Marshall?
No, it was not, Mr. Hill. It was it is what I said last night.
And these other...
Can I have the document? This is really frustrating for me.
These other just going back to the transcript, the other documents.
You asked me about whether the word, I'm not trying to be argumentative, but my recollection of the discussion last night was you asked me if the word guarantee is there. You were not asking whether the substance of a guarantee is there. And no, I'm not contradicting myself.
Well, we can all look at the transcript and we'll go back to that. Let's just go back to the answer you gave. It's disappeared off my screen. I wonder if it can reappear.
I have the.
So the question, it's clear from my question, I wasn't talking about the word guarantee. Just to be clear, is it your evidence you knew at the time that this guarantee of a long-term license was not in the contract? No. You say it's not in this contract document, but we understood it to be in other documents. Now, I just want to ask you which... And
I clarified my answer there, didn't I, in the next sentence by saying, I understand that they don't use the word guarantee here, but we understood the meaning of this the way it was going to be interpreted.
Just try to focus on my question. Just try to focus on my question. Which other documents are you referring to where this guarantee is to be found?
I think it's here, and I think it's in the whole pattern of behavior, and certainly it would have been discussed.
So you are unable to identify other documents that you thought this guarantee was to be found?
Give us back our documents, I'm sure I can.
You said in your evidence, we understood it to be in other documents. Are you suggesting that when you did due diligence on this company, you found other documents that contained this guarantee obligation?
No, those are two different things. You know, when they seized all the documents from I'm sure it would have come up in various communications. When they seized all the documents from our offices, I'm sure that that's where we would have found it. I think if you look at the application from the other concession holders, they also say we have an automatic right to this long-term agreement.
Now, just focusing again on the evidence you gave, you said you understood it to be in other documents. I'm dealing now with your acquisition of this company when you conducted due diligence. Are you suggesting you saw other documents that contained a guarantee obligation?
No, I saw many documents where the issue was discussed because it was a constant issue of discussion. We're walking, please understand the context. we're walking into an investment environment where we're asked to be putting up money first. That doesn't happen in the mining industry. So that's the reason that everybody, the Rwanda government came around to this concept. Well, we'll guarantee it. So fine. And we accepted that. It's an unusual circumstance, but that's what we were willing to accept. For them to say that this, I never, at the reverse, I never had somebody say it is not guaranteed.
And what we're looking at, and you may recall, is we're looking at what you must have understood about NRD's rights when you bought into NRD. And you must have understood, and you did understand, that NRD had no guarantee or assurance about a long-term license, did it?
From the very beginning, I was assured that NRD had a right to a long-term license, a commercially feasible long-term license. I don't know what the terms of it would be. That was a matter of negotiation, but it would have been commercially reasonable long-term license.
And it was obvious to you from your review of the contract that you did undertake that NRD did not have a guaranteed right to a long-term license, did it?
I'm sorry, please rephrase.
It was obvious to you from the review of the contract you did undertake that NRD did not have a guaranteed right to a long-term license.
That's not true.
And let's go back to bundle C017.
Can you, thank you. The Rwandan government was always pointing to what's Article 4, okay, in French it's Article 3, that was our guarantee for having a commercially reasonable long-term agreement.
Well, let's take this in stages. You agreed with this yesterday. I'm happy to go back if you like. Article 2 had obligations.
I disagree that I'm saying something different now.
Article 2 had obligations that you agreed yesterday NRD had to abide by. Yes?
Yes.
And if NRD did not abide by it, amongst other things, Rwanda had the right to terminate the agreement and not to provide you with any long-term license, correct?
And NRD did abide by all those obligations.
Just answering my question, if NRD did not abide by it, Rwanda had the right to terminate the agreement and not grant you a long-term license, correct?
If we did not, you say?
Yes. That was your understanding, yes?
Well, as a matter of negotiation, but as a principle, yes. But that was, what we were told had to be done. These are ambiguously worded language. Each one of them is 4 or 5 words. There was an ongoing discussion between the parties about what was expected when and how it was to be done.
Now, I'm going to come back to Article 4 in a moment, which is the article you referred to, but just staying with Article 2, there was within Article 2 an obligation under Item 3 for NRD to proceed immediately after December 2012 with the industrial exploitation of the site, yes?
Yes.
And you appreciated that meant moving beyond artisanal mining and achieving industrial exploitation of the concessions, yes?
No, you're misusing the words or the implication of those words. There is no industrial exploitation in Rwanda. That, in ordinary parlance, that means entirely mechanized. There is only and has ever only been artisan support mining. And it's the nature of the artisan support mining is a matter of discussion for how to make different mine sites most efficient. There are no rich deposits. There are no open cast mines like there are in Congo or Australia or other countries with impossibly large machinery. The mining has to be done to match the deposit. If it's a very small deposit, that's what you have to work with. You can't bring in and open a large, half-mile wide open pit if the minerals aren't there.
You knew, didn't you, that what was required was to move beyond, moving beyond artisanal mining and achieving industrial exploitation of the concessions?
No, they use the term industrial exploitation, I think partly for political reasons, but partly to suggest that they want something more than simple artisanal work. They define industrialization, although it seems very odd, to include jackhammers and compressors and generators. That's everybody's performance in Rwanda. There are no big mines in Rwanda.
Can we look at your own witness statement? This is your supplemental, your second supplemental witness statement. So your third witness statement, paragraph 23. We'll be going back to the contract, FDI, but we'll just look at the witness statement first. You say there in paragraph 23, I always understood the importance of industrial exploitation, both as part of the requirement of the contract and in order to make the concessions more profitable. My goal was also to move beyond artisanal mining and achieve industrial exploitation of the concessions. So that was exactly the formulation I put to you, which you accepted was you say it was your goal also. And then we go over the page. You say mining is a costly endeavor. I believe I'll be able to attract investors by trading NRD in the alternative investment market of the London Stock Exchange. However, in order to attract investors, NRD needed a long-term license. Without it, potential investors saw NRD as too risky of an investment and were not interested in investing. As a result of Rwanda delays and ultimate refusal to grant a long-term license, I was never able to trade NRD in the London Stock Exchange. Had I been able to, I expected to raise substantial sums of money, but I could have invested in the concession to improve the roads, bridges, and other infrastructure, bring in additional heavy machinery, and build processing plants. So you make it quite clear in your witness statement that you do understand what industrial exploitation is. Yes?
You're misusing the term.
Well, I'm using it in exactly the same way as you used it in your own witness statement, aren't I? You explain in your witness statement that you wanted to achieve industrial exploitation, and then you go on to explain what that means, including bringing in additional heavy machinery and building processing plants. Yes?
You're confusing, you're conflating the issues. No deposit can be treated differently than the richness of that deposit. You can't open up a massive mile-wide open pit if there's no minerals there. The Rwandan mines are very thin and variable veins, not placer deposit like open gold, anything like that. The common parlance in Rwanda for what they mean by industrial exploitation is giving assistance to artisan miners. It can only be that, and it will never be more. I suggest you address that.
That is why
the other witnesses.
That is why you explain in your witness statement what industrialization is. You explain that it involves bringing in machinery and processing plants.
I think you're mistaken about what the pieces of equipment we use. A processing plant is really a more efficient way of a artisan miner using a chisel and hammer to hammer out part of the vein, crushing it, and then panning it. That's in essence all of the mining. When you have a processing plant, you have to simply put larger quantities of extracted material, and instead of it being crushed by hand and instead of being hand panned, it does that in a consecutive order of machinery. So through a gravity-fed machine, that's a processing plant. It's not more complicated than that.
You understood that industrial exploitation of the kind you described in your witness statement was required under Article 2 of the contract, didn't you? You knew that. Yes?
Yeah, but you're conflating what is meant by industrial exploitation in Rwanda with a sense that you have from some other source.
When you purchased NRD, you knew also that there generally hadn't been industrial exploitation as was required under the contract, correct?
For example, Rutongo Mines has been said that, yes, you satisfy the requirement of industrial mining. We did exactly the same as Rutongo Mining. They had no difference in their operation, and that was deemed to be industrial mining.
Just answering my question, when you purchased NRD, you understood that there hadn't generally been industrial exploitation, correct?
That there had not been? Yes, there had.
You can come to the detail of this, but there was at best artisanal mining going on. Certainly in 3 of the concessions, there was nothing except artisanal mining going on, correct?
By that standard, there is nothing but industrial mining anywhere in the country.
Just again, answer my question.
Well, you're using a term
In relation to Gikea, Sabea, Mara, there was on any view nothing except industrial, artisanal mining going on.
artisanal support mining.
In relation to those 3 concessions, there's no plants, no infrastructure, nothing approaching industrialization in respect of those 3 concessions, was there?
You're misusing the term industrialization in the context of how they use it. Any artisan support is considered industrialization by them.
And that's not accurate, is it?
Yes, it is.
And in relation to 2 of the concessions,
You can't name any mine that has industrial exploitation by that definition.
and in relation to two of the concessions, there was only some limited industrialization, and that relates to the processing plant installed at Rutsiro and some enhancement of infrastructure at Nembla, correct?
No.
Now, in paragraph 24 of your witness statement, you're explaining exactly what you mean by industrialization, because you're talking about bringing in additional heavy machinery and building processing plants. And that's industrialization, isn't it?
No. No.
Then why does it appear in the same paragraph as you?
No, you're misreading it. You're misreading it. Any artisan support, and yes, it includes bringing in additional road equipment, additional assistance to the miners. But you're looking for some kind of automated machinery process. That's not what happens in Rwanda.
I'm reading your witness statement. You say you understand the importance of industrialization. That's the beginning of paragraph 23.
And I
you
would
say you wanted to achieve it. You then explain that you wanted to go on, improve built roads and infrastructure, and bring in heavy machinery and build processing plants. Quite clear that you are seeing that as industrialization, correct?
You're conflating the issues. All support for our artisans, any additional support that is beyond a hammer and a chisel is considered industrialization. So
That's
every
not
time,
true, is it?
yes, it is true. Can I finish, please? Every time you bring in additional heavy equipment in the context of jackhammers and generators and compressors to run the jackhammers, that's in Rwanda parlance, that's industrialization. You have a misunderstanding about the significance of a processing plant. A processing plant doesn't do more than make it more efficient. It's exactly the same thing that miners do by hand. And it's somewhat more efficient if there are enough feedstocks to be able to keep it going. You're defined by the deposit itself. If the mineralization isn't there, you can't have a more efficient processing plant.
Now,
I'm sorry.
we can see from paragraph 24 of your witness statement what your business strategy was, which was to proceed with industrialization after getting long-term licenses and achieving flotation.
Every time you bring in additional equipment for miners, that's industrialization. But it's not building a massive processing plant. There's no deposit there which can run. There's not enough feedstocks to be able to run through a processing plant of any size.
Just to look
very modest country, very modest mining. So
just to look at your, just again, focus on my questions, please.
Sorry.
Paragraph 24 explains your business strategy,
yes.
Which was to seek a flotation on the London Stock Exchange,
yes.
And achieve industrialization on the back of the flotation being itself on the back of long-term licenses. Yes?
Yes.
That is the wrong way round.
No, you're
misunderstanding. You were required, just listen, you were required to commence industrialization immediately after the 2006 contract was entered into. So your business strategy could never be viable and consistent with the contract, could it?
No, your premise is wrong. it's unique in Rwanda, and there's nowhere else in the world where mining companies were asked to come in and invest before getting a long-term license. None, not one country in the world. That was done as an accommodation, part of the enthusiasm of wanting good things to happen in Rwanda. We were one of them. We said, okay, you're going to give us the long-term concession. We're willing to do this a little bit backwards. We're going to make an accommodation for you to be able to put in money before we have a long-term license.
So if we go back to bundle C.
If I can finish your question, please. When I'm talking here about industrialization, we're talking about raise substantial sums of money to yet build out the mines even more. There are thousands of part-time artisan miners who are farmers in the daytime and mornings and farmers in the afternoon. And if every one of them had a jackhammer, they can produce more.
Now,
having a jackhammer requires having a compressor and a generator.
If we go back to bundle C017 now. Thank you. I'm going to suggest you knew when you acquired NRD that the Article 2 obligations were unfulfilled, and on that basis alone, NRD had no entitlement to a long-term contract.
No, those were fulfilled, and we were told that they were fulfilled by Dominic, who was the head of the licensing department. We were told we had the best application of all, and by the way, we did read the other applications. We knew it was superior to the others because we worked with the geologists who prepared the others. So then we
suggesting, just to be clear on that last point, I'll come back to that. Who provided you with everyone else's applications?
The ministry.
Mr. Bodega?
And his staff.
So just to be clear, Mr. Bodega provided you with everyone else's applications. When was that?
No, I just said, and his staff. I don't know which one was which, but people saw ours. There was no confidentiality. That's not the way this mining industry works. Everybody was sharing all information.
No, you were aware, you referred to Mr. Bodega saying you had the best application. Now you're referring at the moment to something that happened on your evidence in late 2011, correct? And I'm asking you.
I'm sorry, I don't understand.
I'm asking, well, all my questions at the moment, I just want you to be focused. All my questions at the moment are about what you understood when you acquired NRD in late 2010. And that's got nothing to do with what you say Mr. Bodega told you in late 2011. And you understood when you acquired NRD in late 2010 that the Article 2 industrial exploitation obligation had not been fulfilled, and on that basis alone, there would be no right to a long-term license, correct?
You mean number 3?
Article 2, yes, Article 2, subpara 3. You knew that was unfulfilled, and on that basis alone, there'd be no right to a long-term license.
Really, I'm misunderstanding this whole process. I'm sorry.
So were you also aware that the Zarnax had indicated to the government in their investment plan that they would be investing 39 million in the deal? Yes? Were you aware of that?
I only saw it in the application. I was not aware of it from the Zarnax.
And that you were aware that nothing like this level of investment had gone in, correct?
But you're reversing the process again. Nobody invests in anything in mining until they have an agreement. As an accommodation, they were making some investments. For them to say, well, look, you didn't put in 40 million, therefore you have to go home and you leave your 40 million, doesn't make any business sense. You'll appreciate it.
Just to try and understand what you knew, did you know and understand that the Zarnax had promised a 39 million investment plan over the period of the contract, and that money had not gone in, except a small fraction of it?
I don't know that. No, what I know is what the language that I saw in the application.
And it's not a question of the 39 million being invested in the future. That was money that was to be invested over the period of the contract, wasn't it?
Not that I know of.
Now,
why would you invest 40 million? I'm sorry.
We'll come back to that. I'm afraid the process, Mr. Marshall, is I ask the questions and you have to answer. Now, let's go to item 5 of Article 2. This is an obligation again within the 4-year term, to provide evaluation reports of reserves and a feasibility study after 4 years. Yes, and you were aware that that was something that needed to be provided?
Yes.
And the feasibility study would itself be based in part on the reserves that have been reported based on the geological exploration carried out, including whether the exploitation proposals for a long-term concession were realistic and feasible. Yes?
I'm sorry, say it again.
Yes, the idea of a feasibility study is in part it's based on the evaluation of reserves that's already been carried out following exploration. Yes?
Yeah, I'm sorry. Again, you've got it backwards. This is not to create a study for the government that the government can use as an asset. The purpose of it is for a company to be able to evaluate whether it wants to invest.
Well, again, you're not focusing at all on my questions, I'm afraid. Please answer my question. The feasibility study would be based in part on an evaluation of reserves based on exploration that had been carried out. Yes?
You're going to have to ask me one more time. I'm sorry.
So you'd have a process, you would evaluate, you would explore, you would evaluate reserves, and on the back of that, you would have a feasibility study. Yes?
Yes.
And the feasibility study is evaluating whether exploitation proposals for a long-term concession are realistic and feasible based on the reserves and the investment and the exploitation plan. Yes?
For the company, yes. That's the way all mining companies work.
And if you look at Article 4, you were aware that it says after positive evaluation of submitted feasibility study, Natural Resource Development Rwanda Limited will be granted the mining concessions. You were aware that whatever rights were granted, long-term investment rights were granted, or whether they were, would depend on a positive evaluation by Rwanda of the feasibility study.
No.
That's exactly what Article 4 requires, and that's what you well understood was in the contract when you acquired NRD.
No, it's not true. In fact, that is exactly the provision that the Rwanda government staff always pointed to say, once you approve it, once you decide you want to go ahead, you have the right to do so. They wanted to make sure that the company did the internal research to be able to make sure they wanted to put more money into the project. This was not intended to give the government of Rwanda a way out after receiving so many tens of millions of dollars.
You're not suggesting, are you, the company could simply, without more, say, we're happy with the feasibility study, please grant us a long-term license?
Yes.
There would have been entirely different terms and different and much fuller terms if it had been thought that someone else, other than the government of Rwanda, could certify themselves as satisfied with the feasibility study.
This is the way the mining industry works. It's not the government. The government says, look, we have these sites. Are you willing to invest here? Mining companies go in, they spend some of their money doing exploration, and then they determine whether they want to ask for it.
Then why is it necessary under Article 2.5 to be providing the evaluation reports and the feasibility study to the government? You don't even need to bother. You just keep it internal. Listen to my question. On your logic, you wouldn't even need to bother. You could keep the feasibility to your study to yourself and just say to the government, we're happy.
You'll need to go back to your client. This is their document. We were not given.
And I'm suggesting it's quite obvious how the document worked and you knew it at the time. There was an obligation to provide to the government evaluation reports and the feasibility study, and the government need to be satisfied about your feasibility study before they would grant you a long-term license, correct?
No, that's not the way they presented it, and that's not what they say it meant.
And that's exactly what you understood when you acquired NRD, and indeed it's what you were told by the NRD staff, because they were concerned and they told you that not enough work had been done to justify long-term licenses, correct?
That's entirely nonsense.
Now, can we go to bundle C? Sorry, just before I do, just standing back from all the questions I've asked, I'm going to give you one more opportunity to answer the question. My suggestion is that when you and Spalena entered the frame in late 2010, you did not think for a moment that NRD had any guaranteed entitlement to long-term mining licenses, did you?
Of course they did.
Can we go to,
All concession holders had a guaranteed long-term license if they invested.
well, even on the answers you've given this morning, also if they satisfy their obligations under Article 2? Or are you resigning from that evidence too?
You'll have to be more
You
clear.
accepted this morning already that any long-term license would be dependent on satisfying the obligations under Article 2.
I agree, but you're giving a more narrow interpretation than the Rwandans do to the meaning of language in Article 2.
You go to C68, C068.
This agreement was signed and put into a drawer from the Rwanda side. Everybody was guaranteed the long-term concession license if they invested. What the other documents were, they never came to the field. They never came to understand what we were doing. They weren't interested in what we were doing.
Well, again, Mr. Marshall, you know that's untrue because you know the government was keenly interested in what you were doing and closely scrutinised all the applications and feasibility studies that you provided. You know that, don't you?
No, it's not true.
Well, let's go to the document I mentioned, C68. This is the agreement again that we looked at earlier. I'm going to start at page 14, subparagraph 4. This is a reference. This is one of the, just to make so you understand, this is the clause that, and if you go on to page 15.
Yeah, this is actually a more complicated agreement. I'll need to read the agreement. If
Well,
you mind.
I'll ask you the question and then you tell me if you need to read the agreement before you answer it. I'm within this clause. I want to look at one of the pieces of information that there's an acknowledgement that the buyer knows about. If you look in the middle of page 15, it says,
I have to go back and read the whole agreement. So in that sense, they're correct, but I need to go back and read the whole agreement because
so you knew already when you bought into this company that
no different issues than all other concession holders. We all face exactly the same issue. Why hadn't the government issued the long-term license?
well,
Since yes.
that doesn't make any sense, Mr. Marshall, because the time has only just arrived for the government to issue long-term licenses or not, because we've only just reaching the end of the 4-year period. So what
That
they're
was
telling
the
you,
story we were told to believe. That at the end of the 4-year period, we will be given the long-term licenses.
exactly, and they are, that is exactly my point. The 4-year, end of the 4-year period has arrived. The application's only just gone in, because this is just after November 2010. It hasn't been ruled on yet, the application.
No.
Well, that's what
The applications were submitted. That was a part of, as we had always been explained, that was part of the pro forma exercise to make sure we were going to build out the concessions as they were politically expecting them to be built out.
Mr. Marshall, you're simply making up your answers as you go along.
I'm not. I'm sorry. No, I'm not.
You acknowledged that there were issues with the renewal of the license at a time when the license application had only just been made.
You're creating a fantastic administrative hierarchy around this issue. That's not what happened. Not true.
It was quite a serious risk that there wouldn't be any renewal at all, correct?
Not true. There were parallel lines of negotiation going on. You'll recall, we began negotiating, and I want to say maybe March of 2011, the language of the long-term contract. We had fulfilled all the terms and conditions. They were very happy.
I'm going to stop you there because we're not in 2011 now. We're still dealing with what you understood when you acquired NRD at the end of 2010.
the reason I'm telling you is it was evidence of why I believe that we had fulfilled all of the requirements.
But you acknowledged and were required to acknowledge in your contract that you understood that there were issues associated with that renewal.
As I say, I need to go back and read the whole agreement, but the issues that all of us had were they had not yet issued the long-term licenses. That's an issue. Had we failed in any respect? No.
They'd only just applied. They'd only just applied for the long-term licenses and hadn't even had a ruling yet on them.
It was a formality.
Mr. Hill,
Yes.
you've just put to this witness that NRD had applied for the long-term licenses.
Sorry.
I don't understand that to be your case.
Yes, and that was certainly a slip. Just to be clear, I'm not suggesting there's an application for a long-term license. It's very strongly our case that there isn't an application for a long-term license. It's an application for a 5-year license, and I apologize for that slip.
That's the case. It was an application for a long-term license.
Now, I can suggest to you that your evidence that you thought that there was a guarantee of a long-term license is inconsistent with your acknowledgement in the contract that there were issues with renewing the licenses at all.
No.
Was
But
that-
I'm sorry, you're mischaracterizing what happened. There are parallel lines of relationship. There was the licensing and supervision office who were telling us without any reservations, yes, your long-term application is the best among all of them that we've seen. And we did see the others either through the geologists or through the mining department because they showed them to us and they showed ours to them. There was no secret in this. In many respects, there's no secrets in the industry. In this respect, there was certainly no secret. So we could begin directly. And that's why I say March 2011 to begin negotiating the language of that long-term concession. It's not some additional review or advantages. They knew what we knew. They knew what we had invested. They knew what the process was. And that's why we started that discussion.
Now, next point, and this picks up on the question, the point raised to me by the president, is you also knew at this stage that NRD hadn't even applied for long-term licenses, and its application in November 2010 was for short-term licenses because they knew that that was all realistically they could hope for. Correct?
Well, I don't even understand the premise of your argument. Because it's a 5-year plan, all mining is 5-year increments. Nobody plans more than 5 years.
Just answer my question. I'm going to bring you to the evidence that demonstrates this, but I'm asking you about your understanding. And your understanding, because it was made clear to you by NRD itself, was that this was only an application for 5-year licenses. Correct?
No, I'm sorry, you're misstating the facts.
Well, before Spalena acquired NRD, you would have reviewed the license renewal application, yes?
I had read this agreement, sure, this application.
You had read it, and you read it on due diligence, presumably, yes?
Yes. But no, I read it way before then. It was being prepared in pieces, but we saw different pieces at different times.
And
from the geologists.
Can we go to the license application, which is a bundle C035? And so this is an application for renewal of exploration licenses and an application for the allocation of mining licenses to NRD. You see that?
Yes.
And what that is asking for is a renewal of its ability to explore and also for small mine 5-year licenses, correct?
No, absolutely not.
You're not suggesting that this is an application for a vast mining concession?
Yes,
You're under Article 57 of the 2008 law.
I don't know the site to the law, but this was for a long-term license. As a proper concession holder, as an accommodation, we are being treated as a large-scale concession holder, and this is consistent with that.
Were you aware that if you had been applying for a vast mining concession, you would, of course, as the legislation shows, be entitled to explore and research within your vast mining concession? All you need is a vast mining concession. You wouldn't be applying for renewal of exploration licenses and the mining license.
I would say that would be an insignificant inconsistency.
And the reason that you have two forms of application is that you have a separate exploration license that's being applied for and a separate small mine license. Yes?
I'm sorry, but you're really reaching. That's completely untrue.
And if we look at paragraph 9 of the document at the bottom,
Do you have a page number? Is that a large document?
9, I said page 9, or
Oh, page. I think you said paragraph. My
page
apologies.
9, yes. We can see at the bottom, we have a proposed activity plan, and that's dealing with a period from January 2011 to January 2015, so a 5-year period, correct?
Yes.
If you look over the page 10, we can see more of the activity plan, also for a 5-year period, correct?
Yes.
And if you look under the paragraph under the box, you can see various exploration exercises, including making new reserve calculations in the period from 2011 to 2015. Yes?
Yes.
And
This is, I don't know if you understand, this is the way planning and mining is done. Nobody does it 10
just
years.
focus on my questions. And what this, just pausing here, and you can see the sort of reserve calculations that are now earmarked. What that is itself showing is there hadn't previously been any adequate calculation of reserves, even though that was one of the obligations under Article 2 of the previous contract, correct?
No.
And most of the expected exploration work hadn't been done. And you were told that when you acquired the company, yes?
I don't think you understand the mining process. You know, when it's not like you do all the exploration and then you begin mining. You do sufficient exploration to know that it's attractive enough to invest the money to be able to expect to get a return.
But what this shows
Whether
is
there
sort
are
of
areas that aren't researched, that comes over time. It's not like everything is done at once.
well,
So you're misrepresenting what these things mean.
well, except that you talk about areas that haven't been researched. In Route 0, top item, detailed calculation of reserves of Route 0 primary wolframite deposits. So the main job had not been done. And that's why there
No,
was
that's
a
not
renewal, a request for renewal of another exploration contract, correct?
You're misreading that statement.
And in consequence of the lack of work,
That's wolframite. What research was done on tungsten or tantalum? Doesn't say. When they say detailed calculation, what was the broader calculations that had been done?
Mr. Marshall, wolframite is tungsten.
I'm sorry, did I say cassiterite and tantalum? There are all three minerals in Route 0.
Route 0 isn't a cassiterite reserve.
Yes, it is.
I'll come back to
It
that.
has all three. You're sorely mistaken.
The reality is that Route 0 was being focused on always for tungsten, wolframite,
You're
and
mistaken.
even in it with its primary ore, there had not been detailed calculation of reserves.
You're mistaken. There is tin deposits there, and there are tantalum deposits.
And the plant that had been installed at Route 0 was a wolframite tungsten processing plant, wasn't it?
I understand that it's been characterized that way. The process is the same. You can make adjustments to a plan and they have to be able to process all three minerals. There is no difference in the machinery. There's some parameters that have to be adjusted if you want to get more fines or less fines, depending on whatever the host material is. And it depends on the host.
The commercial reason, just to be clear, the commercial reason why that plant was built was to process wolframite, wasn't it?
No.
And the idea, we've got witnesses from the people who were there when it was built, and you weren't, is that the idea that the Starks had and why they built it was to process wolframite from the scree and thereafter move into the primary ore.
It was,
correct?
No. It was centrally located. Stark was very clever. There are cassiterite reserves right across the other side of the valley. There has been historically a lot of tungsten work done there. There are tailings there that were expected to be processed. Immediately across the road is where the tin deposits are. Half a mile up the road is when you start to get the tantalum deposits. This was a central location on a road.
Mr. Marshall, you're making things up because we have a number of witnesses, and it's not just one witness, we have a number of witnesses who deal with this processing plant. It's also clear from the evidence that this plant did not operate, did it? You're not suggesting this plant operated?
Yes, it did operate.
You're suggesting this plant processed ore?
Yes.
Are you? What sort of ore are you suggesting it processed?
Whatever we wanted to put through it. For example, it wasn't operating regularly in the sense of bringing large quantities of material and putting it in the top. It was operating regularly with regard to the artisan miners that give them support. A plant is nothing more than crushing minerals, washing them by either trommels, jigs, or spirals, and ending up with a finished product at the end. It's the least labor-intensive process. That's all.
Just so we have your evidence on this, your evidence that just so we got it absolutely clear, your evidence to the tribunal is that this plant, the Rutsiro plant, kept operating.
Yes.
Yes? Throughout the period of NRD's.
Yes, it was always available for the artisans. You know, they didn't use, when you say operating, you know, you're drawing in a big issue. You know, it was available for the artisans who were there to use individual pieces. The plant is nothing more than, as I say, a crusher, trommels, washing tables. The artisan miners who are there on site can use pieces of it to make their work easier.
Now let's go back to this document. The consequence of the lack of exploration work that had been done to date meant that there was no meaningful feasibility study that was provided or could be provided in late 2010. Correct?
No.
And certainly no feasibility study.
We did more research. We did more research than anybody.
Certainly no feasibility study that would be sufficient to meet with approval from the government so as to move forward with a long-term license. Correct?
You've got it backwards again. This is not for the government to approve. This is for the company to approve. Decide whether they put in more money.
Let's go to bottom of page 11 of this document. This is proposed business plan, and the business plan only covered the period 2011 to 2015, correct?
Yes.
And that's because this was an application dealing with a 5-year period, correct?
No, this is the way all of these plans are put together. If you compare it to Rotungo, you'll see the same. Nakabingo. This is the way mining companies do these proposals. They don't forecast out beyond 5 or 6 years for the reason that too many things can change. just compare it to the other applications. You'll see.
So just give me one moment. Now, you just gave an answer that this is what always happens, but the reality is that you later in this story, and we'll come to it, do put in an actual application for a long-term license, and you do give projections out to 30 years. So the evidence you've just given is not true.
No, at the request of the ministry, with technical information submitted to us by the ministry.
So instead of being something that always happens, that's not the case.
No,
Despite-
you're mixing apples and oranges. You know, when mining companies do this, it's a 5-year plan. You can't forecast more than 5 years. There are too many variables. So they say a business plan, you know, is very valuable as a planning exercise, but it has no meaning once you get started.
You, again, you chose to provide long-term 30-year projections when you were in fact applying for a long-term license, correct?
That's not correct. We were instructed to provide those numbers, and those numbers were provided to us by the ministry.
Can FTI go to page 143 of this document? This is a document dealing with the plant, and it is indeed a wolframite ore dressing plant, isn't it? And you can see that from the first page of the document.
Right. It was set up to deal first with the tailings at this site. That's why they call it wolframite. There is no such thing as a wolframite or a tantalite or a tin plant. They're all the same. When you go to Ratungo's plant, it's a crushing plant. It's a processing plant. It's not a wolframite plant or a tin plant or a tantalum plant.
Now let's go to page 25. Back to page 25 of the. Sorry, back to page 13 of this document. The one we were on earlier. And this is dealing with what the application is for licenses. And so here, what's clear is it's applied to retain the concessions of Rutsiro, Gakea and Sabea as exploration licenses, albeit of reduced extent. So under this application, the concessions are being shrunk as exploration licenses, correct?
Yeah. What the ministry wanted was for us to say, okay, you've done this evaluation. Now tell us concretely what it is that you want to keep under your as part of your licenses.
So it was they were shrinking as exploration licenses, correct?
No, this was to go to the 30-year license, and we were saying these are the areas that we would like to retain.
No, that's not right. This is an application for renewal of exploration licenses. So the exploration licenses are just on this reduced area, aren't they?
That may be badly written, but are you saying that we're not applying for the 40 years, or what are you saying here? I'm missing the point of your question.
That NRD was reducing its areas, concession areas, for the purposes of its exploration licenses, correct?
All I know is that there is one 30-year license. That's under the statute, the 2008 statute, that's the only possibility, as far as I know.
And if,
I don't know what
in your case, they'd been applying for there was a guarantee of a long-term license, and that was all, and what was being applied for was a long-term license.
No,
It's inconsistent with that, isn't it, to be reducing what's being sought? Yes.
No, I think you need to understand what they were asking us to do. They were saying, look, you've evaluated it. Now, what is it do you really need for your long-term concession? We're already being treated as long-term license holders. We had rights and responsibilities under statute, which made us holders of these concessions, even though it wasn't formally designated as a 30-year period. There was nothing else we could be under the 2008 statute.
Now, can we now go to page 25? This gives a description of the licenses. And it says applications for renewal have to be submitted 3 months prior to the expiry date. Do you see that?
Yes.
And that was because applications under Article 45 of the 2008 law for small mine 5-year mining licenses needed to be made 3 months before the expiry date, correct?
No, I don't know that.
And were you aware that if you've been applying for a vast mining concession under Article 57, you would have had to have made an application 6 months before the expiry date?
No.
And you did know, didn't you? Because not least because you looked at this application, but also from what you were told by NRD, that all NRD was applying for was a 5-year renewal of a small mines license. Can you be provided with C041?
All of us were applying for the same thing. All applications were similar. Ours were more detailed. Ours had done far more work and made much more investment, but all the applications were virtually the same.
Can you look at C041?
We were the only ones who didn't get it.
This is an application from, it's a letter we'll come back to later. It's a letter from you to Mr. Kamanzi, dated 31st of October, 2011.
Yes.
And I just want to look at there's quite a lot of points here. I just want to go to point 10, numbered point 10, which you'll find at the bottom of third page of your letter. You say that in the last sentence of the second paragraph of the letter, it's implied that NRD must engage additional professionals in order to fulfill the contractual obligation. As you may be aware, like all concession holders, NRD awaits a decision of your ministry regarding the conditions on which NRD will extend its existing concession rights. Like all concession holders, we have submitted a 5-year extension agreement for review. When we have an extension agreement of 5 years, our investor will follow the NRD action plan and begin semi-industrial mining. As is well known, NRD has invested more in Rwanda than any other concession holder. We expect to be able to continue and bring our operations to fruition. So your own position to Mr. Kamanzi was that you had submitted a 5-year extension agreement for review, correct?
Well, no, they're two different things. The 2010 application is for a long-term application. The government came back, and I don't know if it was Dominic or who was, and I think this is 2012. Can you go back to the top of the letter?
This is 2011, October 2011.
Okay, then no, they may have come back and asked for an application for 5 years because they said the mining law was going to take longer. And that's the closest I can remember to any reference to it. But the November 2010 application is for a long-term license. And we were negotiating in October 2011 the language of the long-term license.
Well, you just gave a contradictory answer there because you say you're negotiating the language of a long-term license, but you've just said, as I understood your answer, that you'd submitted a 5-year license.
No, you're not listening. I'm sorry. The 2010 application is for a long-term license. If the ministry,
what did you mean when you said we've submitted a 5-year extension agreement for review?
This was a later an announcement from the ministry, as I recall, saying we need a 5-year application because there's going to be delays in the granting of the long-term licenses. Notwithstanding that, and that's why I say there are parallel lines of communication. This is with the minister who had his own unique limitations. We were still continuing with the licensing and supervision office negotiating the language of the long-term license, which by October, I think had been submitted to the cabinet.
Now, as I understood
They're not
evidence you
necessarily.
just gave. You just said that you were asked by the. I'll make sure I get her. Sorry, one moment. The evidence you just gave is you were. I'm afraid my transcript stopped working, but I think the gist of it was that the ministry told you that while you were working on a long-term license, you should apply for a 5-year license.
Also,
Is that what you're saying? That is simply not what happened, is it? We're going to go through the history of this. That's simply not what happened, correct?
that is simply what happened. Yes.
Okay. Well, let's go through it chronologically. C062.
By October, I think our long-term application had already been submitted to the cabinet, and we were waiting for a determination on that.
C062. This is the ministry's response in August 2011 to your November 2010 application.
Yes.
We will actually come back to that, this document, but one of the points made is in the third paragraph. We noticed that you applied for 5-year 5 licenses for small mines within each of the 5 concessions. The new status of the concessions will have to be decided based on the work executed in the light of the contract signed.
We did not actually submit anything, although we had been requested to submit application for 5-year licenses.
No, this is just to be clear, I don't want to confuse you. This is August 2011. This is the ministry's response to the November 2010 application. Their understanding, correctly, is that your application was for 5-year licenses for small mines within each of the 5 concessions.
That was never understood. And I think this letter is simply a mistake or misrepresentation. If what you're saying is that they were trying to shoehorn our long-term application as if it was a 5-year license application, I can't guess what their motivation may have been. But we never had a discussion of the 2010 agreement or application being anything but an application for a long-term license.
Yes. Yes.
No.
Now, Professor Rupaya has given evidence of a state of play at the time this license application was put in. I'm going to ask you to look at paragraph 7 of his supplemental witness statement. Now, Professor Rupaya, you recall, was the chief geologist of NRD at the time this application was put in, yes?
He was a geologist.
Well, he was the chief geologist of NRD. Do you dispute that?
I don't know that he was the chief geologist.
And as the geologist at NRD, he would know, wouldn't he, what the status was of the application and of the...
He did not participate in the negotiations. His job primarily, as we understood it, was working for the Director of Military Intelligence with an eye on the industry as a whole. He did not have a lot of time to be performing in his role as an exploration geologist.
Well, let's look at what he says. As I explained at paragraphs 18 to 21 of my first witness statement, NRD had only completed superficial exploratory work by late 2010, and the 4-year licenses were due to expire the following month. It was in these circumstances that we put together November 2010 application. The idea was that if we successfully developed the 5 concessions during this period, we might be granted a long-term 30-year license to exploit the concessions. It was not the expectation or belief of anyone at that time that NRD would be granted a 30-year license at this stage. That was not realistic based on the limited exploration that had been undertaken. And that is accurate, and it's also what you understood when you came in to buy NRD, isn't it?
No. In fact, this is the first time I've seen Professor Nkanika write that kind of thing. He was fired for plagiarism, but I don't have any, certainly he never communicated this to anybody in my firm in NRD, and certainly not to me.
Now, this suggestion that he was fired for plagiarism This is the first time you've suggested that, isn't it, in these proceedings?
And what?
It's another example, isn't it, of Mr. Marshall, of you reaching for accusations against anyone who says something.
No, you can ask him. Please ask him. I say fired for plagiarism. It was agreed that he would retire after him being caught in plagiarizing a document.
Can we look at Mr. Professor Rapaya's
His function, just to be clear, was primarily for the director of the military intelligence. We understood that. We were happy to enable him to collect information, and whatever reporting he was doing, that was all right with us. We understood that that's the functions of the state.
Can we look at Professor Rapaya's first witness statement at paragraph 16 to 21? So he deals here with the November 2010 application, and he was involved in putting it together and you weren't. And what he explains is we were conscious in November 2010, NRD was required to provide a feasibility study to the government in order to justify the granting of new licenses to continue mining.
What section, I'm sorry?
I'm looking at paragraph 16. Because the licenses given to NRD, that had given NRD the right to mine in the 5 concession areas were going to expire in January 2007. He then goes on to say, we realized internally the government would be disappointed at the lack of development of the 5 concession areas since 2007. As I've explained, we were still using artisanal mining in all the 5 concession areas. And although some investment had gone into remedial works of the pre-existing infrastructure at Nemba, and although we had installed the plant at Rutsiro, which was not productive, nothing had been done at the other 3 concessions. NRD had only done superficial exploratory work carried out by another German, Dr. Peter Schönherr, not carried out any proper assessments of the mineral reserves. They had relied on satellite imagery, some limited use of ground penetrating radar for a few days, and some limited sampling. What I would have expected and what I proposed, but what H.C. Stark refused to do, was much more detailed sampling and then drilling in areas that have been identified as having potential to identify underground reserves. In these circumstances, that we put together an application to the government for the grant of some new exploration and small-scale mining licenses within the 5 concession areas. We hoped that if we put together an overview of what had been done to date and proposed to carry out some further exploratory work over the following 5 years, the government would look favourably on granting us 5-year licenses. After that, we hoped that if we had successfully developed the 5 concession areas in that period, we might be granted a long-term 30-year license that was possible under the 2008 mining law. November 2010 application prepared by Peter Schönherr summarised the work that had been done to date, gave a plan for research and exploration work that would be done between 2011 and 2015 if we were granted further 5-year licenses, gave some very approximate estimates for reserves, which were more guesswork than anything else because of a superficial sampling that had been carried out, and set out a business plan which assumed that the new Rutsiro plant would be successful because at the time the report was being drafted in October 2010, it was still being commissioned. We also addressed the fact that when the government had awarded the 5 concession areas, the business plan had projected investments by Visanex of around 40 million, whereas nowhere near this amount had been invested. I understand Mr. Marshall's claiming these proceedings that this November 2010 application was an application for a 30-year concession, and that the report contained within it was a feasibility report which would be sufficient to persuade the government to grant such a license. All I can say is, as far as I'm aware, this was not the expectation or belief of anyone at NRD at the time. We were really just hoping to be granted new 5-year licenses under the 2008 mining law. Now, that is all accurate, isn't it? And it also reflects what you were told by Mr. Ehlers and others when you arrived at NRD.
That is not accurate, and I've never seen anything vaguely similar to this in all my time at NRD. This to me was made up specifically for this arbitration and no other reason.
Now, Professor Rapaya was there when this application was being put together and you were not, correct?
We were a joint venture partner with him under a cooperation agreement. I was not participating in pulling together the documents for this, but he was still there until 2012, so another 2 years, and he never communicated any of this to me.
And he is in a good position. He is in a good position to understand what was expected and intended by this application, and you are not, correct?
he was in a position where if he was following his responsibility as a geologist for our company, he would have communicated this to me if it had been true.
And
I was his boss starting in December 2011.
the substance of this was communicated to you, wasn't it,
No, it wasn't.
Mr. Marshall? Because Mr. Ehlers told you exactly this.
No,
correct?
Mr. Ehlers' affidavit is also incorrect.
He accompanied you for 3 weeks while you were going about your due diligence, correct? Yes?
I don't recollect 3 weeks of due diligence. We were working closely together beginning in the beginning of September.
Can we look at Mr. Ehlers' statement at paragraph 19, his first witness statement?
Perhaps we might look at that after the adjournment. We've reached,
Absolutely.
I think, a convenient moment to break for 30 minutes.
Okay.
You are on mute, Mr. President. I think somebody's going to need, somebody needs to actually unmute on Zoom.
We're all right. We're not
Oh,
muted.
there we go. Perfect.
But
Okay.
we would like the big picture on the screen.
That is nothing I can do from here. Your technician's going to have to be able to do that there locally, unfortunately.
Where is he?
I've got some phone numbers. His name is. I'll try to call.
Look, we'll carry on. We'll carry on. We'll carry on.
Okay, I'm going to go off camera. I'll wait to hear.
No, we're going to carry on.
I don't think we have a witness yet, unless Mr. Marshall.
Well,
Would you like me to bring the witness in?
Oh, I'm sorry.
yes,
yeah.
please. Yes,
May
please.
I ask one of a very brief housekeeping question, basically just the schedule for this afternoon. I know it was an open question at the end of the day yesterday to make 30-minute breaks, but
Yes.
just for expectation purposes, I don't have any further detail about what's expected for the schedule for the rest of the day. When those breaks,
We're going to go through until about 3:45 our time. That's another hour and a half. Then we have a half an hour break. And then we go through till 6 o'clock our time, where we have a quarter of an hour break. And we finish at 7:30 our time. A bit of flexibility in when we break to make sure it's convenient time.
thank you. I just wanted
The next break in an hour and a half or so will also be a half an hour break.
thank you.
Okay, we're going to bring the witness back in right now.
Yes, please.
Mr. Marshall, I was going to ask FTI to pull up paragraph 19 of Mr. Ehlers' witness statement. Mr. Ehlers is dealing here with what he told you prior to your acquisition of NRD, and he explained in paragraph 19 about the November 2010 application, and him telling you that if they were that the application, any license would be on a short-term rather than a long-term basis. And what he says at paragraph 19, do you see? That was because, as we fully, at the bottom, that was because, as we fully accepted, NRD had not sufficiently carried out the exploration it had agreed to do in the contract, and had therefore not been able to provide a feasibility study which contained the detail which would be necessary to satisfy the government it should grant the concessions to NRD on a long-term basis. And that's what you were told, isn't it?
No, no, that's not.
And then he goes on to say, in relation to this, under the contract, The granting of long-term licenses was conditional on NRD providing evaluation reports of reserves and a study of the feasibility of long-term mining at the end of the 4-year period, and these being approved by Rwanda. However, as I learned when I came in, funding and investment in NRD had not been made to the extent originally envisaged, and as a result, NRD had carried out only relatively superficial exploratory activities, such as reviewing satellite imagery and carrying out some pretty basic, not very comprehensive sampling. Although, accordingly, we thought the most of the result from submitting to the application would be that NRD might convince Rwanda that at least we had the intention to carry out the kind of detailed exploration they would have expected, and now had a plan to do so, even though we had not done it by that point. And again, that reflects what he told you, doesn't it?
No, it's entirely apocryphal. It's detailed, but apocryphal.
Then he says, I also explained to Mr. Marshall that, as was obvious from the visits we took to the concessions, NRD had not taken any real steps towards industrialization, which was also a requirement of the contract. In relation to this, as is apparent from the November 2010 application, the original business plan submitted by NRD in 2006, on the basis of which the contract was signed, had pledged an investment of almost 40 million between 2007 and 2011, whereas in fact only a small fraction of its investment had been made. My understanding, as also reflected in the application, was the original owners had not been able to commit the promised finance. Further, when Stark had taken over control of the business in 2008, they had decided to change the business plan from one focused on high levels of capital expenditure on infrastructure and investment in equipment, which would have led to true industrialization, instead to focusing on trying to make a profit by working with small-scale artisanal miners. I'll explain something about this below. And again, that's what he told you, isn't it?
No, it is not. It's
He's
entirely apocryphal.
Which bits do you disagree with?
We never had any of these conversations.
Though you certainly understood, didn't you, for instance, about the 40 million of investment from the start that had been promised in the original business plan not going in?
No, the 39 million is referenced in the.
Sorry, yes. 39. You knew that hadn't gone in, yes?
But it was not a requirement.
It was in the investment plan.
I understand that he's saying that it is, but it was not.
Well, it was in the investment plan to be spent over 5 years, and then indeed
it was predicted to be invested over 5 years. Nobody ever said you have to come up with the remainder of the 39 million. In fact, we were never asked for investment.
My fault, I spoke over you, but you're saying it was predicted, did you say?
No, it was Zarnak had predicted that they were going to build some kind of, if you look at their original investment plan, some kind of tantalum processing plant for $20 million, and that they would also be building out Gatumba and yet another concession. And so it was very unclear what was, it was, I would say, a good faith statement of their commitment rather than an accurate portrayal of what concretely they would do with their money.
But it was their investment plan on the basis of which they got the contract, wasn't it?
But investment plan indicating the types of things that they were interested in doing. Nobody was held to a checklist of investments that if they were made, then that was sufficient. Nobody ever said we failed to invest enough.
And as you recall,
until this arbitration process.
As you recall, the November 2010 application, in fact, has a section explaining that the 39 million hasn't been spent and trying to explain why and saying that there's been a change of management and a change of approach. Yes?
Yes, as I explained, this was not a commitment, a contractual commitment to invest 39 million as a condition of getting a long-term license. I'm sorry, I have to repeat again, this was a very unusual circumstance, unheard of in the mining industry, where mining companies were investing money before they got a long-term concession. That being the case, people were trying to work in good faith and work around as an accommodation to the Rwanda government, who were struggling. They wanted to be able to show process. They wanted to be able to show US investment. They wanted to be able to show things were changing.
Let's go on to see what Mr. Rader says about what he told you. He says, for these reasons, this is paragraph 22, for these reasons, I do not think that Mr. Marshall could have had any expectation when he acquired NRD that it would necessarily be granted long-term licenses or concessions. It should have been, and I believe was, clear to him that at least the steps proposed in the November 2010 application in terms of further exploration would have to be carried out before there was any chance of the government being persuaded that long-term licenses should be granted to NRD for any of the 5 areas for which it had granted the initial 4-year license. And there was no guarantee that those initial 4-year licenses would be extended at all. And again, that's what he told you, and you clearly understood going in.
Completely untrue. In fact, most of this is completely untrue. It's very detailed. I respect that he's put together a very elaborate story, but it's simply not true.
Can we now go to paragraph 18 of his second witness statement? This is dealing with your position on the mining, what the mining community understands. Paragraph 18, based on my experience of Rwanda, it is not true that long-term licenses are automatically granted by Rwanda after 4 years. That's just not how it works, and everyone in the mining community in Rwanda is aware of this. Rather, it is the common understanding that many conditions have to be met in order for long-term licenses to be granted. Indeed, this is true of every country I've worked in. Shortly after I joined NRD in mid-2010, I met with Dr. Michael of the OGMR to discuss the process of obtaining long-term licenses, and he advised me more work still had to be done, in particular in carrying out exploration and proving ore resources before they would be granted. I informed Stark of this. Subsequently, Dr. Biriarminets, Dr. Michael reiterated the same point to me several times about the work that would need to be done. Then he says, before long-term license is granted. Then he says, as I've explained at paragraph 19 of my first witness statement, I clearly explained these requirements for the granting of long-term licenses to Mr. Marshall before Spalena acquired the company in December 2010. And that's exactly right, isn't it?
No, it's exactly wrong.
And as he says, in particular, I explained to him NRD could not expect to be granted any long-term licenses upon expiring the initial 4-year license, as it had not sufficiently carried out the exploration and was unable to provide an acceptable feasibility study as required under the contract. And that's what you knew.
Entirely false statement. He arrived in June. He left several times because of health reasons. He went home at Christmas in December, and he never came back. So his total stay in Rwanda was probably 4 months. He didn't have the experience. He never communicated any of these things to me. We never got any. I mean, we were grateful to be able to negotiate with him to figure out how we were going to work into a joint venture between NRD and Bayview Group. But none of these things are entirely made up for the purposes of this arbitration.
You say he did not have the experience. Mr. Aders is a professional who's been involved in a career in mining all his life, and you are not, correct?
Mr. Ehlers?
Yes, he's a mining engineer, and you are not.
He has a very, very bad reputation.
So I'm just picking you up on your suggestion that he's not, didn't have the expertise. He has expertise in mining that you do not have. That's correct, isn't it?
He had responsibility in working at very large complex gold mining operations. As far as I know, he was fired from most of them. But he was doing unspeakable things in Rwanda, preying on people. And
do you want to have one more go at answering my question, and we'll see if you can do it? He has expertise in mining, which you do not have, correct?
It's possible, but I don't know that.
Now, let's just go back to what he says at paragraph 26 of his first witness statement. Let's see if you agree with what he says here. My understanding is that when granting licenses and mining rights under agreements, such as the contract entered into between NRD and Rwanda in 2006, what Rwanda wanted to ensure was that the mining operations in the country would move away from an artisanal mining model towards a more productive and professional industrial model. This necessarily involves significant investment in exploration and resource evaluation, and then in more sophisticated mining equipment and infrastructure, as well as the organizational requirements for employing miners and ensuring greater health and safety standards and ceasing reliance on child labor. And that's a fair summary, isn't it, of some of the things that industrialization involves? Yes?
No, not in Rwanda. That's not the meaning of the term there, no. Any artisan support, they deem industrialization. Anything to move away from simple buckets and shovels and hammers is, in their mind, industrialization.
Let's look at paragraph 27 now, next paragraph. In short, by the time I'd started to work for NRD, had not taken any significant steps to transition from a basic form of artisanal mining to an industrial model because the necessary investment was not made. And indeed, as admitted in the November 2010 application, once Stark took over, he's taken a conscious policy decision to base the business on supporting small-scale artisanal mining on multiple bases. Accordingly, none of NRD's sites were producing anything remotely close to the quantities of minerals that would have been expected after proper investment and industrialization. And that is a fair summary, and it's also something you understood when you came in, isn't it?
I'm sorry, let me read it for a second.
Yes, please do.
No, that's not true.
Well, as then he again goes on to deal with the concessions individually, starting with Route Zero. He explains that at Route Zero, Stark had attempted to industrialize by building a plant using equipment purchased from Malaysia. The plant was built to wash the minerals and to extract tungsten from the wolfram ore body. You agree with that so far? Yes? Nothing you're aware of that's wrong there?
Yes, again, he's misusing, he's not using, I'm sorry to have to repeat it, but this concept of industrializing mining is different from the way you seem to be interpreting it. And he is trying to muddy the water here in this sentence. Industrialized by building a plant. All increased possibilities for the artisans to have jackhammers, to have a handful of machinery. Now, this is quite separate from the road building, from the bridge building, from gaining access to sites. Those are first. Second to that is enabling the miners to be able to be more productive.
Now, is that the only thing you want to disagree with in paragraph 28?
This sentence.
So I've covered this point with you before. I'm not going to ask you more questions about that now, but is that the only point
Your Honor,
you disagree with in this sentence?
Your Honor, may I ask that he allow the witness to finish before he cuts him off and says he's done with a point? He clearly wasn't done, and the purpose was to stop him from answering.
Well, I obviously don't want to cut across answers, but I will cut Mr. Marshall short at times if he appears to be digressing, because we've just simply got to get through this, and we're going quite slowly.
And that's
I object to that description of that answer. It was directly on point.
Now, is there anything else you want to disagree with in this sentence, Mr. Marshall?
Yeah. You asked whether Stark had attempted to industrialize by building a plant using equipment purchased in Malaysia. Now, first of all, that's not the meaning of industrialize. According to the Rwandans, the Rwanda government and the Rwanda mining community, industrializing is providing any additional support equipment to the miners.
Now, you've given that evidence, and I disagree with it, and I'm not going to ask you about that again. Do you have a different point?
Do I have a different point
Do you
about
have
this?
any other point other than that point about industrialization? Anything else you disagree with in these first two sentences of paragraph 28?
Yes, because that's not, that's only one element of industrializing. I object to both your term of industrializing, meaning some kind of abstract full mechanization mining. There's no place in Rwanda and in other places where you can do that if it's simple vein mining. These are very limited deposits, and to say, well, you had an obligation to industrialize, that's not the meaning of it in Rwanda.
Let's go on. When I started as managing director in early 2010, the equipment had already been purchased.
Using equipment purchased from Malaysia. No, the equipment wasn't purchased from Malaysia. The equipment was purchased from all over. They had a very good German engineering firm which sought different pieces from different companies because they needed to have it as hardy and as resistant to breakdowns as possible. For example, in comparison, Rutungo did buy a whole plant from China, and the whole plant never functioned. They had to replace motors, they had to replace cables, belts, and you can ask Susanna about it directly. She was there. This was very different. This was a highly specialized engineering project from the German company. They spent nearly a year just doing the site work. when they did the engineering work, they went to find experts in each one of these types of processing equipment, because the plant is nothing more than an assembly of processing equipment, a crusher, a roller crusher, a trommel, a jig. All these pieces can't come from one place and survive. The engines had to be sturdy. We never had to repair any significant piece of the plant ever. The engineering had to be done.
The plant wasn't operating.
I'm sorry?
When you say you never had to repair a piece of the plant wasn't in fact processing.
The plant was processing. We didn't have feedstocks to start it from the beginning. Pieces of it were. You could operate the shaking tables. You could operate the jigs. The plant doesn't have to operate as one piece. That's what I'm.
Let's go on with what Mr. Ayler says. When I started as managing director in early 2010, the equipment had already been purchased and construction of the plant was well underway, though it was not operational. Artisanal mining was still continuing. NRD was making some money from this, taking the minerals from processing in Kigali. However, the problem was that Stark and NRD had never undertaken a proper analysis of the ore body at Rutsiro prior to building the plant, and had simply assumed without conducting proper exploration that the minerals were in higher concentration was in fact the case. In other words, they'd gone ahead and built a plant without doing the necessary exploratory groundwork. The result was that because of a low concentration of minerals in the rocks, which were in scree in the hillside in the area the plant had been built, the plant machine could not produce sufficient volumes to make its operation economic or commercially viable. I showed this plant to Mr. Marshall when we visited Rutsiro and clearly explained to him my concerns. It was not appropriate for the site in which it was built. From what I subsequently heard from contacts from Rwanda, once Mr. Marshall took over the NRD, this plant was never operated and mining at Rutsiro remained based on artisanal mining. And all that is accurate, isn't it?
No, none of that is accurate.
Can we go to the what he then says about Nemba?
Can I answer and give you specifics why it's not true, or do you just want to go
Yes,
on?
you please do, but please be, if you can, concise, just because of timing.
Well, I can't fit to your argument. I need to be able to explain the process so you understand where you're mistaken.
Well, perhaps in that case, Mr. Cowley will do it with his redirect. I'm going to move on to Nemba.
No,
If you look at I'm going to ask you to move to Nemba now, Mr. Marshall. Nemba had not been industrialized either. In the context of this mining site, which unlike Rutsiro was located in the flat countryside, industrialization would have meant carrying out proper exploration by way of drilling and then building underground tunnels to exploit seams of tin underground identified from this exploratory drilling. However, this was not done. Instead, NRD had continued to use tunnels and infrastructure that had been set up in Belgian colonial times, although in fact a number of the tunnels had been closed on health and safety ground under Stark's ownership, and some re-timbering work had been carried out, and to allow artisanal mining on the surface. As of Rutsiro, I explained this to Mr. Marshall and showed him the site, and that's accurate in relation to Nemba, isn't it?
No, it's not, and it did not happen. He never made any of those statements to me. When you're building out an existing mine like Nemba was, it is different from a greenfield site, which is what Rutsiro was. They built the plant in Rutsiro in order to be a central location for deposits with up to 10 miles away, and they brought the dump truck suitable for that activity. Nemba was different because it is a smaller defined deposit of cassiterite with some coltan. And in that, you build out from existing veins. You don't start as if it's a greenfield site. You determine what you have and you make assessments about what the likeliest and most rich veins are and pursue them individually.
But using exploratory drilling, which had not been done, correct?
Lord, I'm sorry, you're sorely mistaken about the purpose of exploratory drilling in vein mining. There has never been any successful exploratory drilling in vein mining in Rwanda ever, even though the government has often asked for it. Exploratory drilling can be for placer deposits. I think if you can imagine, if you're trying to drill into a vein, it's like drilling in and hitting a piece of string. If you hit the vein, it's 100%. If you hit right next to it, it's 0. It doesn't tell you anything. And that's why, although Dr. Michael is misled and thinks that that's a good idea, none of the companies do.
NRD's other sites are dealt with in the next paragraph, the Mara, Sabea and Gakia concessions. And those also remained basic artisanal mining operations and no industrialization had occurred. And that's correct, and that's what you were told, yes?
No, that's not what I was told.
And we've also seen, just in relation to your last point, we've also seen from the 2010 application that it was envisaged that there would be further exploratory work in the November 2010 application. And that just shows, doesn't it, the kind of work that had not been done prior to 2010 and should have been, correct?
No, that's not correct. That's not the way the industry works. There's always exploration and development ongoing at every step.
Now, and after...
With regard to Mara, Sabea, and Gachia, it's an allocation question of where you decide to use jackhammers, drills, compressors, and generators. It's a set, and you have to decide based on what kind of production you're getting, where you allocate that set. You know, these are always management questions, and there is no magic to any of this. And you allude to plants somehow as being magical. That's not it. This is simply determining what the best locations to pursue mineral drilling are, and guessing that you're going to be, by using the machinery here and not someplace else, you're going to get a better result.
We go to Mr. Sindagaya's witness statement there, paragraph 16. He was there for rather longer than Mr. Ayers, so he can take the story forward.
He was suspended for 6 months or so I'm not sure that he was.
Well, he was there until November 2012. And let's just look at what he says about the Rutsiro plant.
Before that, he was suspended for 6 months in the beginning of 2012.
Let's just look at what he says about the Rutsiro plant, paragraphs 15 and 16. As I explained above, when I joined NRD, the plant at Rutsiro is under construction. Spark was spending a lot of money, around 25 million francs a week, on a construction plant and related infrastructure, including building a road to access the plant. Unfortunately, the plant never operated. The plant had been built to process tungsten. However, it turned out there was not enough tungsten rocks at the site to make the operation of the plant viable. So he's also confirming that the plant never operated because there was not enough tungsten for which it was built, correct?
No, he has an axe to grind. He stole from the company, we fired him, and now he's, as I can see, making stuff up. This is not true.
And as he confirms, you go to his second witness statement, paragraph 5. He also says, in relation to the same point, although we ran a few trial runs of the plant, it was never in use throughout my time at NRD. And that's correct, isn't it?
No.
Now, you're also shown the company's documentation in relation to the due diligence that you conducted, yes? When you did due diligence, you saw other documentation from the company. Not just a license application and the contract, you looked at other company documents too, didn't you?
Yes.
Correspondence, yes?
Yeah, it's 12 years ago. I don't really remember, but quite likely.
Can you be shown R105? This is a letter from NRD in July 2009, so again, before your time. And in the first 4 paragraphs, it explains what's the position at July 2009. Nemba, Rutsiro, Gachia, Sabea, and Mara concessions granted on 24th November 2006 for a 4-year period to evaluate the potential by exploration and to start industrial mining operations as soon as possible. In those days, Christoph Zarnak and his son Jens Zarnak from Germany were the major shareholders of NRD. Despite firm promises made by these gentlemen, they had limited funds and were lacking expertise in exploration and in mining. Therefore, very little progress was made during the first 2 years until H.C. Stark, one of the world's leading processors of special metals.
I don't know where you're reading from.
I'm sorry, I'm towards the end of the first main paragraph. Do you have that? Therefore, very little, last sentence, therefore, very little progress was made during the first 2 years until H.C. Stark, one of the world's leading processors of special metals, took full control of the company late in 2008 by acquiring the shares from the Zarnaks. Another reason for the delay in our exploration and investment program was the lacking infrastructure in such areas like in Rutsiro, Sabea, and Gachia concessions, where we had to reconstruct roads and bridges. Then he goes on to the third concern, had to cope with last year was complete lack of sufficiently detailed topographic maps. And then he says, all in all, we lost about 2 years to investigate the concession's potential and to evaluate ore grades and reserves. We therefore kindly apply for an extension of the concession agreement for another 2 years until November 23rd, 2012. And were you aware that the Starks had applied for a 2-year extension of the original agreement?
No, I wasn't, but I can understand, because not that they need to prepare additional materials for the government, but they wanted to be able to hold on to the right to have the long-term concession, but they weren't prepared to invest more money without doing, obviously, more research.
But on your argument,
this is not about the government. This is about their needing to do that work for themselves.
But on your argument of this sort of guarantee of a long-term contract, they wouldn't need to ask for 2 further years, would they? Because it wouldn't matter what they were doing.
I don't know. I wasn't party to those discussions. As far as I knew, we had complied with all the conditions. They'd all been accepted. We were the best, in fact, application. And we immediately went into negotiating the language of the long-term concession.
Can you go to bundle C? Just to be clear, did you this request for a long-term concession was refused by the government? Were you aware of that?
No.
Can you go to bundle C026?
October 2010?
Yes.
All right. The documents being presented to the cabinet were not until the end of 2011.
I'm just showing you this document, which is a 2010 document. Now, this says, following different visits of OGMR officials to your mining sites and different reports submitted, we do inform you we're satisfied with exploitation progress at Syria mining site, specifically the construction of a washing plant, which is still at the testing phase. We also acknowledge upgrade of facilities at Nemba mine, like the supply of water and new equipment. The 4-year contract you have with the government of Rwanda will expire in 2 months' time. However, there are no final report and feasibility studies for any of the 5 concessions granted. And then the writer refers to the dramatic decrease in productions of minerals. And then he says, regarding to your request for a 2 permits extension, you were requested to show clearly what had been done in the past 4 years in exploration and exploitation, submit reasons for the need to extension. Due to the relatively low investment done and a large number of concessions you own, I request you to give some back to the government. I believe in the last 4 years, you identified those you would prefer to keep. In your 2-year progress report, you give a good estimation of wolframite resources, but no data for tantalite and cassiterite was submitted. But you're not able to give us also the estimation for the 2 minerals before the end of the year. So NRD was being asked to give back some of the concessions, wasn't it?
That's what the text of this letter says. I don't know about it.
And you were aware of that, weren't you, when you came into the company?
No, but they often ask for things and then reverse themselves.
The government had already identified a relatively low level of investment and had already notified NRD of that. Yes.
It may have been a low level of investment for whoever this author was, but it's certainly far more than any other investment, mining investment in the country.
And you were also aware
from the only road repair, nobody had done the work we had done.
You were also aware from your due diligence, weren't you, that by mid-2010, Stark had ceased providing funding to NRD and equipment was in fact being sold to pay miners' wages?
That's not true.
If you look at Mr. Sindagaya's witness statement at paragraph 17, you'll see, here's a account of it. Mr. Sindagaya says in paragraph 17, there was a period of about 6 months in 2010 when it mandated the then managing director, Mr. Ehlers, to restructure the company's business and operations around cassiterite, including investigating the possibility of using the plant for cassiterite, and it provided around 100,000 in June, July to support the proposed restructuring. We did not receive any further money from Stark after this, and so far as I can recall, they started looking for buyers. And then a little lower down in paragraph 18, he explains about an Australian company withdrawing and then meeting you. And then he said, and it's right to say that NRD was in some financial trouble by the time that you arrived, correct?
No,
Well, we'll come back to that.
not that I know of. Is as far as I understood, this to me, this is entirely new information. I've never seen this before. It was never represented to me when we came to the offices. We've been there many times, but we came as the new owners beginning of January. This information was never communicated to me. HC Stark is a blue chip company. They do everything right, really. They pay their taxes. They have good engineers. They're meticulous about this process.
Now, I'm going to turn now to the question of
Anthony Ellers was embezzling money. We couldn't find out how much. And is that what happened to the money? I don't know.
I'm going to turn now to the question of investments made into NRD, starting with investments made before you and Spalena acquired NRD. Now, Mr. Sindhigaya had been there since January 2010, and he explains that in his witness statement that in the period he was there, the only mine into which there was material investment was Root Zero in respect to the processing plant. And would you agree with that?
No.
If you look at paragraph 9 of his first witness statement,
all of the concessions had equipment, and it was a management decision where to allocate what equipment when. It's not a permanent thing. The veins, are sometimes very successful, and sometimes they peter out for a while. So it's an allocation question.
So he explains paragraph 9, Rutsiro, the only plant invested in his time. And then
by the way, this is the only plant in the country.
Then he explains in paragraph 11, Nemba mine not industrialized, mine done by artisanal minings. There was some infrastructure, few tunnels left over. NRD did not make any investment in a Nemba mine during the period I worked for the company, although I understood some very limited investment had been made before I arrived. That'd be before 2010. And that's right, isn't it?
No, it's not.
Well, he's the accountant of this company, so he's going to have good idea, isn't he, of where the investment is, where the money is going.
He's not an accountant. We had an external accounting firm. His job was to supervise these things. This is the first that I've ever heard him say these things, so I would have to guess at what his motivation might be.
Then he says, paragraph 12, sites at Mara, Sabaya, Kakia, also artisanal mining operations. During my time at NRD, the company did not invest any substantive money in them. And that's correct, isn't it?
No, it's not.
And then we have Professor Repair explaining it from his perspective, and you'll see that at paragraph 8. His witness statement.
This is still Amy's.
Paragraph 8 of Professor Repair, please. So that's Prosper Nikanika Repair. If FTI could, you've got it. Yes, that's right. Paragraph 8 of that. He explains there that he joined as chief geologist in March 2008 when the Zarks had sold their shares to Stark. And so he's able to speak to matters from 2 years before Mr. Sindhigaya, yes, from 2008. So 2 years before Sindhigaya arrives in 2010. and he's able to cover the period from 2008, which is the whole of the start period, to early 2012. So that's the period covering the first couple of years of your own ownership. Yes?
I understand the date.
Yeah. So he says at paragraph 9, when the time he arrived, this is 2008, it's clear that in the year or so the Zarnax have been in charge of the concessions, very little has been done to develop them, and very little money appeared to have been invested. So that's the starting point in 2008. You do disagree with that?
I do disagree with that.
Well, you know about investment in the Zarnak period when Mr. Rupaya
I know
doesn't.
the equipment that was purchased in the Zarnak period, and I know generally where it was distributed during that time.
Well, Mr. Professor Rupaya is got a clear picture because he was there and you were not. Yes?
He has a different picture. I don't know what his motivations are. These are statements that until now he certainly never made to me, and I don't believe them to be true.
He then goes on to explain what happened in the Stark era. And he explains that Stark were particularly interested in exploiting tungsten. I learned that prior to my appointment, when the Zarnax were still in control, an Australian geologist had calculated the scree rocks in which Zero concession had significant wolframite reserves. I believe that is why H.C. Stark had been interested in acquiring NRD. On the basis of this information, H.C. Stark decided they would invest in the mechanized plant at Route Zero to process wolframite scree. The machine was imported from Malaysia, took a long time to be delivered. Just pausing there, this machine was imported from Malaysia, wasn't it? That's the second time we've seen this. Different witnesses.
Second time, and it's incorrect for the second time.
Different witnesses.
Many pieces were purchased from Malaysia, but it was a specialty built plant sourced of equipment from different companies in different parts of the world.
Then he says, took a long time to be delivered and then to be commissioned. It cost somewhere in the region of $1 million, and H.C. Stark believed they'd be able to generate significant profits from it. However, by the time Dr. Reuter left in 2010, it had not been fully commissioned. The commissioning was completed by Mr. Ehlers when he joined, but the plant was a total failure. And when it started in late 2010, it turned out the scree rocks contained very little wolframite. And so the plant was essentially useless. It was not commercially viable, and it never operated throughout my time with NRD. And that's accurate.
That I knew Professor Nkanika, he never said anything like that to me or anybody I knew. It was always the premier plant, and it could be used for any of the 3 T minerals that were available, cassiterite, tungsten, or tantalum.
And then still on the question of investments, he goes on at paragraph 11. In addition to the failed plant at Route Zero, H.C. Stark made some relatively small investments at Nemba, which was already the most developed of the concessions because it had mine shafts and tunnels left by the Belgians. H.C. Stark invested some money to repair some of the tunnels which had become dangerous, but this meant they were closed for a while. They also bought a couple of crushers which were fed by artisanal miners who mine the rocks manually, either with picks and shovels or with some jackhammers, which H.C. Stark had bought. They also acquired 3 compressors and a grinder and some safety equipment for the miners. Overall, however, this was a pretty low level of investment for a concession which had the possibility to be a large-scale industrial tin mine. And that's all accurate, isn't it?
None of that's accurate.
And then paragraph 12, no investments, so to speak, were made in either of the other 3 concessions, apart from perhaps some safety equipment for miners and a few hand tools. H.C. Stark were just not interested in them. And that's correct, isn't it?
I'm sorry, where are you reading from?
Paragraph 12. Please read it to yourself. I just read it out.
That's simply not true.
And then Professor Rupaya goes on to explain in paragraph 13 that he proposed to carry out exploratory work. They weren't interested in it and they only wanted to focus on the wolframite. And that's also something that you understood.
Professor Nkanika was working for DMI. That was his primary obligation. That's what he had to do because it was a requirement from the state. We understood that. We could rarely get Professor Nkanika to go into the field. So we had to bring in foreign expats to do the exploratory work because Professor Nkanika would not do it.
That's simply not true because he did go into the field, and you can see this from the next paragraph. So paragraph 14. So by late 2010, NRD was still running artisanal mining operations with little of what I would consider proper serious exploratory work having been done, and with no industrialization of any of the concessions. Each of the sites had a site manager, but they were not skilled mining engineers. They were really just managing the artisanal miners and trying to ensure that what they provided, what they produced to NRD rather than selling to other people. We also had security people on the site to try to stop unauthorized artisanal miners from taking the minerals and selling them elsewhere. As I was not being used to do exploratory work by NRD, I used to go into the field, check site by site, and produce monthly reports of the production at each site. So he did go into the field, didn't he? And he produced these reports. Yes?
A day at a time. He never did any significant exploratory work when I was there, and he refused to do it. He was busy with government matters.
He didn't do significant exploratory work because, as he explained, the investment was not provided for that work to be done. Correct?
No.
Now, let's go to the document we were looking at.
By the way, I would like to make one comment about the process here. All mining is artisanal. It's only a question of who gets support from the equipment. The deposits where there's the greatest likelihood, these are very highly scattered, very small deposits. The only process of industrialization is in allocating those groups of equipment to people who could make use of them. So for him to say there was no industrialization, that's false, because all industrialization is artisan support industrialization.
We go to bundle C35, C035. I'm just going to start by looking at page 57. Sorry, I did. That's Professor Ripai there, isn't it?
Yes.
In the field. In the field, yes.
Yes.
Now, can we go to page 97 of this document? If we look at the bottom of this page, we have a section headed Achievements in Research, Production and Processing versus Targets outlined in Original Business Plan. And underneath that paragraph, it reads, the original business plan was submitted by NRD in 2006. The proposed volume of investment in equipment and working capital amounts to 39 million for the first 5 years, 2007 to 2011. Yes?
Yes.
And
that's what it says.
And then if we go on to the next page, and we can look at the last two paragraphs. It says, therefore, when HC Stark acquired the majority of NRD in 2008, the focus of activities and investments changed from large and unrealistic projects to supporting small-scale artisanal mining in multiple places, with an emphasis on increasing the standards of safety in the workplace and protecting the environment. And then it has a paragraph which says the following tabulation gives an overview of the investment in equipment, services and salaries over the last 4 years. An expenditure of 7.6 million francs is evidence of the commitment of NRD to the development of a thriving mining industry of Rwanda and its people. And 1 moment. So that's dealing with the relative underinvestment, the amount of the underinvestment by comparison with what was predicted by the Starks. And if you look at the table that follows, I'm going to ask FTI to now.
Sorry, just
yes.
To go back, I think if you could bring up the previous screen. Sorry, both screens at once. Thank you. At the bottom of the screen, it says the original business plan included investment in Nyakabingo and Gafurwe, which are also very large mining concessions. So if this plan was to include those, then you're talking about again maybe a third more and actually richer deposits than what you're dealing with in the West. So I can imagine that it would have been more if you were including Yakabingo and Gifurwe.
Can you go to page 101, FTI, please? Just to jump ahead to the actual number invested compared to the 39 million projected, and the euro figures on the right-hand side, so it's 9.3 million euros. Yes?
Yeah, I don't have the top of the table, but okay.
And you knew coming in, didn't you, that this 9.3, that there was this significantly less investment had gone in than planned?
Then 40 million.
Yes.
Yeah.
That's what you knew that?
Yes.
Yes. Can
But
you then go
40
to page
million
99?
40 million was not the contracted amount.
No, we've got that. Don't worry, I'm not going to go back to that. I want to move on. Can we go to, so page 99 gives the expenditure from 2007 to 2010. And I'm going to want to look, FTI, at 3 pages, which is 99, 100 to 101. I don't know how you could, whether that all 3 can be put on the screen or whether that's not viable.
You lose screen space very quickly. If you can do them sequentially, that would be much better.
Well, okay. So just try and give you an overview of this document, Mr. Marshall. You see you have expenditure 2007, 2010. You have a number of items here: vehicles, processing and laboratory, plant, mining and tools, you see on this page. Yes?
Okay.
And then the next page, you have Office Kigali, salaries, costs, infrastructure, environmental activities, and so on. Yes?
Okay.
And then the last page, you have the final, a few small items, and the final number of 9.3 million. Yes?
Yes.
You can probably keep the 9.3 million figure in our heads and just look at 99 and 100.
Right. At the exchange rate at that date, it was 13 million. That's the handwritten number underneath it.
Now, there's no suggestion in this report that all this investment is all new investment from the Starks. In fact, much of this would have been reinvestment of income from mining. Yes?
Yeah, I don't know.
Likely. When you look at some of these items,
Certainly, I would imagine that some of it is, because there is turnover, and so there would be income, but I don't know if that's reflected here or not.
yes. Well, it's the kind of thing you would expect, because you see, for instance, this covers rent and salaries and the kind of items that you'd expect to be coming out of operational income.
I see.
I
I would have to have somebody walk through that for me, but I know as a general practice, other concessions do include turnover as part of their contribution.
Now, I want you to keep 101 on the screen, if possible, FTI. And then if we can now go to C054. This is the letter from you to Mr. Kamanzi in January 2013. And we'll be coming to the substance of this later, but this is the application which you submitted in January 2013 for long-term licenses. Do you recall that?
Not specifically, but I see the letter.
Yes. Well, I'm going to do all this cross-examination chronologically, so we will get to January 2013 soon, I hope. And I'm going to ask FDI to go to page 5 of this letter. That's 4, one more page. This gives total, an estimation by you in January 2013 of total investment in the period 2007 to 2012.
Okay.
And you'll see you end up with a figure of 15.8 million euros.
Okay.
Yes? If we keep that on screen and go back to page 99 of the other document, thank you. You can see that this section starts with a list of vehicles acquired before 2010. Now, if you add up those vehicles acquired before 2010, you will find those numbers add up to fractionally over 865,000 euros, which is the same number as the number in your 2013 application document. I'm not asking you to do the arithmetic. You can take it from me, and no doubt someone, your counsel, will intervene if he disagrees, but you can take it from me, but it adds up to the same number. Then if you look at plant root 0 on page 99, you'll see you have a number for the plant root 0 of 912,000 euros. And you see that is the same number as you have as at 2013 in your application. Yes?
Yes.
And you get the same in other items. So for instance, we have processing and laboratory. Those numbers as at November 2010 on page 99 add up to 269,514 euros. And that's the same number as we see in your January 2013 application. And we have the same thing for mining and processing, where there are items that add up to 757,604 euros on the right-hand side. And again, in January 13, it's the same investment expenditure as at between 2013 and 2010 are the same numbers. Do you see that?
I'm getting the idea, but go ahead.
Yeah, so in all these areas, and we can do it across this document, in all these areas, the actual expenditure that you relied on in support of your application in January 2013 was the same expenditure. There's going to be one exception, which I'll come to. It's a big exception, but it's the same expenditure as was included in the 2010 application. Yes?
I don't know. I would have to have somebody look at it.
And what this shows is that there was no material investment conducted once NRD was taken over by Spalena. All the investment and expenditure that's material took place before November 2010, correct?
No.
Well, it's what your own figures show, because these are your own figures.
I understand that. I appreciate if you're running a company for, what was this, 2 years with 300 employees and 10,000, 20,000 subcontractors, there are necessarily expenses. Are these tables correct? I don't know. I would have to talk to the people who created it.
But it's we're going to come to the left-hand side soon, because we're going to look at the application, but this was your application in January 2013, and you were unable to identify any investment beyond the investment identified in November 2010. It's correct, isn't it?
I'm sorry, you'll have to rephrase it.
Yeah, when you made an application for a long-term license in January 2013, were unable to identify any investment beyond the investment I'd already identified in November 2010.
No, that's not true.
The only difference.
I'm not saying that it's here on the chart or not. I would have to have somebody walk through it with me. But there were significant investments, including all the BVG material.
Well, that's just one example of why this story about the BVG material is an invented one, isn't it?
No, it's not.
And I said there was one exception, it is a significant one, and that's at the bottom of the table on page 5 on the left-hand side of the page. You will see that there is an item of $6 million, euros, for foreign consulting and engineering. And it says in square brackets, est, so that's estimated. Yes?
Yes, we had significant expenditures from delegations of Slovak and Czech geologists who came over.
And that is not a real or accurate figure for actual expenditure on foreign consulting or engineering, is it?
Yes, it is.
Can we look at Mr. Sindegaya's second witness statement at paragraph 6.2.4? This is, he deals here, he's referring to a different document, but the same figures. States that the estimated foreign consulting and engineering costs are 4.84 random francs. This figure is grossly exaggerated. The only foreign consultant who worked for NRD for any decent period of time and who attracted significant salary was Mr. Fink, a German engineer who built the plant at Rutsiro. He spent approximately 2 years at Rutsiro, leaving at the end of 2010. So that's before the end, just interposing, that's before you purchased. I recall that paying his living allowance was always a priority, even though NRD was struggling financially. There are no other permanent foreign consultants employed at NRD during my years at the company. I do not recall any other consultants being hired after 2010. Although Mr. Marshall did bring in some Slovakian staff in 2011, they worked for Bayview and their task was primarily to construct this clinic at Bisesero. They did almost no work for NRD. And that's accurate, isn't it?
No.
And so what we see, we go back.
Amy is highly biased. He's terribly embarrassed for the terrible things that he did, and he got caught, and we fired him. So he's trying to get back his own, as far as I can tell. I've never seen any of this. None of this was ever mentioned to me.
What we can see in this document is that there was no material investment in the 2+ years before January 2013 that you had been in control of NRD, correct?
No.
Now, the claimant's written opening at paragraph 9 suggests that insofar as there was investment, that was derived from retained cash from operations. Would that be what you understand?
No. I mean, I think there was some retained cash from operations, but that was certainly, we were feeding the company. We had all kinds of operational responsibilities, investments. We were trying to do as many things as we could, as quickly as we could, because we saw the possibility of doing it better than anybody else. So it's a matter of allocation. It's a matter of putting in procedures so that not only does the compressor and mining drill stay in one place an appropriate amount of time, but that they do get supervised and for both maintenance, but to simultaneously identify what other area may need them more. And it's a constant exercise in covering whatever expenses come up. It's not a simple business.
Mr. Marshall, if you had put new money into this company, you would have identified it in your application form, wouldn't you?
I'm sorry?
If you had really put new money into this company, you would have identified it as one of the investments in your application form in January 2013.
We did identify it. We knew what we had to spend money on, and we spent the money on it.
And
this application, no, it was irrelevant. We had spent more than any other company. This application is only to say, look, remember who we are here. There's in the whole country, there's 6 mining concessions. We were expending far more money than anybody else.
And I would suggest that far from putting money into this company, which you weren't doing, you were in fact siphoning off money out of the company, which was being siphoned off and going off to Slovakia, correct?
Oh.
Now,
that's actually so far afield from what we were doing. Every day we were having to reallocate resources to be able to keep it going properly. And in the middle of that, we have the mafia, we have the military, we have bribed people who are causing problems.
Can we have now go to bundle C147? this is a internal NRD document that you've relied on in your reply. And if we look at the column headings, we can see that it purports to be a schedule of actual expenditure. What is it? You tell me, is this supposed to be budgeted or actual expenditure? This is one of your documents, Mr. Marshall. Are you familiar with this document? C1, it was produced by your side.
Yes, I'm sorry, what's your question?
Yes, are we looking at budgeted or actual expenditure as far as you understand?
But it says budgeted, although it's misspelled, but.
Can we go to Mr. Sindagaya's second witness statement at paragraph 6.2? So he comments on this document, and his evidence is that the investment figures the claimants rely on are pure fantasy, and the sums are grossly inflated. And if we look, I'm just going to pick up one example. If you take 6.2.3, he says the summary of activities, investment and plans on all NRD's concessions list an item: donations, construction of a clinic as having been incurred in 2010. There was no clinic at any of NRD's concessions, or a clinic was built at Cicero as part of BBG's promised corporate social responsibility initiative. And that's right, isn't it?
I don't know where you're reading. I'm sorry.
I'm sorry. You read it to yourself. I'm reading 6.2.3. Read that to yourself.
Yes.
And it's right, isn't it, that there simply was no clinic built?
Well, we had planned clinics for the other concessions too. The two companies were being operated jointly at that time. Were expenses from NRD being contributed to a joint charitable function, quite likely.
Now,
I don't think the construction of the clinic was finished until 2013, but it was a charitable project. It was not to do with producing income.
If we look at 6.3 of Mr. Sindagaya's witness statement, he explains the investment figures relied on by the claimants are not only inconsistent with NRD's audited accounts, they're also inconsistent with the reality of NRD's financial situation during the years I worked for it. Throughout this period, the company was in survival mode. The only outgoings were payments to miners, salaries, and basic operational expenses. There simply was no money available to be invested. And that's accurate, isn't it?
No, that's definitely not accurate.
Now, Mr. Ehlers also comments on your €6 million foreign consultant and engineering figures. And you'll see that at paragraph 14 of his witness statement. For his supplemental witness statement, I apologize. Supplemental witness statement, paragraph 14. So he also is looking at the same figures, and he says the investment plan report summary specifies that 4.848 million francs was, which is 6 million euros, was spent on foreign consulting and engineering. However, during my time at NRD, I don't recall we ever employed any foreign consultants or engineers aside from the engineer who constructed the plant infrastructure at Route Zero. Further, I was not aware of any foreign consultants or engineers being hired before my time, apart from a geologist member and another who provided provisional assessment of the ore body at Route Zero. So like Mr. Sindagaya, Mr. Ehlers does not recall any foreign consultants or engineering.
Mr. Eilers was there, as I keep saying, between June and late November. I don't know what he saw and he didn't see.
But you're not seriously suggesting, are you, that €6 million was actually spent on foreign consultants and engineers?
Is an estimated number of all the engineering obligations? I'm sure it wouldn't be there if it wasn't true.
I'm suggesting you knew that it's not true, and that this expenditure and investment didn't occur.
I understand that you're insisting that I am lying, but again, I'm not lying. This is the best estimate that our staff gave. If you're telling me that there's some other evidence, not by Mr. Ehlers or Amy, please let's talk about it. Their answers are nonsensical to me. They never commented. They never. If there was, it would have been numbers that Amy may have been a part of making that estimate. I don't know who else was involved. You can find out. But but for Ehlers, who was there before that period, he has no basis on which to say that.
Now let's go back to
long enough to understand the company.
Let's go back to C147, third page. You have some figures there for 2011 expenditure, which is presumably budgeted. And we know from the other document that we looked at that there's nothing like this level of actual as opposed to budgeted expenditure, because outside the square bracketed figure for foreign consultants, there's virtually no difference between the expenditure figure for November 2010 and the figure for January 2013. Yes?
We'd have to get our audit team back together and the planners, because I can't comment on it. I don't know. From my perspective, I have not looked at any of these because I thought this was going to be part of the bifurcated process. This goes to damages, not to, and we're separating that out, aren't we?
Can we keep that page on the screen and go to bundle R240? This is an email that's been produced by your side. It attaches another version of a document we've been looking at. And can you go to page 3 of the version attached? And this was a figure, sorry, one more page forward. So this is a document that was produced in September 2014, this second version, and it updates what we see in the other document, because instead of 2011, if you look at the left-hand column, it now says 2011 to 2013. Yes?
Okay.
And we can see that the numbers involved are the same.
Okay.
Do you see that?
I don't, but
Well, you can see. Look, I mean, I don't want to put words into your mouth. If you look, for instance, at 8333 figure for environmental projects.
I wasn't involved in the preparation of these, so if you ask our CFO, I think you can get concrete answers.
Well, what we can see is that the same investment, if you can call this investment, is put in for 2011 to 2013. As is put in for 2011 on its own, the second document being produced in 2014. Do you see that?
Yeah.
And this again shows, doesn't it, that there's no material investment in the whole of the period through to 2013.
I think you're going to need to refer this question to my CFO. Remember, we had fulfilled the requirement. If we had put in $1 million, we had fulfilled their requirement as it was expressed to us. I understand the business plan talked about 39 million, but for what they wanted as this initial phase to be able to show that you were capable of doing this, it was not to to contribute $39 million and then let Rwanda decide whether they get to keep it or we get to keep it. That was not, it never was the equation.
Mr. Marshall, you, as Spalena, didn't put in any material investment, did you? All the material investment took place before November 2010 and was done by the Starks.
That's
correct?
not true. That's not true.
Now, I'm now going to move on to look at the period from the beginning of 2011, after Spalena had acquired NRD. And we've looked at the level of investments in this period. Can I just ask you to pick up Mr. Sindagaya's witness statement? If FTI could put paragraph 21 on the screen.
Maybe I misunderstood, and maybe we should have been more up to date on going through this. I had understood this was being bifurcated at your request, that these go to damages. I'm not, you know, for us to be able to talk about what expenditures were incurred when, we had not prepared and gone through all those background materials.
Now, I'm going to ask you to look at, I'm going to ask you to be showing paragraph 21.
It'd be helpful if you could answer my question so that I could understand if what part is bifurcated and what part is not.
Well, I'm asking you about your documents. There's certainly been a bifurcation of the damages part of the case. I'm asking you questions on the basis relevant to the case that is before the tribunal, which is merits and jurisdiction. And so I'm going to pursue this line of inquiry, but although as it happens, I've come to the end of that particular group of questions. I'm now asking you about paragraph 21 of Mr. Sindagaya's witness statement. He says, from the day he started at NRD, Mr. Marshall showed no interest whatsoever in the mines or the operation of the mines. He did not invest any money in the mines and did not visit them. The new management team that he brought in had no mining experience or expertise. Mr. Marshall's focus was on getting the mining licenses renewed, as he believed this would enable him to raise money in the US and elsewhere. He therefore spent a long time visiting the US Embassy and the mining board, trying to use political pressure to get new licenses issued, rather than actually managing NRD. And that's a fair summary, isn't it?
No, I would say it's vicious. I would say that it shows his bias. He's pretending not to know what we were doing. The reasons we were going to the embassy were because that was our protection. They offered to help us. They were very kind in their help. We were getting preyed upon by at least one mafia group, and we were getting preyed upon by the military who, well, on one side, they wanted legitimate help. They also wanted us to smuggle. So I had to go to the embassy. I had no choice. And the embassy staff, to their credit, they didn't have to. They came to dozens and dozens of meetings with us to represent us in talking with representatives of the Rwanda government. It's a very unpleasant time. And we still, to this day, don't know exactly who had what motivations. Was it all to cover up the smuggling? You know, that's speculation.
Now, that aside, I'm not going to pick you up on those points, Mr. Marshall. You made them repeatedly. I am going to ask you to focus on my questions, but I will just say that none of those points are accepted. But I'm going to ask you to focus on my question. Mr. Sindagaya is right, isn't he, about what he says about the management team. You got rid of Mr. Ehlers, who was a mining engineer, and replaced him with a new management team that had no mining experience or expertise. Yes?
No.
Who do you say in your management team had mining experience or expertise?
Susanna, our CFO, and I were at the top of the organization, and we retained almost all of the Stark organization. Many of them were very capable.
Who do you say, well, we'll take that in stages. You're not suggesting that you and Ms. Moskovikova had mining expertise, are you?
No, we didn't need it. We had, and the same is true with Stark. The same, I mean, Rutongo, Tinko. The top people do not have mining expertise. They bring in consultants who run the mines for them. Tell us what to do. Explain it to me so I can understand it, and then we make judicial decisions.
So the answer to my original question, that you brought in a management team who didn't have mining expertise, is that's correct.
No, it's not correct. We kept the management team that has mining experience.
And
I was merely the CEO listening to everybody to try to steer the company in the correct direction.
Well, we know that we know who replaced Mr. Ehlers. We know we have
Mr.
Mr.
Ehlers
Quam,
was
for
fired for
instance.
cause.
No, you're saying Mr. Quam's got management mining expertise?
Mr. Kwan came in to look at some security issues, including, in particular, the crimes of Mr. Ehlers.
So is there an MD you're suggesting that has mining expertise?
No.
Is there any senior executive that you're suggesting has mining?
We kept all of the Stark staff, and I was the new managing director in order to be able to bring a logic to what I could see were logical decisions.
Which senior executives of this company do you say you retained that had mining expertise?
Who was running with mining?
Who was running the company?
We had a logistics manager. Amy was okay for what he was doing. We had an operations manager who would spend most of his time traveling from site to site. In fact, there was nobody who we didn't replace except for cause. When we found somebody was stealing or self-dealing, then we fired them. That's the only times. Otherwise, the Stark management team, and it was about 20 people, all stayed in place.
Again, your evidence is not accurate, is it, Mr. Marshall?
Are you saying that I just lied, or I'm not sure what you're saying?
I'm trying to find out. I'm trying to ask you about the management team. We know what happened to the management team. You got rid of the MD, replaced it with someone who wasn't a miner, and there were not other managers who were mining experts. That's correct, isn't it?
No.
Now, it's also right, isn't it, that, sorry, just give me one moment.
Ehlers did not have this kind of mining expertise.
And we're going to look at the documents over the next day or so, but it's right to say, isn't it, that a fair summary is that your focus was on putting political pressure to secure licenses.
No. My objective was to give the best service that I could to the Rwanda government as an advisor on numerous issues.
And you had no intention of committing any investment, any material investment, before a fundraising, which could only happen after long-term licenses were secured.
But your question's a false one. If we had the license, we would have expended huge additional amounts. But there are very complicated simultaneous negotiations going on with three discrete parties, as we identified them. With regard to the licensing and supervision department, we already had a long-term agreement. All we need was the okay from the cabinet. With regard to Dr. Michael and his machinations with Anthony Ehlers, who was bribing who and how that was working, I don't know, but it created a nightmare. With regard to the military that we were representing and giving advice to, they told us, please do not pay attention to Dr. Michael or to the Minister Evo. It's a problem of corruption. We gave hours-long testimony on the corruption we saw, and we followed their advice because they were the legitimate decision makers as far as
Mr. Marshall, everything you've just said in that last long answer, and we'll all make a note of it, is entirely new, not in any of your witness statements. And that's because you just made it all up. Yes?
True.
Why isn't any of that in your witness statements?
Which part?
Any of it. The three strands, Dr. Michael and Mr. Ehlers bribing each other.
Mr. Ehlers told us he was bribing Dr. Michael, and that's part of the reason we fired him. The reason we refused to allow him to come back to Rwanda.
That's not in your witness statement, and if you had genuinely thought that was true, or that was a point, you would certainly have said so in your witness statement, wouldn't you?
Look, I'm getting death threats. I don't know what point to be able to. Let me just say one thing about the death threats, if I may.
No, I'm not going to ask you about those. I'm going to ask you to answer my questions. Now,
I would ask the tribunal to allow the witness to answer because he's trying to answer why he didn't put it in a witness statement previously, which was the question. Mr. Hill is not letting him answer the question and suggesting he's not, but that's only because he doesn't like the answer.
Mr. Marshall does say in his witness statement about having death threats, so that certainly is not the reason. I'm not going to give him a platform to make further false points, which are not answers to my questions.
you asked him about why he didn't specify bribery by Mr. Ehlers of Dr. Michael. That was the question, and he was answering it, and you cut him off. Now you just changed. Instead, you asked him something different. Please just allow him to answer. Just be respectful enough to do that.
Well, I'm obviously in the president's hands.
Let's have an answer to that question. Put the question again and then let the witness answer it.
Yes. Why is it not in your witness statement, this suggestion that there was bribery as between Mr. Ehlers and Dr. Michael?
My understanding about death threats is what I've learned from the State Department while I was in Rwanda. And that is that people do not get murdered for revenge. They only get murdered to stop statements being made. So I've been very reluctant to suggest what I was going to say in advance of this hearing, because that puts a target on my back. If they know that I'm going to talk about what happened in the military, what our representations of the military were, how the military is handling the smuggling from Congo, and what that means for the determinations of the ministry, all those things are tied. And it's a constant reevaluation of where I see the most risk. Thank God I've gotten to this hearing, and I'm can't say that a bigger risk or not. But with regard to Anthony Ehlers and his bribing of Dr. Michael, if you look at the, I think it's in our document, and I hesitate because I'm not sure. Anthony Ehlers confided in me after we bought the company. I said, well, what am I going to do about Dr. Michael, because he's causing such problems and I can't pay him a bribe? And Ehlers said, well, I've been bribing him and it won't be any problem. And with that, I had to fire him, or at least begin the negotiation, criminal investigation, which was handled by Bill Quam, into all of his activities.
Mr. Marshall,
that's the reason it may not be in the original pleading.
Well, you do make allegations against Mr. Ehlers, which are in your witness statements, and they don't include that one. That's correct, isn't it?
I don't know.
And you also make serious allegations against Rwanda, including in your witness statements, including serious allegations of smuggling and mentions of stories about unnamed oligarchs. And you're not seriously suggesting that this further allegation about a bribe of Dr. Michael is the thing you had to keep quiet on because you were worried about some threat to your person. That's simply an invention, isn't it?
No, it's absolutely not an invention. But what they're doing, right now, the world believes that Rwanda's minerals are $800 million a year. And what I found out and was regularly reporting to the ministry, to the United States Embassy, they were my friends. And I was telling them not just once a week, but virtually every day, how we knew what we knew about the mining, smuggling of minerals from Congo, from conflict areas, bringing them to Rwanda and selling them to international investors under the pretense that they're conflict-free. They
Mr.
are
Marshall,
not.
the difficulty of all this is those points are in your witness statement and are in your claimant's memorial. So you weren't keeping those back, were you?
I'm sorry.
I suggest you all of your points there are invented by you too, but you were not holding those back, were you?
I expected a lot more interest in it than came, and that's fine. But do I know who was doing it? Do I know how the minerals come into the country, who sells them? Yes.
Let's move on.
Those are additional information.
Let's move on in half an hour.
Thank you.
Thank you. Could we have Mr. Marshall back, please?
No problem, Mr. President. I'm bringing the witness in right now.
Right now.
This is Mr. Harrison. If we could just wait 1 second, Mr. Cowley is still out of the room. He's coming right back.
Right.
I can see him coming in now. Thank you.
In the meantime, Mr. Hill, I should just mention the tribunal had said they were having a hard time seeing some of the documents. So I'm going to be zooming in a little bit more. Just give me any direction on that front that you see necessary.
One moment, Mr. President. We're having just a slight difficulty starting his camera. One moment.
All right.
Mr. Marshall, if you could do me a favor and just remove the external camera that's covering up your internal camera on the top of the screen.
Like that?
Yeah, you can just remove it. We were having an issue with the external, so we'll use the integrated camera. All right. Okay, Mr. President, we're good to go.
Thank you very much. Just before we resume, the team who are producing the transcripts have said they've been having a little trouble with people speaking too fast and sometimes more than one person speaking at the same time. So far as the form is concerned, I'm not sure that Mr. Marshall is the culprit. I think there may be a tendency to try to read rapidly through statements, putting the transcribers under pressure. So if
not intentional, with apologies.
yes, anyway, if you could do your best to speak one at a time, and Mr. Hill not to go too fast when you're going through statements.
Thank you, Mr. President. Mr. Marshall, could you be shown bundle C179? This one is certainly going to need to be zoomed out. This is an email.
FTI, can you bring it to the other screen like you were before?
Certainly, doing that right now.
That's microprint on that screen.
And it's not a great copy of the document either. This is an email exchange between you and Mr. Ehlers in February 2011. And I'm just going to pick up a couple of points from it where you are dealing with allegations that you're making against the former CFO, who's obviously not Mr. Ehlers. And you say, and your email's the second one on the page. Do you see you say, hi, Tony. As we agreed from these last emails, Julius and perhaps others have nearly bankrupted the company. Do you see that? And was it true that you regarded the company as nearly bankrupt in February 2011?
Well, it was certainly melodramatic language. We did have some extraordinary liabilities that I didn't know about, and I don't know whether the staff did.
And then
that was being melodramatic.
And then just a little lower down, I'm going to go 3 paragraphs down. You say, just sorry, pause there. Thank you. Second paragraph. I'm having Tom and Bill identify and so on. Again, that fairly reflected your view, didn't it? That reflected your view at the time. What you knew about the finances was bad.
Yeah, that's right.
Now, I asked you a question earlier this afternoon, and it's at page 99 of the transcript, at line 28, I think. I said, it's right to say NRD was in some financial trouble by the time you arrived, correct? And you said no. And he said, not that I know of. This is all entirely new information. But NRD was in financial trouble when
No,
you
I-
arrived, as we can see from these documents?
Yeah, I think I've been consistent throughout. I think we had an interchange yesterday when I was identifying some of the unexpected liabilities.
But in answer to my question earlier, I suggested to you NRD was in some financial trouble by the time you arrived. You said no, and you're now accepting that it was, correct?
As I say, this language about nearing bankruptcy is being melodramatic. We had sufficient resources to keep the company going until it was able to keep itself going. But what was surprising, as I said yesterday, were these handful of undisclosed liabilities.
Now, in this email, we can see from the first paragraph, I'm not going to trouble you with the detail, but you are making a series of allegations about Julius and perhaps others bankrupting the company, and allegations against the former CFO. Yes? Julius.
Yes,
You recall
Julius was the CFO at that time, and we discovered that he wasn't really keeping books in a satisfactory manner. So we fired him, and we fired his deputy because they were not accurately reflecting the status of the company.
And if we scroll up on the page, FTI, please. So we go back to the top. We can see Mr. Ayler's response. He says, "I'm shaken to the core and I feel awful about this. I will hang in there as long as you feel you need me. I will not run. I must carry full responsibility for this. I was misled by the CFO and there is no excuse for that. I will return on the 28th as you suggest." So Mr. Ehlers, as CEO or MD, was standing by and ready to bear ultimate responsibility for being misled by the CFO in light of the information you were giving him. Yes?
No, he was not managing director at that time. He had been replaced by me. We didn't know what his job would be.
But he is ready to stand by because as far as he's concerned, he was in charge and this has happened on his watch. Yes?
That's right.
Can we just look at the reply document at paragraph 266? This is your reply memorial. You say in your reply memorial, paragraph 266, this is in relation to your allegations against Mr. Ehlers. He accepted responsibility for nearly bankrupting the company in the time period surrounding the sale to the claimants arising out of bad business deals and crooked employees. Now, that is a very unfair characterization, isn't it, of Mr. Ehlers' honourable email saying to you that given that the misleading by the CFO happened on his watch, he would bear ultimate responsibility and stand by it and help out. Correct?
No, well, it depends on the timing. We had started a criminal investigation of Ehlers. We had the police in. The reason that I delayed his coming back, ordinarily, with the start of the new year, he would have come back the 1st of January, 2nd of January. But we delayed him because there was this ongoing investigation. I didn't want to prejudice it by being unfair to Ehlers. I waited for the criminal report to come out, the internal report, and then the criminal report that was filed with the police. I had instructed him. He was, as you say, he said, I will come on the 28th as you suggest. And then I called him up and I said, please don't come back at all.
Now, that's quite a long answer, and it wasn't an answer to my question. I really will. We must try and make progress. My question was about this paragraph in the reply, and I'm suggesting to you that this was a unfair characterization of Mr. Ehlers' email, where he accepts responsibility in the sense of saying, I was in charge at the time and I was misled and I'm happy to come back, stand by and help out. It's very unfair to characterize it in the way you have in this reply, isn't it?
Very unfair for me to say he accepted responsibility surrounding the sale.
Yes. Yes.
I'm not understanding the question. Because he accepted responsibility, why is it unfair for me to say he accepted responsibility?
Well, we can see it for ourselves. Let's move on to this. Stay in the reply. Paragraph 264 of this reply document contains another of other allegations against Mr. Ehlers. And in particular, at the top of the page 106, you say, relatedly, he mistreated female employees by harassing, assaulting, and punching them. Do you see that?
Yes.
And you give a footnoted reference for that. And that footnoted reference is to an incident where there was indeed an altercation between Mr. Ehlers and a male member of staff, correct?
I don't know what the reference document is.
Well, it's to a reference from to a statement of Mr. Umpongo, and it is he was a male member of staff.
I do recall that one. Yes, he is male.
And the supporting material you have for your allegation that Mr. Ehlers mistreated female employees is one altercation with one male member of staff, correct?
I think all are true. I think that he did do that. If we didn't provide the criminal report, we should have provided the criminal report.
This is a serious allegation of mistreating female employees for which
Yes.
you had no basis whatsoever, and you should have withdrawn, shouldn't you?
No, it is in the criminal report. He was running a bordel at a Deutsche Welle house, and he was abusing women and preying on people. It was terrible, terrible situation.
Mr. Marshall, I'm not accepting any of that. But that is also not the allegation you're making in this reply, which is dealing with mistreating female employees by harassing, assaulting, and punching them, which is simply untrue and something for which you have no basis at all.
It is true. We have a basis for saying it's in the criminal report. I don't know why the criminal report's not attached as exhibit.
It's because it doesn't exist, Mr. Marshall.
It's not true.
And at paragraph 260 of the reply, you make the allegation that NRD fired Mr. Ehlers for a number of serious criminal acts, but Mr. Ehlers has never in fact been spoken to by police, and no criminal charges of any kind have ever been pressed, correct?
I wouldn't know that. I know that we filed a criminal complaint. We had a number of meetings with the criminal police where we gave, and staff member also gave testimony. The allegations, as far as we could determine, were all true.
You also refer at paragraph 261 to Mr. Ehlers stealing company equipment, but the true position, as he explains, is that this was equipment which was retained by him after he left the company. He was owed money by the company, and he indicated to you he would hold on to the equipment until he was paid his outstanding money, correct?
No, it's entire fabrication.
And what we actually see in this part of your reply document is another example of you blackening the names of people who you fallen out with exaggerated allegations, correct?
No.
Now, I'm going to go back now to the question of the investment in the concessions. Can you go to bundle C015? Go to page, this is the government's mining policy in January 2010. You would have been familiar with that, wouldn't you, given both your investment in NRD and Bayview's investment in Bisisera?
I don't recognize it.
Well, in that case, I might try and take it quite quickly. Paragraph, page 31, can you go to? you will see this is under a section at the top of the page, ensure that the existing 4-year prospection and extraction permits produce detailed resource statements. So one of the points being made by the government is that the existing 4-year prospection and extraction permits needed to end up with detailed resource statements. And you know what's meant by detailed resource statements, yes?
This is not a document that anybody in the ministry had the competence to prepare at that time. I believe this is to be a fabricated document.
So just to make sure I understand, you're suggesting the government of Rwanda's mining policy in January 2010 is a fabricated document. Is that right?
It certainly was not available in 2010. When it was prepared, I don't know. This is not a document, certainly, that they gave any distribution to. And I doubt that they had the competency to write it at that time, even through contractors.
And let's just look a little bit lower down in this paragraph. It says, given, this is the bottom 4 lines, given that many of these 4-year licenses are coming up for renewal in 2010, there is a need to ensure that the owners of the licenses are making every effort to undertake effective exploration with a view to developing these industrial mining opportunities, resource and ultimately reserve statements. To do this, 3 actions are required. And then can we go down? First of them is establish clear criteria for the evaluation of the exploration efforts of holders of mine concessions. And underneath that, it says without, second sentence, well, first it says provision of validated resource statement with effective quality assurance and quality control signed by a member of an international recognized professional body. Without such proof of effective exploration, 30-year licenses will not be granted. And without proof of the ongoing development of such resource statements, companies will not be given extensions to their 4-year licenses. And the government's policy, as you knew at the time, was that within the 4-year period, companies needed to have proved that they had done serious exploration and proper resource evaluation, correct?
This document is I think, prepared for this proceeding. I've never seen it before. I can't imagine that anybody had the capacity at that time to be able to write this document. And there was no consultant that I was aware of that had been brought in to put such a document together. With regard to whether we had done enough research or not, we were repeatedly informed that we had.
Will you,
Mr. President, may I ask, the representation has now been made in repeated questions that this is the policy, and it's been described as issued by the ministry. The document we produced on the I think first number page after the index. What page number?
Page 3 of the document.
Page 3 of the document. The one we produced is titled a green paper. So something in the works, something being worked on as we produced it. If council actually has an issued public policy of the government of Rwanda, I would suggest he use such document if he's going to be referring to those policies, and stop informing this witness in his questions that this document is something other than what we produced.
well, as far as I'm concerned, looking back at the transcript, my questions have been put on an entirely fair basis. I would submit that's not an appropriate intervention at all, and I would just like to proceed with my cross-examination.
Yes, please proceed, Mr. Hill.
Mr. Marshall, you knew at the time, didn't you, that without proof of effective exploration, long-term licenses would not be granted? Yes?
No, as I say, this document, I don't believe it was prepared at that time. I don't believe it existed for many years afterwards, because they didn't have the staff to be able to articulate these things, if indeed that had been their policy. I was told, and we were always told, that the work we had done was superior to the other applications. We saw the other applications, and we were the only company who did not get a long-term concession.
And just taking that up, we already know, don't we, from the document we saw, but NRD was in fact told in October 2010 that the work that it had done constituted little investment, and it had been asked to give some concessions back. You recall that? That's what the NRD was then actually told. Yes?
No, NRD had not been told that, and that was reflected in my response. NRD prepared the application. In March, we were called up by the Licensing and Supervision Board. We began negotiating the language of the long-term concession. Dr. Michael and Evode's decision-making was only peripheral to the real decision-making going on in Rwanda, in my opinion.
Well, we saw the October 2010 letter with NRD being invited to give concessions back, didn't we? Yes, you remember we looked at that earlier. This is before anything that happened in 2011 that you just referred to. Yes?
Yes.
And we also know when we get to August 2011 that your license application in November 2010 is refused in part because there's no proper feasibility study, correct?
No.
And so the suggestion that you were continually told. Sorry, I was going to. You speak, please.
I disagree with the characterization, and with regard to the ministry's decision making, it could turn on a dime. So, in the one hand, we've already being told that the long-term concession agreement has been prepared and approved by Dr. Michael and it was then Minister Kamanzi and been forwarded to the ministry cabinet for approval. I don't know what the political dynamics are, but you often get odd sort of requests or observations or something less than a policy statement, which is not intended for its purpose.
Mr. Marshall, we're going to be looking at the government's letters to you and their own internal deliberations, and we can see that far from turning on a pin, they are entirely consistent. The only thing that's inconsistent is your version of events where you suggest there was some other stream of dialogue. That's correct, isn't it?
No, I would say it's creative writing and an attempt to link together disassociated decision-making.
And you knew when you came in that the license application submitted in November 2010 fell a long way short of amounting to the kind of proof of effective exploration that the government would require, didn't you?
No, and they wouldn't have submitted our long-term application and draft contract to the cabinet if that had been the case. I understand that that was Dr. Michael's animus, but that is not what was happening.
No. Let's go now to your reply memorial again at paragraph 62. Now, this says on November 29th, 2010, NRD submitted an application for a long-term license. Pausing there, that's not correct, is it?
Yes, it is correct.
Yes.
We submitted an application for a long-term concessions on all five.
Let's look at paragraph 63. The application also contained an environmental impact assessment report prepared by Dr. Fabian Twagaramungu, which included an environmental management plan. And there's a reference to the document at C036, that's at footnote 119. And I'm going to ask FTI, we're going to go back to the reply in a moment. Can we just look at that document? So C036. So that is what's called a rapid environmental impact assessment of Nyota Bindi mining site. And Nyota Bindi mine is one part of the Sabaya concession area, isn't it?
Yes.
So this is one environmental impact assessment for one part of Sabaya.
I'd say that. I think it's Gachia, not Sabaya.
Well, it doesn't matter. I'm not sure you're right, but it doesn't matter for the purposes of any of this.
Okay.
Then there was also, we accept, an environmental impact assessment for the Ritsero plant. Do you recall that?
Yes.
there were no other environmental impact assessments for any other of the other sites, were there?
No, and there wouldn't have been.
Why do you say there wouldn't have been?
Well, the way the Department of Environmental Management works is they do it after you've gotten the long-term concession. We did this as a matter of accommodation because we wanted to show two particular problem areas. Otherwise, you would be doing an impact assessment for the whole concession. And if you only received half of the concession, then it would be wasted effort from the department's perspective. That was their policy and is their policy. But you should ask directly to Zuzana Marushkevichova because she was the interface with the Department of Environmental Management.
But although you say, can we just go back to the reply then? So just to be clear, when you say paragraph 63, the application also contained an environmental impact assessment report, you accept that the only environmental assessment reports done were for Route Zero and for
Sabea River catchment, yes.
and for Nyota-Bindi.
Yeah, Sabea River catchment. Those were the two places we were being specifically asked to do.
And coming back to your reply, paragraph 65, can we look at the first sentence? The reply says the sufficiency of the application pursuant to the contract is confirmed by numerous letters and communications between claimants and respondent. Now, there's only one set of correspondence referred to in support of this allegation, and that is at C156, which is referred to in the footnote to this paragraph. So can I go to C156? This is an email string from January 2011, so shortly after you took over NRD, and when the November 2010 license application was pending. If we look at the email at the bottom of the page from Professor, thank you, Rapaya, he says, "Dear all, be informed that this morning I met Mr. Bidega Dominique, Acting Director in OGMR, in order to get information about NRD renewal application. He said it was still in examination because OGMR is very busy starting with CTC implementation. OGMR has to meet RDB next week, and he hopes a response will be given at the end of January." So all he's doing at this point is telling you that the license application was under consideration. Yes?
Sounds like it. I don't remember this.
So if we go back to the reply.
I don't know. Obviously, I don't know what Professor Nkanika and Dominic's relationship was, so I can't comment on it.
You haven't identified any documents that support the proposition in the first sentence of paragraph 65 that the sufficiency of the application pursuant to the contract is confirmed by numerous letters and communications between claimant and respondent. And the reality is that there are no letters or communications that confirm the sufficiency of your application. Are there?
I don't know what documents this may be referring to, but obviously if they began the negotiation for the language of the long-term concession, that's sufficiency in itself.
Well,
I think
you're referring, aren't you, to some exchanges between you and Mr. Bidega in late 2011, correct?
No, it began in 2000, I want to say March 2011, but it may have been late March, early April 2011.
Well, I'm going to come. Sorry, I mean, I'm talking across. You finish.
That's when the negotiations began, and they went on for several months.
Well, I'm going to come to your discussions with Mr. Bidega, so don't worry about that. Now, as you are aware, NRD's November 2010 license application was refused in August 2011. Yes?
No, it was not, because the negotiations continued for the language of the long-term license.
Well, you've seen now, I'll come back to that point. You've now seen the documents in this case, and you accept now that there was an internal review of NRD's application by Dr. Biriabarema before Mr. Kamanzi notified you in August that your license application hadn't been accepted. Yes?
I don't accept it. I think that's the new document Dr. Barema created. And we've never seen it. It was never articulated, never communicated to us. The other documentation, if you give us back our documents from our offices, I'm sure there's additional details about it. But I'm 100% sure that if Dr. Mike, he goes by, if he had actually done any research, according to Professor Nkanika, he didn't do that. He didn't even read the document until 2012. So I'm sure that Professor Nkanika, at least on that point, is correct.
Let's look at Dr. Biriabarema's first witness statement. Now, he was the director of, he was a geologist, yes, and a director of the Rwanda Geology and Mines Authority, yes?
Yes.
You recall that? Let's go to his witness statement at paragraph 10.
Can you say the name one more time?
Yes, Biriabarema.
You have to, Dr. Mike.
Yes, thank you.
Yes. And you start with paragraph 10. He's dealing there with his assessment of the NRD license application. And he says these obligations included investing appropriately, and he's referring to the Article 2 obligations, carrying out sufficiently detailed exploratory activity and submitting a satisfactory study assessing the feasibility of mining in the areas over a 30-year period. We would not be prepared to grant long-term concession areas to operators who had not demonstrated their professionalism and ability to develop the concessions into high-performing industrial mining operations. This was the reason we had only awarded relatively short 4-year contracts back in around 2006 to operators like NRD. We needed them to prove their credentials, including by way of a proper evaluation of the mineral resources before we could proceed to granting them long-term concessions. The grant of long-term concessions was therefore in no way automatic, but was wholly dependent on their performance during the 4-year term and ability to satisfy us of their potential to run professional and productive industrialized sites over the long term. Now, that in fact reflected what you understood when you arrived at NRD, because that's effectively what Payless had told you.
Absolutely not. I think he made this up in preparation for this this arbitration. Dr. Michael would not have written this at this time.
Let's go on, paragraph 11. In the end, although NRD built the proposed plant in Rutsiro, it was a failure. They had not carried out sufficient exploratory work prior to investing in the plant, and the mineral resources in the surrounding area which they were intended to process had not been sufficiently evaluated. In short, my experience of NRD was that they had failed to meet our expectations. Although Stark had made some investment, it was mainly focused on the failed Rutsiro plant, and by the end of 2010, they had invested only a small amount of what had been proposed in 2006. NRD had also failed to industrialize the concessions as required by the contract, which instead remained based on artisanal mining. Further, they had not carried out what I would consider to be sufficient exploratory activities, which was also a requirement of the contract. It was therefore clear at the time they applied for new 5-year licenses at the end of 2010 that they had not met the requirements of, sorry, if FTI could scroll up, not met the requirements of the contract. Further, the document claimed by NRD to be a feasibility study fell far short of what was required of a feasibility study. On this basis, on the basis of this application, we could not possibly have granted even the short-term 5-year mining licenses requested, let alone any long-term concessions. And that review from the government reflected exactly what Mr. Ehlers and Professor Rapaya thought at the time when they prepared the application and what they had told you.
To use your word, this is entirely fanciful document.
Well, this is his witness statement, and he actually has a report.
I
Which we have
understand.
at bundle R111.
this was not their procedure. It was not the conditions they required of us. And it was not the economic deal we made with it.
No, this is a report done by Dr. Biri Arborema in respect of the NRD's, in terms of NRD's application.
Dated one, please.
I'll come back to you on that. So he's dealing with NRD's November 2010 application. If we look at the second paragraph, he says the nature of the agreement was, and he explains that those obligations under the contract, and we've looked at those already in the contract. Yes. Progress report, evaluation reports, and feasibility studies. Yes.
I'm sorry, as I understand, what you're saying is that this is Dr. Michael's report from 2010.
Absolutely. Yes. This is his review of the 2010 application.
No, it's not.
No, he confirmed in his witness statement that's what this is.
I think
And in the third paragraph, what he says is the current report describes the initial figure of 39.359 by the first management as seriously flawed and inappropriate. Total of about 14 million US is reported to have been invested up to December 2010.
Dr. Michael didn't even read our application until 2012.
And then if you go over the page, second page,
This is a creative writing exercise in my mind. I'm sorry.
Dr. Michael has his comment on the extent of the works done. So he says below are comments which provide an evaluation of the extent of the work done as measured against the expected work of the mineral resource evaluation, which was to be the basis of long-term contract negotiations. And there he says, satellite and ground penetrating radar were intended, indeed are capable of indicating surface and near surface features, which should be targets for detailed exploration. As presented in the report, these methods were intended to enhance certain exploration targets to help plan an exploration program. And then he says, evaluation of 5 scree deposits by processing 130 samples, 100 kg each. Although the sampling seems not to have been detailed enough, the results help take a decision to construct a 20 ton per hour gravity concentration plant. And then he says, detailed calculation of primary wolfram deposits in Rwanda is very highly theoretical and is not practical at all to provide any basis of objective planning. The same applies to estimation of Nemba Tim deposits. And then down to 4, please, FTI. Sampling in Rutsiro, Gike, and Sabea to identify specific exploration targets for tantalum and tin in these areas was carried out in 2008 and 2009. A total of 115 samples were collected and analysed. The study shows important areas of significant tantalum anomalies. These were supposed to be followed by more detailed exploration, which has not yet been done. The current results can only be taken to be qualitative. Most of the geological work involved acquisition of historical data and understanding the regional geology and metallurgy, remote sensing to identify exploration target areas, regional sampling to map target areas for more detailed exploration, and very preliminary theoretical calculations of resources in some locations. So the conclusion in all these respects by Dr. Michael is that there has been some exploration work, but it is superficial and not sufficient. Yes?
No, I maintain that he wrote this as part of the preparation for this hearing.
And if
It's
you
a fraudulent document.
If you go now to page 3, he says in the top paragraph, we can see the conclusion. Although some preliminary exploration work was done, it fell far short of the target in the agreement. This is very crucial in light of the large area given to the company because of its expressed financial and technical capability. and then what the company is applying for, a continuation of mining and exploration works in the 5 concessions, Mara to be converted into a mining license, and then so on. And then he goes on to the significant features of a new business plan. And that conclusion at the top of the page, falling far short of a target in the agreement, is exactly as NRD had predicted when they made the application and as you were told, correct?
No, you're mischaracterizing.
And it meant that NRD hadn't met the requirements under the contract in respect of reporting reserves and a feasibility study, had it?
No, and this document's a fraud. Dr. Michael didn't read our even application until 2012, according to his own staff. I don't believe any of this, and I've never seen it before.
But you accept, don't you? I'll come back to what you say about this document. You accept, don't you, that NRD, that the criticisms are accurate ones, and
No.
NRD hadn't met the requirements under the contract in respect of reporting reserves and exploration and feasibility study?
No, in fact, it was never even communicated to us, except in Dr. Michael's anger to make these very general statements, not supported by his staff.
And NRD certainly had not produced a feasibility study that was capable of being positively evaluated so as to justify a long-term contract, correct?
No. We had provided all the documentation that they required, and we were told it repeatedly.
Now, can we go further down this page? Mr. Reporting there, Dr. Biriyama gives significant features of a new business plan. It includes a 50-ton-hour processing plant at Nemba, exploration techniques of geophysical surveys, large-scale trenching, diamond drilling, geological and geochemical mapping, etc., are planned in most of the areas, with a planned exploration budget of 382,000 euros. The value is meagre. And it's fair to say that the exploration budget planned in the November 2010 application was a meagre exploration budget, wasn't it?
That was a number given to us by the ministry. That was not our number.
No, that's not true, is it?
Yes,
That is the number that was put in when I fully accept it wasn't your application because it was before you came, but it was a number that was put in by NRD and what they were allocating to exploration, correct?
You're misunderstanding the process. When NRD, when every concession holder is preparing the documents, there is a lot of consultation back and forth between the company and the ministry. And between them, they come up with information, technical information that is acceptable to both sides.
That is just not true, and you weren't even there when the application was put in.
All the application process is the same. It's a very negotiated process. And it was the same process when I was negotiating with Dominic Bodega and his staff for the language of long-term concession. They supplied the information, the technical information to be included in that contract.
We have witnesses who were involved in this application, and they don't suggest that this happened, unlike you.
I dispute your witnesses.
Can we go to bundle C062? Before FTI leave that document, there's one more question on that last document. Don't worry, I don't want to take time on it now. Let's go on to C062. This was the letter from Minister Kamanzi of 2nd of August 2011. And in this letter, he informed you that the government didn't regard you, NRD, as having fulfilled your obligations under the contract, and in particular, Article 2, correct?
No.
Well, look at the second paragraph. Contract signed between the government of Rwanda and your company on 24th November 2006.
I understand that Dr. Kamanzi or Mr. Kamanzi had an animus as well, but we were being told by the licensing and supervision department that yes, we had in fact fulfilled those requirements. We got this letter, I understand it, but that was not the position of his staff.
He's the minister and he is communicating to you the outcome, and he's explaining to you that the contract has been regarded as, well, he says not fully executed. Explaining what he means is not fulfilled, particularly as regards Article 2, that's the obligation to provide final report of reserves and mining feasibility studies. Yes?
I see the language you're reading, but the way that would have been interpreted and is interpreted is the feasibility study is being performed for the company to determine whether it should continue in its investment, not to provide a valuable tool for the government to give to somebody else at a later date. This is an exercise that companies go through to determine whether they're going to go ahead. To say that Article 2 is somehow not fully executed, we didn't know what that meant at that time. Certainly at that time, we would have gone to talk to the staff and they would have said, yes, you've performed better than anybody else in this regard.
Mr. Marshall, you were being told that one of the conditions of the contract, one of the obligations under the contract in Article 2 had not been fulfilled, and you were fully aware of that. Yes?
No.
And
I dispute the meaning of this language. That's all I'm saying.
And as I understood one of your earlier answers, you thought something different because of something that someone on the staff was saying. Is that what you're saying?
No, I'm saying that it's an iterative process. You know, it's not Rwanda has its own internal weaknesses. They're desperately trying to do professional things. That being said, none of these things can happen in the extract. You're trying to say, if I could, you may contradict me, but you're trying to tie together sentences in documents that you have in your possession. We don't have all our documents. You're not providing us with all the ministry documents. That being said, things are not like what happens in that letter. The way Rwanda and many African countries work is you sit down with people and you say, what do you want to do? How is this going to work? Where do you want this? What's the emphasis? What are you trying to achieve? And you work out that process.
Let's look at what he does say in the letter. So after dealing with you not complying with Article 2, he goes on and he says, we notice you applied for 5-year licenses for small mines within each of the 5 concessions. The new status of concessions will have to be decided based on the work executed in the light of the contract signed and on the provisions of a new mining law. We extend the operation of your license for 6 months from the day of the receipt of this letter to allow us time to determine the future of these concessions. And you understood by this letter 2 things, didn't you? First, that the government considered that NRD had not met its obligations under the 4-year contract, correct?
No, I disagree that that's the meaning of this letter.
Secondly,
the words say, but that's not what we're being told by the ministry.
Secondly, you understood that the government was granting a temporary 6-month license while it considered what would happen to the concessions. Yes?
Yeah, I see the language.
Let's now look at what you say at paragraph 20 of your second supplemental witness statement.
But okay.
So this is your second supplemental witness statement.
Notice on this letter is August 11th, by the way. This is during the time we're negotiating the actual language of the long-term concession, not to be seen in the abstract.
Well, just to be clear, I don't accept what you just said, and we will look at your discussions of what you describe as these negotiations, and we'll come to that. Paragraph 20 of the second supplemental statement from you. You say there, Minister Kamanzi sent a letter to NRD on August-September 2011 purporting to terminate NRD's licenses. Claimants did not accept Minister Kamanzi's letter at face value for 3 main reasons. And then you give 3 reasons. And you say here, purporting the letter, as you understood it, purporting to terminate NRD's licenses. Now that's slightly loose language, isn't it, Mr. Marshall? Because the actual licenses by that point had expired earlier in the year. And what he's in fact doing is giving an extension to the licenses, but he's recognizing that the obligations in the contract are unfulfilled and there's no further obligations under the contract, correct?
No, I would say that the agreement was executory. We had fully performed, and now we were waiting for their performance.
So I'm just trying to understand what you meant in your witness statement when you said purporting to terminate NRD's licenses. And what I'm suggesting is what you mean by that is not the licenses, but what you mean is he was recognizing that you hadn't fulfilled your obligations under the contract.
I disagree with that characterization.
And what did you mean? It's your witness statement.
Can you go back up a little, because I can't read the language anymore.
Mr. Kamanzi sent a letter to NRD purporting to terminate NRD's licenses.
Yeah, I don't know if that's referring to the letter that you and I were just looking at.
Yes, it is. It's the only letter from the 2nd of August, and it's from Mr. Kamanzi.
Do you know that?
Yes, that's
Have
the
you
only
looked at the
letter.
logbooks?
You're suggesting this is a reference to a different letter.
It could be. I'm asking you whether you've looked at the logbooks to determine whether there was only
No,
one
Mr.
letter.
Marshall, this is your witness statement, which derives from the.
And I don't know which letter it's referring to. That's why I'm asking you if you know whether there's another letter dated
Well,
August.
it's your witness statement. Are you suggesting you were not referring to the letter we've just been looking at?
That's
Because
why
if so, you haven't produced it in the evidence in these proceedings.
I understand, but I'm asking you whether we're talking about the letter we just saw, and then I would answer it in that context.
That's the only letter that's been made available by either side. It's the only letter that anyone's ever been talking about from Minister Kamanzi. Okay, so we are not talking about the same letter. What did you mean when you said purporting to terminate NRD's license?
Yeah, I would say that that's inartfully worded, and I'm not sure what it means.
And what you meant was your understanding that he was treating, the government recognized that the obligations in the contract were at an end because you hadn't fulfilled your obligations under Article 2.
No, I would say that he may have been alluding to an argument that he was going to be making in the future about that being the case, but that was not, in fact, the truth.
Now, you then say claimants did not accept Minister Kamanzi's letter at face value for 3 main reasons. And what you say is at the time of the letter, a long-term license had already been submitted to the Cabinet for approval. Dominique Bedega told claimants to ignore Minister Kamanzi's letter. And after the letter, Minister Kamanzi approved the negotiated form of the long-term agreement as signed by NRD.
Yes.
And together with the Prime Minister, forwarded the final signed version of NRD's license to the Cabinet for final approval. Now,
that would be a typical sort of circumstance where something is written in the letter and then it's reversed in this case in a very short time.
Well, we'll come back to those 3 reasons, but just the starting point is you're suggesting these were the reasons why the claimants did not accept Minister Kamanzi's letter at face value. But you do accept, don't you, that from the government's perspective, they were treating the obligations under the contract as being at an end. And you're explaining reasons why you didn't take that at face value.
No, I'm sorry, maybe I'm misunderstanding your question. Despite the letter, we were having negotiations and had complete from I see the timing of this, we had completed negotiations on the language of the long-term contract. And that had been submitted, and as I was told, had been submitted to the Cabinet. So was this a negotiating position? That's the way I understood it.
Mr. Marshall, none of that is true. But what is true is you recognized at the time that the government was regarding the obligations under the contract as at an end following your inability to fulfill them. Yes?
Definitely not.
And you also knew.
Absolutely. Not just definitely, but absolutely not.
You also knew that the 6-month license extension that the government did give was something that was voluntary and something they didn't need to give. Yes?
No, actually, those extensions had political purpose that we don't know about. My guess is that Kimanzi was being told he was not performing well. And so, and his way of being able to solve this was to send around letters, not just to us, but to others saying, you have a 6-month extension. Not everybody had gone through the process of negotiating the terms of the long-term agreement and had submitted to cabinet. So for us, it was a negotiating position.
Mr. Marshall, there's no need to reach for a conspiracy theory because it's obvious on the face of a letter what's happening, which is that the Minister Kimanzi has recognizes that the obligations in the contract are at an end as far as the government is concerned, but he's prepared to give you 6 months to see what can be negotiated for the future. Yes?
No.
That's what he's saying. And you understood that NRD had no continuing rights from that point at any kind with regard to a long-term license.
It was an executory contract. It had already been fully performed from our side. And the only performance we needed from their side was to approve the long-term agreement, which had already been negotiated.
You understood at this point that NRD had no continuing rights of any kind because he reached the end of the 4-year term and not complied with the obligations under Article 2. Yes?
You're ignoring the fact that our long-term contract is in front of the cabinet.
Well, I'm going to come to your 3 reasons why you say you didn't take this letter at face value. And if we go to paragraph 50, first, can we just go to paragraph 53 of the claimant's memorial that deals with this letter? I'm going to, just for FTI, I'm going to come back to that part of the Mr. Marshall's witness statement in a moment. But first, we're going to look at paragraph 53 of the memorial. That's the wrong reference. I'm so sorry. Just give me one moment. I'm so sorry. Oh, no, I think the FTI may have brought up the wrong document.
Yeah, I think I'm sorry. I think that was the reply memorial.
Thank you. The claimant's sort of opening memorial.
Thank you.
Yes. So paragraph 53, you say the 6-month extensions, this is the same letter from Mr. Kimanzi, was the first of many extensions of the contract, throughout which representatives of Rwanda continually represented to Mr. Marshall that long-term contracts were forthcoming and guaranteed. Now, we've just looked at the 6-month extension, and it's not doing that at all, is it? It's saying the opposite. It's saying you haven't complied with the agreement, but we're giving you 6 months to see what can be discussed.
Well,
correct?
You're very elegantly focusing on the words in this document, which is only one of the sources of communication. And it's not true that we were repeatedly assured, please be patient, don't do anything precipitous, through all our advisors. U.S. government staff were there. Every ministry we went to, it was always the same line. And you're stringing together threads of sentences to say that it was something else, and it's not true.
Quite clear that this 6-month extension was not an extension throughout which representatives of Rwanda were representing that long-term licenses were forthcoming and guaranteed. It was the very opposite, correct?
Not correct.
Let's go now to your, let's just look at paragraph 32 of your witness statement.
First witness statement?
Yes, please. You say there, instead of, this is your witness statement, instead of immediately granting claimants the long-term contracts, Rwanda granted them a series of extensions with the repeated representations that the long-term contracts would follow. The first one was granted in August 2011 for 6 months. Again, no representations were made at all that long-term contracts would follow, were they?
I was nearly daily be given the representation that long-term contracts would follow.
Let's look at the penultimate sentence in this paragraph. Nevertheless, the express purpose of the extension was to negotiate the long-term contracts. Simply untrue, isn't it? It wasn't the express purpose of the extension because you had been told that the obligations under the contract hadn't been fulfilled.
I'm sorry.
Your witness statement, nevertheless, the express purpose of the extension was to negotiate the long term.
Isn't that the language of the last sentence of that letter?
It's your witness statement.
I understand, but isn't it a reference to the last sentence of the letter that 6-month extension would be suitable in order to reach an agreeable result, or I forget what word they used.
It's to
Am I
see.
misremembering?
Happy to pull it up if you like. It's C050. C062.
We had several of these letters where we were told that this should be enough time to reach a favorable response, or allowing us time to
We
determine.
notice you applied for 5-year licenses for small mines within each of the 5 concessions. The new status of the concessions will have to be decided based on the work executed in light of the contract signed and on the provisions of the new mining law. We extend the operation of your license for 6 months from the day of the receipt of this letter to allow us to determine the future of these concessions. You didn't see that for a moment, did you, as conveying an assurance of a long-term license?
I, in the context of the work that we were doing and the people we were communicating with, I absolutely did.
Well, of course you
There
didn't.
was nothing
Mr.
was
Marshall.
detracted from it.
He's making clear a number of things in this letter. He's making clear, 1, you haven't complied with the contract. You haven't met the obligations under Article 2. 2, that you've only applied for 5-year licenses. And then he's saying he's giving you 6 months to decide what's going to happen. You couldn't possibly have read that as an assurance in respect of a long-term license, did you?
Well, I understand, but you'll appreciate that right now, our long-term license for 30 years was in front of the cabinet.
Well, it wasn't, and that's simply not true.
It simply is true. I don't know why you keep refuting it. We were told it. We went through the application process. We reached agreement on the language. It was approved by Dr. Michael and Dr. Kaman and Mr. Kamanzi, and it was referred to the cabinet for approval.
And you're saying that had happened by August 2011, are you?
I think that's what it says.
Well, this is all simply untrue. We'll come to these 3 of your reasons from paragraph.
I don't know if it was August 2011, but it was certainly under negotiation. I thought there was a reference in the witness statement which gave a date, but I don't recall what date.
Well, let's go back to that. Let's go back to that witness statement. It was paragraph 21 of your supplemental witness statement.
Sure, I do remember quite clearly, certainly by the end of the year, November, for example, that it had been submitted to the cabinet.
Well, we're looking at a letter in August, and you're trying to explain that. Sorry, it's paragraph 21 of your
The second supplemental?
it must be. Yes, paragraph 21 of a second supplemental.
I think you'll appreciate the quote you've brought up. Nobody would invest in it if it wasn't guaranteed. It's like, it would be like buying a lottery ticket from people you don't know.
And sorry, if FTI could look at, don't blow it up for the moment, FTI. So this was your second supplemental. You were giving the, do you see it? Sorry, can we put 20 and 21 up at the same time? You remember, this is where you said how you didn't accept Minister Kamanzi's letter at face value for 3 reasons.
No, that's a mistake. It would not have been submitted as of August 2nd.
Well, you say it's a mistake, but you've actually given a number of answers today where you have said and repeated your suggestion that a letter had been submitted to Cabinet by this time. And you're not now maintaining that.
Yeah, no, my memory is, and I, don't have any of my files here, so I can't go back and check. We began negotiating with the licensing and supervision department, I want to say March or April. And by November, we had reached agreement on all the languages of both the BVG long-term license and the NRD long-term license.
But this mistake, which you now say is a mistake,
Well, this
something that was in your witness statement, and it's something that you've repeated today. And it's only now when I've been pressing you with it, because I'm obviously about to go to the detail, that you are accepting, but you're not now saying that there is some letter submitted to Cabinet by August 2011.
Yeah, no, I don't think it was August 2011. That's what my point. My memory is that it was the end of the year. October, maybe November, or something like that, by the time we had finished negotiating all the provisions.
So we can strike out item 1 on your list, can you, of the list of why you didn't accept this letter at face value?
No, I think it should reflect that we were negotiating the letter, not that it had already been submitted.
And even that's not true, is it?
I don't know why you just, I'm sorry. Yes, it is true.
Now, the allegations that you make in this paragraph about negotiating a draft of Dominic Bodega, which gets submitted, approved by the minister and submitted to Cabinet, is also something you've said in your reply memorial at paragraph 65, where you say that, let's just look at it to make sure I've understood the allegation correctly. Let's look at paragraph 65 of the reply. Your allegation, as I understand it, is that Mr. Bodega approved licenses and they were submitted to Cabinet, and that involved a meeting with Minister Kamanzi with the Prime Minister to recommend the draft so that it's final. And then if we go on to paragraph 70, again, Bodega providing NRD with a long-term license. Then you say, lower down that paragraph, Bodega submitted the agreement to his boss, Birial Barema, who approved it, sent it to the minister, and then going off to Cabinet.
Yes.
So there's 3 parts of your allegation here. First, that Bodega provided NRD with a draft long-term license. Secondly, it was subsequently negotiated and approved by Dr. Birial Barema, who in turn submitted it to the minister. Thirdly, this agreement was submitted to Cabinet. And none of those things are true, are they?
As far as I know, they're all true.
Can we go to paragraph 10 of Dr. Birial Barema's supplemental witness statement?
Dominic is the head of a committee which reviews and approves these applications. Once he's approved it, reviewed it and approved it, it goes to Dr. Barema, Dr. Mike, and then it's brought with presumably a positive opinion, and Kamanzi then adds his opinion, which, because it was sent to Cabinet, would also have been positive.
The role that you've just suggested Mr. Bodega has, that's also not true, correct?
As far as I know.
He did not have that role in the ministry, did he?
You're telling me something that I don't know.
Let's look at
what I've explained to you is the role that I understand him to have.
Let's look at paragraph 10 of Dr. Biriyama's supplemental statement. At paragraph 4 of his statement, Mr. Bodega claims that the OGMR Regulation and Supervision Unit was responsible for negotiating a long-term license of NRD, that he provided NRD with a draft contract in September 2011, that this draft contract was the form of agreement that was used for such agreements between investors and the government, that he, together with his team at the Regulation and Supervision Unit, worked with NRD for several months to negotiate the terms of that agreement. Mr. Bedega also claims at paragraph 5 of his statement, I approve a draft agreement, following which it was sent to the Minister of Natural Resources, who in turn submitted it to the Cabinet. As I explain in detail below, all of his statements are untrue. 1, we were not negotiating a long-term licence of NRD in 2011. As I explain at paragraph 12 of my first statement to paragraph 6 above, NRD's 2010 application was for the new 5-year licences. NRD did not apply for long-term licences until January 2013. 2, NRD's 2010 application came nowhere near the standard required for the granting of a 5-year licence they were in fact applying for, let alone a long-term licence. As I also explained at paragraph 12 of my first statement, not only had NRD failed to comply with the contract, it also failed to provide an acceptable feasibility study. 3, although we had discussions regarding new licenses with Mr. Marshall during 2011, we never came close to discussing the terms of a new agreement, as NRD was never able to satisfy us. They had the technical or financial capacity to develop the concessions. A draft contract would not have been prepared unless and until we were satisfied that NRD's application met the requirements necessary to be granted a license, and we never were satisfied. 4, Mr. Bedega never provided me with any draft contract regarding NRD, including the document exhibited at C114, which he claims to have drafted, and the draft contracts exhibited at C42 and 207. I've never seen these documents before, and I never had any discussions with Mr. Bedega regarding a draft contract with NRD. It was not within Mr. Bedega's remit to conduct negotiations or to prepare draft contracts. If he ever claimed to NRD he was negotiating on behalf of OGMR, then that was certainly something that was not within his authority and not something that I was aware of. Then he just deals with Mr. Kibalenko, and I'll come back to that point. Then he says, I did not submit a draft contract with, this is 5, did not submit a draft contract with NRD to the Minister for approval and or submission to the Cabinet. If I had submitted a draft contract to the Minister, I would have had a review meeting with him before it was submitted to the Cabinet Office. No such meeting ever took place. And then as regards Mr. Bedega's suggestion, paragraph 5 of his statement, that Cabinet would or should have communicated its position on a contract with NRD to him or me, I note that Mr. Bedega was at that time a mid-ranking official at OGMR. I was the Director General of OGMR, and I was myself never contacted by the Cabinet. If Cabinet had had any questions regarding a contract with NRD, those questions would have been discussed with the Minister himself. However, in this case, no such questions ever arose or could have arisen, as no contract with NRD was ever submitted to Cabinet. And that all reflects the reality of what really happened, doesn't it?
This is all new information to me. I doubt it, and I think that this was prepared in preparation for this hearing.
Can we go to bundle C207? This is a set of documents produced on disclosure following a request from the respondent. It's a number of communications between you and Mr. Bedega, and NRD came to employ Mr. Bedega, correct?
Yes.
And he joined NRD at the beginning of 2012, didn't he?
Early 2012, yes.
So shortly after the emails and draft agreements we're about to look at, yes? Now, it's right to say, isn't it, that in the assistance he was giving when he communicated with you in respect of this draft contract, Mr. Bedega was helping you out in advance of his joining the company?
No.
You never understood him to be articulating an official position on behalf of OGMR, the Geology and Mining Authority, did you?
Of course I did.
If we go to the first email on the chain at page 1, this chain is sequential in time. We can see there's an email from, we were on, back where we were, thank you, just stay there. This is an email from Mr. Kibalenko to Mr. Bedega copying you. Now, Mr. Kibalenka was an employee of you and NRD, wasn't he?
He was a consultant to us, yes.
Yes. So he's on the NRD side of the fence, yes? Now, this is the first email on the chain. It's an email of 28th of September. And what we can see is that contrary to your allegation in the reply, it's not Mr. Bidega who sends you a draft contract at all. In fact, on the 28th of September, Mr. Kibalenka emails you and Mr. Bidega a draft agreement. We can see the agreement starting on page 2 of the document. Yes?
I'm not understanding.
So, your allegation in the reply is that Mr. Bidega provided you with a draft agreement.
He did, from
You have
Gafford.
now, your side has exhibited, has produced on disclosure the documents that go to this allegation. And what they show is that it starts off, in fact, with Mr. Kibalenka of NRD producing a draft and sending it to you and Mr. Bidega. Yes?
This would have been well into the negotiation because this page is talking about what the ministry's position was on capital investment. The document was simply a document by Gafford, which is another large concession that the ministry, we were told that the ministry had been negotiating or had negotiated, and they gave us that. We went through the exercise of whiting out all the names and all of the specific provisions related to Gafford and used that as the template. This email would have been communicating to us, well, and I don't know, but the information about the technical parameters came from the ministry. They were the ones who told us how much had to be invested and what the production numbers were likely to be for each of them. They're much more modest than Dr. Michael would have liked, but that's because he was part of the smuggling operation.
Now, again, none of this is true, Mr. Marshall. Your reply contained the allegation that Mr. Bidega had sent you a draft contract. We asked for disclosure of the material, of that material. This tab C207 is all that your side has produced by way of disclosure in response, and we can see the sequence of events. And the first email, first draft contract comes from your side, from Mr. Kibalenka, correct?
No.
Mr. Bidega was
all
not.
our documents from our office and whatever Gafford document was there. I think you need to ask Dominic or Kibalenka or anybody, but that's the process I'm telling you.
Mr. Bidega was not providing you with any draft at all, was he?
No, the ministry provided us with the draft.
And you were the one who had the idea of putting in these details of investments and estimations of investments.
No.
And if we go to page 5 of this exhibit, this is an email from you. It's a little further on, now at 14th of October. You say to Mr. Bidega, sent to his email, his Yahoo address, "Hi Dominique, I have attached a draft agreement for your review. Please have a look and tell me what you think." So again, it's not Mr. Bidega providing you with the draft, contrary to what you said in the reply, is it?
No, in colloquial terms, every time the agreement gets passed and it's not a final agreement, it's referred to as a draft. So this is just yet another draft. And by the way, all ministry employees use their private emails. There was no, at this time, there was no ministry email system for them to work through.
Let's look at page 7 of this exhibit. So this is your draft agreement.
This would have been our amendment to their draft agreement that they gave to us.
And what you sent, what you provided in Article 2, the rights, if you look at item 2,
Yeah.
the right given by the semi-industrial mining concession licenses are valid for all the duration of a license, brackets 2017, will be granted after the signing of this contract. So you were providing for 5-year licenses under this draft agreement that you sent to Mr. Bodega, correct?
Yeah, I don't know why that number is there. The later drafts are talking about 30 years, not 5 years.
Reason it's there is because you understood that all that NRD had so far applied for was a 5-year license.
No,
And that's why you put in a 5-year license in your version of the draft.
no,
isn't it?
this is an early draft. The later draft has 30 years.
And if we go to page 4 of this document, we can see that again, there is forecasted cash flow provided for, not yet filled in, as well as estimated capacity of production. And that again is something that's all come from you, isn't it? Rather than from Mr. Bodega as something to put into the contract, correct?
No, that would come from the ministry.
If we go to the top of page, so go to page 33 of this exhibit, go to the top of the page. This is a letter from you, email from you, say, "Hi Dominique, I have attached a draft agreement. Please excuse the date on the file, but I could not change it after I began drafting the agreement. I need better computer skills." So again, quite clear that you are the draftsman of this agreement, yes?
They provided us with a template and we were amending it and working on the document as we sat down for discussions each time. I have legal training, so it made more sense for me to be putting the language into the agreement and then for him to check it to make sure that it was what he was expecting.
Mr. President, I wonder if now it might be a convenient moment for a break. It's perhaps a little earlier than I thought, but I wonder, it's been quite turgid stuff we've been going through, and I wonder if now works for the tribunal. I apologise. I think you're on mute, Mr. President.
I apologise. We will take a 15-minute break now.
Okay, fine.
All right, we're going to go ahead and open up the breakout rooms. All
You're
right.
getting very good at it.
Okay, Mr. President, the
Yes,
witness
please.
in the waiting room, I'll wait for your permission to bring him back in.
Please invite him back.
Okay.
Mr. Marshall, could we go back? We're in bundle C 207, and if FTI could pull up page 25. This is another email from you in this sequence. And it's another one from you to Mr. Bodega saying, "I attach a copy of our proposed agreement. Please note especially Article 3B. Can we go to page 28 and we can look at this article? And you, in this agreement, this is still a 5-year agreement, but there is a new obligation that you have inserted in this draft at Article 3B, which says at the bottom half of this para, do you see, as soon as NRD makes a calculation of reserves and begins semi-industrial production at any time after signing this agreement, and as a result of making the estimated total amounts of investments set forth in the Article 4 capital investment program, NRD shall then be granted a long-term 35-year concession right. So what you're doing in this draft agreement is, although it's a 5-year agreement still, you're providing on certain conditions that there can be a grant of a 35-year concession right. Yes?
I see the language you're talking about.
Yeah. And that was what you were proposing.
So that's what they were proposing.
No, you remember I hope I didn't go too quickly. You asked him to.
Well, I asked him to look at the language. This is the language that we were talking back and forth. This is how he wanted it framed.
Not so, Mr. Marshall. You were suggesting a term that would, on certain conditions, lead to the grant of a 35-year concession, correct?
This is reflective of our conversation is what I'm pointing out to you.
It's your drafting and your proposal, yes?
It's reflective of our conversation. It is not my proposal versus his proposal. This is the language that he was looking for to make it acceptable for him.
No,
that's why I highlighted it for him. Was this sufficient?
If we go to page 89 in this thread, in this email chain, we can see that you're still in conversation with Mr. Bedega in December 2011.
Yes.
In the middle of December 2011. And you knew, didn't you, that Mr. Bedega himself didn't have authority to agree the terms of a license, and it would need to be approved by Dr. Biriabarema and thereafter a minister, correct?
Dominic is the head of a committee, and when the committee approves it, it is referred up to Dr. Mike, and if he approves it, it's referred up to Minister Kamanzi, and then the whole package submitted to the cabinet.
Well, the second half of what you've just said is correct. It had to be approved by Dr. Mike and submitted to the minister, but you are wrong to suggest that Mr. Bedega was the head of any relevant committee for the purposes of agreeing a contract of this kind, aren't you?
Well, that's the first I've heard of it.
And you didn't understand at any point.
He was the acting director of OGMR. So I assume.
You didn't understand at any point that this draft agreement had actually been agreed by Dr. Biriabarema or submitted to the minister or provided to cabinet, did you?
I absolutely believed it. He told it to me.
And if you had understood that, we'd have seen that all over correspondence, which we don't. And it's inconsistent with the meeting you did have with Dr. Biriabarema in December 2011, isn't it?
Dr. Biriabarema was a wild card. I never knew what he was going to do when, because he was so angry with me. That being said, there was nothing about this process that I doubted. If you claim that there should be other documents, then they would have been in our offices, and I would again ask you to give them back to us, and then we can show it.
Well, just in relation to that last answer, you did know then, didn't you, that Dr. Biriabarema, who needed to approve an agreement of this sort, had never approved it?
No, no, obviously not. I had been told that he had approved it, and Minister Kamanzi had forwarded it with his approval to the cabinet.
We can see what Dr. Biriama's position in fact was as regards your application, because in December 2011, you did meet with him, didn't you? Do you remember that?
Yes.
And you were told at that meeting that NRD's performance fell short of the level expected, and that the government were only prepared to negotiate on new licenses for 2 out of the 5 concessions, correct?
No, that's not correct.
And Mr. Bedega was not at that meeting, was he?
I don't think he was.
Now, we'll come back to that meeting. I'm just going to move first to a different topic, which is environmental, closures of concessions on environmental grounds. Now, we've been looking at the period in 2011 after you arrived at NRD, and you are also aware, you were aware at the time, weren't you, that the government of Rwanda was quite concerned at environmental damage on NRD sites, yes?
No, well, there's ongoing environmental damage everywhere in the context of it being erosion. These are very steep slopes. Miners and farmers, neither of them pay much attention. some of them are in our concession areas. And so the easy person to go and say, can you please fix this, is us. This is not because of our mining or our poor supervision. This is just what happens in Rwanda. It's not like there's cyanide or any heavy metals. This is simple erosion issues. And we were asked to fix some in the Spalena River catchment.
Can you go to bundle R110? This is an inspection report for mines in the Western Province from November 2010. And can you just go to page, so this is the time of the application. Can you just go to page 6 of that document?
What's the date of this?
This is November 2010. So the same date, same month as the application for the 5-year licenses was made.
Can I ask Mr. Hill for clarification? Are we supposed to be looking at R110 or R100?
R110. Is that not what's come up? Sorry.
I thought
That's what I have.
prior page.
This is 100.
I thought on the prior page it said R100, but it went by fast. I apologize if I misread it, but I would just ask to double check that.
It does say 100 on the bait stamp.
This is in my files and what's marked as R110.
It looks similar to.
Anyway, it's the document I want.
Just for clarification, there's a translated version of it. I think it might be a typo on the Bates number.
Thank you. So can we go back to it? I'm after page 6 of it. So these are observations from the government inspectors. And what they say is that if you look at the 4th bullet, in general, all mines of NRD experience environmental damage. And so their finding in 2010, end of 2010, was that all of NRD's mines were suffering from environmental issues, correct?
I see the words. I think this is a fabricated document. I was never aware of it, never heard of it. Nobody ever complained about it.
Well, we'll look at complaints now. Let's go to bundle C040.
Not communicated to us. Anyway.
This is a letter from Minister Kamanzi in October 2011, notifying you of his concerns at environmental damage on land that was subject to an NRD concession. And I imagine you recall that letter, yes?
I did, and I responded.
Yes, let's look at your response. It's at C041. Now, this was a response from you which goes on for 6 pages with a series of arguments against Minister Kamanzi's observations. And it'd be fair to say that in this letter, you don't accept any criticism of NRD's environmental compliance, correct?
No, I think you're mischaracterizing it. What the issue was that he was complaining about was in Yatabindi, which is a coal town, the only recognized coal town area in the country. The Belgians had been using what they call ground sluice mining tactics approaches, which are illegal in most countries because it's really turning on a fire hose and washing down a hillside and then picking up what minerals are at the bottom. So there are some areas in Yatabindi, I think you can see it in some of the photos, I don't know if they've been shown to the panel, and it's about 3 kilometers wide that the Belgians did this. It's a scar on the hillside, but it's not a particularly attractive mining area, agricultural area anyway, so it hadn't been a priority. The Belgians did that in the 1920s and 1930s, and there had been some efforts to dam up parts of it to make sure that the erosion didn't get worse. That's what we were addressing, and he said that was NRD had caused those problems and therefore needed to be subject to immediate sanction. He did it to a group of 300 people, and it was a political statement rather than a statement of fact.
Well, he was talking about the continuing siltation of the river that resulted, wasn't he? Yes, he was saying there was a continuing problem, correct?
Yes, yes, it is a continuing problem, and we have been building dams there to hold back the silt.
Let's look at the penultimate paragraph of the letter.
But it was not something that NRD did. This was ground sluice mining by the Belgians, as I say, in the 20s and 30s, and it continues.
You say he was asking for remedial action, and you say it's impossible to perform what you ask, given the misrepresentations and half-truths and faulty logic of the letter. We at NRD and our investor group must conclude that the intent is to nationalise the Gakiri mining concession. If the intent is to nationalise this concession, I would encourage an open and frank discussion about how the nationalisation process will work and how to present this information to the international investment community. And it's fair to say, isn't it, that this allegation of expropriation and the threat to present information to the international investment community is one that you resorted to frequently in answer to critical correspondence from a member of the government?
No, this was a highly inflammatory hearing where I was not allowed to speak. I was made, sort of a caricature bad guy. His information was wrong. Who was responsible for it was wrong, and we weren't sure we were going to get out of there alive. I think this is actually a measured, as loud as it sounds, 20 or 12 years after the fact. What he did was really put us and the team that I was with at personal safety risk.
This is a response to his letter. And in your letter, you talk about the minister having made misrepresentations and half-truths and faulty logic, don't you?
If you read the whole letter, you'll understand what that means, yes.
Well, when you read the whole letter, what we can see is that at this stage, you are denying any responsibility for any environmental damage. And you are also saying it's impossible to take actions to perform what he wants you to do. Yes?
No, we're not responsible for what happened in the 1920s and 1930s. No mining company can be.
Well, we can all read. We've got limited time. I'm not going to take you. Just listen to my question. I'm not going to take you to every paragraph.
I request that you let him finish his answer, because he did cut him off again, and you asked him a multi-part question.
Okay,
he was answering it. Please.
Yeah.
Yes, please let him finish his answer.
We were put in a very unpleasant position because this is a problem area, and I think you can see photos of it. They did do ground sluice mining. We cannot be responsible for, no company can, for degradation without specific agreement. This would cost millions of dollars to remediate this. You can do lots and lots of short-term fixes. The problem that they were having was that there was silt in the Sabea River. The amount that actually this is a comparatively stable place. The amount of silt that comes from it is minimal. This is where the river begins. This is not partway down the river where there is substantial silt coming into it. So what we did was we brought an environmental team from Czech and Slovakia, Dr. Novak, who's a famous environmental specialist with a team from his university. And they spent the better part of 2 years identifying practical procedures to eliminate the silt from this part of the Sabea River catchment. The majority of the problem is downstream when it's agricultural runoff. Here, we like to think we made a significant impact. In fact,
Mr. Marshall, I've listened to that answer. It wasn't an answer to my question. Now really focus on my question. And the question was that you were at this stage denying responsibility for any environmental damage, and at this stage saying it's impossible to take further action. Correct?
No.
Well,
it's a multi-part question, and I'm trying to answer each part.
Well,
we had no liability and no responsibility even under Rwanda law for it. I was trying to make him understand that even though he had been provoking a riot in front of 300 people, it was not our it was not damage that we had done, and it was not damage that we had a responsibility to fix, but we would fix it and step by step make efforts to do that.
Do you want to show us where in the letter you say to Minister Kamanzi that you would fix it? It starts at page 1.
I didn't say we would fix it. I said we would take remedial steps. We brought in a team to.
That's the point I'm trying to get to, if you'll listen to my question. You don't, in fact, in this letter, indicate you'll take any remedial steps. I completely accept you do later, and I'm going to come to that. But my point, which I'm trying to get you to focus on, is that in response to Minister Kamanzi's observation about environmental damage, your immediate reaction is not to offer any acceptance that there's been environmental damage by NRD, and not to offer any remedial action. And that's correct, isn't it? And we can look at the whole letter. It's 6 pages long.
Let me read both letters and then I'll respond. But we were certainly, we felt like we were at risk of our lives. So I may have been upset.
Well, we've got page 1 and 2 on the screen. You can take it from me. There's no
May I read it?
acceptance. Well, I'm trying to move this along as quickly as possible.
I understand. You asked me a serious question.
We're looking for either an acceptance by you that NRD's done anything, contributed at all to the environmental damage, or an offer of remedial action.
Okay, let me read the letter. You'll note that it is Gachia, not Spalena. Okay. Can they move on?
Yes, we put the next 2 pages up, please, FTI.
Yes, he threatened termination.
So you've now read it.
No, I haven't. Sorry. Just one more minute.
Sorry.
Yes, I'm sorry. Go ahead.
So you've now read it, and I'm right, aren't I? There is no acknowledgement by NRD of any contribution by NRD to environmental damage, and there's no offer at all to remediate at this stage, is there?
There's the point of the letter, and I think if you read it correctly, is that we do not acknowledge any liability or responsibility for any of this silting at the upper ends of the Sabea River catchment. This is where the river begins. Okay, so just so you understand,
That really is a digression.
you want to know.
I want you to focus on my question. That is a digression.
Explain it. You won't understand.
Sorry, could I just intervene a moment? The question was a very simple one, susceptible to an extremely short answer. Please try to listen to the question and answer it.
Okay, thank you for that. No, I am offering implicit help. We had been offering help before, and it did continue.
Well, I'm going to suggest you clearly weren't. I'm also going to suggest, and you're going to give me one opportunity to comment on it, but accusing a minister in response to a fair letter about environmental damage of misrepresentations, half-truths, and faulty logic is hardly the action of a responsible professional mining company, is it?
I disagree. Under those circumstances, I disagree.
Can we go to bundle C043? This is a report that you did commission in relation to the damage on the mine after this letter. This is Dr. Twagiramungo's report of November 2011. And can you go to the second page? He has his findings, bottom half of the page, where he says the most significant environmental problems found are the following. There is a continuous pollution of the Sabea River by sediments from Nyartabindi mining sites. There are numerous areas in Nyartabindi where gully erosion and landslips are taking place as a result of mining activities and non-implementation of the best management practices of erosion and sedimentation control. There are many vertical trenches from mining sites towards Sabea River in Nyartabindi 1, 2, and 3. The horizontal trenches are in bad conditions, not maintained, and need to be widened in order to have the required size comparative to the volume of the sediments. The existing sediment ponds are not enough and not well maintained. And so, and then the last point, some unknown individuals are still mining in informal and in disorganized manner, resulting in more environmental and socio-economic concerns. And then he has his action plans, and they include construction of check dams, upgrading the existing sedimentation ponds, constructing 2 new sedimentation ponds, revegetation, filling the created gullies, planting trees, ensuring security, and training NRD's workers on Nyartabindi on the best environmental practices. So what Dr. Twagiramungu found was that there was in fact continuous and continuing environmental damage being done, which needed action. Yes?
No, Nyartabindi was closed. There was a security problem because illegal miners were working there and making some damage. And that was the reason we did go in there, and we I think, largely followed this plan. Although I would have to get the environmental people to be able to say what was done and what wasn't. Maybe all of it was, I don't know. But it's only about illegal miners. There was it was closed just for the reasons you're talking about.
Yes, it had just been closed. And what this geologist is finding is that it's the activities of NRD that have indeed been contributing to the economic damage, correct?
So it was
environmental
closed,
damage.
No, it was closed during Stark's time and maybe before Stark. I don't know that any mining was ever done. When I say just closed, I mean it's closed completely, not like partly open or
This is referring to NRD's workers on Nyartabindi being trained.
yes, yes, but that's creating dams and limiting the silt coming down. That's not mining being trained.
What was found was that NRD's mining activities were still a contributing factor, whatever the historic problems from the colonial era, correct?
No, NRD wasn't mining there. As far as I know, NRD never mined there.
And can you go to bundle C044? Now we have in this letter a change of tone from you because you're writing now to the mayor of Ungarero district. And in the first 3 paragraphs of this letter, you say, this letter is to update you on the site work and remedial activities going on at Nyartabindi site. Since our meeting on October 25th, NRD has retained an environmental expert to guide the NRD remediation works. Dr. Fabian researched and wrote a report in 2010 entitled Rapid Environmental Assessment of Nyartabindi mining site and has been repeatedly visited the site. He prepared a remediation plan for the site and has been supervising the hundreds of workers that have been upgrading the horizontal trenches, reinforcing the weirs and constructing new sediment pools. Then in addition to the hundreds of casual labourers that have been hired by NRD to improve the site and reduce the sedimentation into the Sabaya River, NRD has put into place a variety of additional improvements. And it's fair to say, isn't it, that this is a change of tone because you were acknowledging that there was a problem caused by NRD. Yes?
If you perceive a change in tone, I'm not going to argue with you. We believe that that Minister Kamanzi had put our lives at risk. I was very unhappy. I did deny, and I continued to deny as long as I was in Rwanda, that we were responsible for any of the Belgian mining. As far as I know, these sites were closed from 2007, and maybe even in Rudemi time. There are people who go in there and illegally mine, and they don't pay attention to the runoff. And so this exercise was to repair what those illegal miners had done.
No, I don't accept that, but I'm going to move on to a different topic, which is, and ask you to go now to R018. And we're back on the question of the licenses. And this is a letter from January 2012 from Minister Kamanzi to you. And he deals with the December 2011 meeting that I was discussing with you a little earlier. And he says, I received the information of what was discussed in the meeting held on 12th of December 2011 between NRD and our representatives from RNRA, Geology and Mining Department, with the objective to agree on the nature of the new contract with NRD. Given that the resources evaluation accomplished under your previous contract fell far short of the level expected, it was put to you we would only be prepared to negotiate with you possible new licenses on only 2 of the 5 concessions you held. So just pausing there, the point made is that the resources evaluation under the previous contract fell far short of the level of expected, and you're being told again that your November 2010 application was considered as inadequate and you hadn't complied with the contract, correct?
That's right, but this letter is not true.
Well, it's Minister Kamanzi's letter, isn't it?
It is Minister Kamanzi's letter, but Dr. Michael had misreported what had been said in the meeting. I was never made an offer of 2 out of 5 concessions. In fact, the discussion never went in that direction. There was nothing, no discussion like that.
And you say he's also sorry, you finish. Please finish.
I followed up in a subsequent letter answering this letter in that vein.
And the government did make clear to you, didn't they, that they were prepared to negotiate for 2 out of the 5 concessions? Yes?
No.
And Mr. Kamanzi is also making clear that he's regarding your previous contract as indeed a previous contract and not a continuing one. You see that in the second paragraph.
Yes.
And you knew very well that this is now in January 2011, there had been no long-term contract approved by the minister, who had been Mr. Kamanzi, and then sent to cabinet, didn't you?
I'm sorry, you said January 2011?
Sorry, January 2012.
Yes, no. We were being told repeatedly that it was still in cabinet and that it was always, the cabinet has a list and they determine which issue is going to be determined by the cabinet, and that ours had not been included on the list. Dr. Michael, I knew to be have a very bad relationship. I could not pay him bribes. I was in a difficult position with him. He expected to be the owner of NRD, as he repeatedly told me, and that it was unfair that
none of those points just to be clear, none of those points you just made about Dr. Michael have ever been said before in any witness statement by you, have they?
I think I have.
Well, we can look at your witness statements. And coming back to the point, it's quite clear, isn't it, that Minister Kamanzi had not approved a long-term contract for you and sent it to cabinet. And it must have been totally obvious to you when you received this letter.
We were, all the concession holders were in exactly the same position. Nobody had a long-term license. Nobody had any more than performance and waiting for Rwanda to perform. So we didn't think of ourselves as any different.
It was clear, back to my question, it was clear to you that you did not have a long-term agreement that had been approved by Minister Kamanzi and submitted to cabinet.
I believe that we had.
Well, how could you have believed that when you got this letter?
Because I don't know what their internal politics are. I knew that it was in front of the cabinet. I knew that at the time that he had approved it, it was okay. Did he have the ability to withdraw it? No, I didn't know. And I didn't mind. I was waiting just for the decision of the cabinet, nothing else.
Now, let's look. You mentioned your response to this. Let's have a look at it. It's at C039. You start off by telling Minister Kamanzi he's been misinformed.
Yes.
And you then go on in the second paragraph. I'd suggest to quibble at the language. You say, first, Dr. Michael never stated that the ministry would only be prepared to negotiate possible new licenses on only 2 of the 5 NRD concessions.
Yes.
In fact, he made one mention that I believe he used the word prefer, that NRD only retain 2 licenses. So that's your quibble, is it?
I don't think it was a quibble. I don't think that he even made it a question. He may have made a statement to the room at large, but it was being done in translation, and I don't know. I don't think so. I was told by the others who speak in Rwanda that if he had said that, it was say, I would prefer you to keep 2 licenses, not as an offer, not as a requirement.
You then look at what you say at the bottom paragraph on this page. You say it's not true, as alleged. I stated if NRD does not get the 5 concessions, NRD would not accept the ministry's office to negotiate an agreement over 2 of them as suggested to NRD. I certainly never made such statement, and I was never even aware that Dr. Michael was informing me the ministry expected to take 3 of the concessions back. Now, at that point, you only had a license extension until February 2012, didn't you? Yes?
Yeah, I don't recall what the...
You were given a 6-month extension in Minister Kamanzi's August 2011 letter, yes?
Yes, it was commonly understood in the mining community that those extensions had a political purpose and were not connected to the negotiations. But that may well be true that 6-month period finished. I don't know.
Minister Kamanzi told you that the 6-month period was connected to negotiations, didn't he? Because that was a 6-month period that you had to try and sort things out. Yes.
Yeah, he gave. If you look at the long-term. Or rather the extensions, they were for odd periods. One was only for 2 weeks, for example. It seemed to have a political dynamic and nothing to do with what was happening. He would not. You want to know if I was negotiating? The only negotiation I had was with Dominic and the document that was in front of the cabinet.
And just to understand the point you make at the bottom of this paragraph, you say, not even aware, Dr. Michael was informing me that the ministry expected to take 3 of the concessions back. Well, given that the licenses were due to expire in February, and given Dr. Michael was saying he only wanted to negotiate in respect of 2 of them, it's quite obvious that what he was expecting, wasn't it, was that 3 of the concessions would lapse and would go back to Rwanda. Yes?
No, the meeting wasn't even about these licenses. The meeting was about what was happening in different mining areas. If he made these cursory messages, they were not made clear to me.
This was a confected, made-up surprise on your part in answer to Mr. Comanzi's letter, wasn't it?
No, it was not.
Can we go to the next page, look at the second paragraph? You say it must also be noted that your letter of 26 January 2012 was the first indication of any kind that NRD was in any respect deficient or in its resource evaluation. NRD vigorously disputes that such research, as you put it, fell short of the level expected. You see that?
Yes.
Now, you knew very well that the failure in respect of the feasibility report was identified in Minister Comanzi's letter in August 2011, yes?
If you could bring it back up, but to me, we were still in the process of negotiating the long-term concession, so it could not have been deficient.
He told you the respects in which the 2010 application was deficient, didn't he? Told you hadn't met your obligations under Article 2 of the contract in respect to the feasibility report.
Okay, I for reasons I don't recall right now, I did not, if that was what it said, it was not something that I took seriously because we had our long-term concession in front of the cabinet.
And this is another piece of confected surprise, isn't it?
Oh, it's not. This is the process. Not everything is pretty there.
And then you say in next paragraph, your letter is a great shock. We evidently misunderstood your message relayed through Mr. David Ben Susan that NRD was performing well and that the concession will be extended, presumably under the terms of a draft contract approved by RNA Committee and RDB. And again, what you're doing there is suggesting things to the minister that simply are not the case, aren't you?
No, that's what this is. I don't do that. But I understand to be the case. That's what I articulate.
And you knew very well that NRD's performance was not considered satisfactory, and the contract had been regarded as no longer being on foot with the obligations unfulfilled. Yes?
No, I knew that the supervision and licensing board committee had approved it, had found it acceptable. In fact, had found it the best of all the applicants. If Dr. Michael or Minister Comanzi had an opinion without looking at the documents or without reading the application, then I followed what was the detailed analysis by the board.
Now, you suggest here that there's been a draft contract approved by RNRI Committee and the RDB. That's a different version of events from what you now say in this arbitration, which is that there's a contract approved by Dr. Biriabarema and Minister Comanzi and provided to Cabinet.
RNRA that's the ministry, so that would have been the supervision and licensing board. The RDB, I don't know, I don't recall now what their position has been or why I thought that was the case.
But what you're not saying is, look, Minister Comanzi, you've approved this contract and submitted it to Cabinet. And if that was what you thought had happened, you'd have said so.
As far as I knew, I've given you what I understood. The fact that Dr. Comanzi was jockeying for a negotiating position to get tougher terms in a long-term contract, or what his motivations may be, I know that he didn't read the application or the long-term license.
No, but your case, but your version of events you're trying to ask the tribunal to accept is that by this point, Minister Kamanzi and Dr. Berry Arborema have in fact approved a long-term license and submitted it to Cabinet.
That's what I was told.
But if you had really been told that, you'd have said so loud and clear, because you clearly don't hold back in your correspondence. Correct?
So you think that? I think that I am tactful unless my life is being threatened.
Well, no one's, even on your evidence and allegations in these proceedings, no one's threatening your life, are they, at this point? On
I'm
your
sorry?
case. Even on your allegations, there's no threats to your life at this stage.
At this point, no.
And yet what you also do, we can see in this letter, is copy it to the Prime Minister, the Minister of Justice, CEO RDB, the Ambassador, and various lawyers. And why were you doing that?
I don't recall the circumstance, but I wanted to make sure that it was generally known what the process was. If he was going to flip-flop and decide that it was not an acceptable document, then that's fine.
You were trying to bully Minister Kamanzi, weren't you?
No, I wanted to make sure that the process was fair and transparent.
And you're also putting a false version of events in this letter.
No, I'm not putting false
and then
version.
copying it to a number of other people at the same time. Yes?
No, I'm not putting a false list of events in this. We had, and I understand this to be calculated in the damage section, but we had put millions of dollars in already, and we were at risk of losing everything. I was very worried. No.
Look at the penultimate paragraph. NRD requests you give consideration to the provisions of the bilateral investment treaty. If the ministry anticipates termination of any or all of the NRD concessions, such terminations are taking or expropriation of the assets of American investors. The bilateral investment treaty provides that the American investors will be compensated before the asset is expropriated. Please see attached summary. So you are already lining up your correspondence, aren't you, for a claim of the sort you've now brought in this arbitration?
I was very worried, and the people that I was working for in the military were very worried.
Now, can we go to Mr. Sindhi Gaya's second witness statement at paragraph 6.4?
All I can do is, I can't, the political system there is what it is. To bring a claim in Rwanda court for enforcement, the Rwanda courts would not recognize me. I can't sue them in US court. The only way I can bring a claim is under the treaty. That's my only mechanism to get a review. So, as far as I was concerned, I had a very good relationship with everybody in the government except these two people. And then Minister Ebot as well.
Let's look at what Mr. Sindhi Gaya says. On several occasions, I recall Mr. Marshall telling me that if NRD was not granted licenses, he would sue the government for $15 million US. I remember being surprised by this. It seemed a huge sum to be claiming, given the company was an artisanal operation based on miners using traditional tools of their own, namely picks and shovels. The only substantive investment in the concessions, whether it's Zero Plant, which was a commercial failure, as I explained above, and a fleet of 4 trucks. And it's right, isn't it, that you told Mr. Sindhi Gaya that if NRD was not granted licenses, you would sue the government for $15 million US? Yes.
No, I think this is a fraudulent document. That conversation never happened, and it's not something I would even have conveyed to him. What I would have no purpose in conveying information like what our expectation was.
No, we have been looking at late 2011. It's right to say, isn't it, that from 2011 onwards, you started borrowing money on behalf of NRD from Mineral Supply Africa, yes?
The only lines of credit available in the country are, if you're in the minerals industry, are from the mining traders. So I did have a line of credit of about $100,000 from MSA.
If we go to Mr. Kayahura's witness statement at paragraph 17, he had been working at Mineral Supply Africa. He explains that in 2011, NRD were working at some mines that were potentially very good, particularly the mines at Nemba and Rutsiro. Mr. Ben Susan and I were interested in working with Mr. Marshall and NRD to develop these mines. Mr. Marshall knew of and exploited our interest. He regularly asked MSA to lend NRD money, allegedly for investments in the mines and the infrastructure for the mines. Between 2011 and in and around 2015, MSA provided around $500,000 to NRD through a series of loans, none of which had been repaid when I left MSA at the end of 2016. And that's accurate, isn't it?
No, that's not accurate.
Which aspect do you say is not accurate?
David Ben Susan was working with General Kabarebe, who was the then Minister of Defense, in bringing minerals from Congo. They very badly wanted us to participate in smuggling minerals from Congo and representing them as having been mined in Rwanda so that they could be DRC conflict-free as defined under the statute. US statute. That was the SEC requirement. We had a letter of credit for $100,000, a line of credit for $100,000. All companies have a line of credit with the traders. It was never 500,000. We had a major falling out with David because he was involved in a number of corrupt schemes. We contacted, among other people, we and other people contacted his parent entity and explained what he was doing with Mr. Kayahura and the fraud that they were perpetrating on people. I attended business meetings with General Kabarebe and David Ben Susan. They wanted our concessions. They wanted us to merge with their company. For us, it made no sense because, and I know this may be getting away from it, but I found them dangerous and that it would end badly for us. For David to claim that we owed him, or in this case, Fabrice to claim that we owed him 500,000 was nonsense. We had one of his staff people out in the Western concessions on secondment, a woman named Solange. We could not figure out what she was doing, and David claimed that he was advancing her money, which he never got approval from us on. So as far as I'm concerned, it was a nonsense discussion unless he could show us something of where this $500,000 went.
Let's see what Mr. Sindayaga says. He's the accountant, and you suggest he's a bookkeeper, but he describes himself as a senior accountant. Let's look at paragraph 23 of his first witness statement.
David Ben Susan asked us to give verification to his auditors that that was a debt, and obviously we laughed and refused. And we took the issue to David's parent, Cronymet, and explained what had been going on, and that is what led to David being fired.
Well, Mr. Kayahura has confirmed this 500,000 figure. Mr. Sindayaga, who's at the company, is able to say in paragraph 23 in the middle, in total, between November 2011 and September 2012, when I left NRD, he borrowed, that's you, borrowed around $300,000 this is from Mineral Supply Africa. So that's right, isn't it? That you were borrowing hundreds of thousands of dollars.
So we had a line of credit for $100,000, and we had left several pieces of machinery as security for that line of credit. There was nobody else who had to provide a line of credit, security for it. We were happy to do so. If it got to 120,000, I don't know about it. Certainly never got to 300,000, much less 500,000.
Well, yes, you went to both 300 by September 2012 and 500 rather later. And that's correct, isn't it?
No, that's a lie.
Now, it's also right, isn't it, that you were borrowing this money from MSA ostensibly for investment into the mines, but it wasn't going into investment at all. It was going into general cash flow and your own personal expenses. Yes?
Certainly, none of it went to my own personal expenses. I would have to go back and look at what the specific use of the money was. I can't say off the top of my head. But
NRD, sorry, you finish, please finish.
certainly not personal expenses.
NRD continued to be in a worsening financial state under your control, didn't it?
No. We had been able to pay off all of the outstanding NRD debts that were there when we got there. We had been able to turn the company around, but for the taking of the tags, we were doing well.
You weren't paying your employees either, were you?
Yes, we
Because
were.
we see that result in a series of court judgments.
No, to this day, we don't know who those people were. If they were NRD employees, they were certainly NRD employees before we got there during Zarnak or the Stark periods. We could never find out who they were.
It's also right, isn't it, that from the time you took over, production went materially down from production levels at the time of the Stark years. Yes?
That depends on what period. You know, certainly with regard to NEMDA, it went up significantly. When they suspended our operations in our Western concessions just because of the Sabea catchment, even though if our areas didn't all go into the Sabea catchment, yes, it went down because we were suspended.
Now, it had already gone down well before the suspension that you're talking about, hadn't it?
Not that I know.
Correct?
Not that I know.
We'll come back to that.
Okay.
And in early 2012, Professor Rapaya left, didn't he?
He retired.
He explains that in his witness statement that he asked for early retirement because the business was in chaos, you were not paying the miners, and as a result, they started to sell minerals and steal company property. And that fairly sums up the position in early 2012, doesn't it?
No, and I need to take a moment just to explain to you how the artisan mining process works. We organize the mine into gangs. They associate usually by family, but sometimes family and friends. There's a gang leader, and the gang leader has supervisory expertise and authority. The miners mine the minerals. And this is true for all mines without exception. The miners mine the minerals. We take it as a group when there's enough to do it. Usually it's about once a week. The wives in particular didn't want it less than once a week because they wanted a lump sum that they could use for schools and so forth. We would take it up to a trader like MSA, sell it to them, and bring the cash back. There were no bank accounts. There was no other mechanism. There were no checks. And bring the cash back to the mine and give it to the miners. In principle, the minerals are actually their minerals. Okay, and we're allowed to get a small margin off of it. But these we're selling for them in practice. All the mines operate the same.
Now, just coming back to my question.
Sorry, one last thing, just so you understand. There's security, there's specialty functions like people who have expertise in blasting and supervision. So there are some permanent employees, they always get paid. There was never an instance where somebody didn't get paid.
Just to come back to my question, Professor Rapaya explains that he left in early 2012 at a point where you were not paying the miners, yes?
No, for the reason I just explained.
And Mr. Sindagaya also makes this point. If you look at paragraph 22 of his witness statement.
There are no miner employees. They get paid when the minerals are sold, and they get paid from those proceeds.
But you weren't doing so. And you can see that from paragraph 22 also of Mr. Sindagaya's witness statement.
I'm sorry, you don't understand the process. There would be riots if we didn't bring them the
well,
money.
There were, and that's the point. Mr. Syndergaard explained it. Around May 2012, we stopped paying the miners for their minerals. And from then on, it was very difficult for me to visit the mines as I would be confronted by hundreds of angry miners asking why they were not being paid. I stopped going to the mines in early July 2012, at which point NRD owed 50 to 60 million Rwandan francs to the miners. By the time I left the company in September 2012, the miners owed about 100 million francs for minerals they had sold to NRD, but for which they had not been paid. And that's correct, isn't it?
Entirely apocryphal.
It reflects also Mr. Rapaia's evidence, and it also shows that you were running this company into financial difficulties. Yes?
No. And in fact, the very next day, they would have gone to the labor inspector. There was never a labor claim against us, if that had been the case.
There were claims. I'm sorry, I'm interrupting. You finish.
Not that I'm aware of, there were no claims. Certainly, they never went, as far as I know, to the labor inspectors and said, we haven't been paid for our minerals. This is made up from whole cloth, as far as I know. And it sounds to me very much like they coordinated to write it.
Now, I'm going to go back to the license story. Can we go to bundle C034? This is a letter from Minister Kamanzi again. And it's dated 20th of February 2012. And he says, this is in reference to my letter extending the special license you had in the above concessions for 6 months in order to negotiate terms of the new contract. It's not been possible to conclude the contract in the above time of extension. I understand the absolute necessity to conclude this agreement as soon as possible for strong investor confidence. However, because of the need for more time to finalize the process of contract negotiation, I extend your existing license for 3 months. I'm certain this is enough time for us to conclude a good contract for this partnership. Allow me to thank you for your continued commitment to invest in the mineral sector in Rwanda. So he's expressing optimism that a contract can be agreed, yes?
Yes, but he never followed up with the meeting.
But he's also, at the same time, not giving you any guarantee or assurance that you'll get long-term licenses, is he? Correct?
This is not the only communications we had.
And by this stage, you hadn't even applied for any long-term licenses, had you?
Yes, we had.
And nothing had changed positively for NRD since you acquired NRD and were told by Mr. Ehlers that the most you could hope for would be a renewal of 5-year licenses.
We were the only concession holder who did not get a long-term license, and all of our application materials, investments, and studies were equal or better than that of all the other concession holders.
Can we go to R040?
What is the date of this again? I'm sorry.
This was February 2012.
February what?
2012. So in other words, do you remember the August 2011, he had given you a 6-month extension. February 2012, he gives you another 3-month extension. So I'm now going to a new document, which is R040. This is an evaluation of your license application in May 2012 by Mr. Immoner, who would later become the Minister of State in charge of mining. And at this stage, he was a mining geologist in the Government Geology and Mines Department. And you can see on page 1, he's evaluating the material in your application of November 2010. Do you see that?
Yes.
And you can see also that one of the things that he includes in his list of sources of information is Dr. Biriabarema Michael's report. Do you see that?
I see it.
So you were suggesting earlier that that report was some form of fabrication for the purposes of this arbitration. But you can see, can't you, it's one of the things relied on in May 2012 for this further evaluation by Mr. Immoner. Yes?
I don't know that this document I was never aware of Evo ever evaluating us or ever visiting our mine or ever talking to anybody on our company. I doubt that this is a real document. And for him to refer to yet another fraudulent document is not surprising for me.
So you're suggesting, are you, this is another fraudulent document? Is that right?
I would believe it to be, but I haven't read it all yet, so I don't know what he's saying.
So let's start on page 1. You see he's evaluating the material in your application of November 2010. You see that's item 2 under main sources of information. And the reason he's evaluating that is that's the only license application you had made by that point, correct?
You'll have to scroll down. I don't see that here.
So it's item 2 under main source of information.
Application for renewal of expiration, but he doesn't include the second line, does he?
So I don't understand what you just said. Just repeat that, please.
Well, in the application is for 2 things: renewal of expiration licenses and allocation of license. Otherwise, we wouldn't have put it on the front of the 2010 application.
Well, I'm going to suggest to you that clearly the document he's referring to is the document we spent some time looking at, which is the November 2010 application. Yes?
Yes, but you went on to say that it's only for 5 years, and that's not what the 2010 application was, is my point.
Well, I'm not going to go back to that with you. Let's go to page 2, item 3.1.
Well, you asked me to agree to it, and I don't agree, is what I'm saying.
He deals there with the initially proposed work plan and budget, making the point that the original proposed budget submitted in 2007 was equipment and working capital 39 million, and then reported expenditures from 2008 to June 2011 are 12 million. Yes, do you see that?
I see that.
And at the top of the next page,
He never came to us for this information, so I don't know where he got it.
top of the next page, they've only invested 30% of initial budget. They explain this by the lack of knowledge of the nature of the mining industry in Rwanda by former NRD's management, which submitted a plan seriously flawed and inappropriate. And that's just a summary, isn't it, of NRD's own application and their own explanation for the discrepancy between the size of the investment.
Well, he never came to talk to us. After he applied for a job, I don't think we ever saw him again.
Well, just answer my question. All he's doing there is summarizing NRD's own position in its own application.
I would say that he's editorializing on it, don't you?
Well,
They explain by this by lack of knowledge of the nature of the mining industry. That's an editorial comment.
no, it's not. That's exactly what the application said. It said that NRD, the Zarnak, didn't have sufficient experience and knowledge of the mining industry. That was the point in the application, wasn't it?
Rather than going back to looking at that language, I don't think that's, I think that's an editorial comment.
Then Mr. Imino then goes on to exploration. And he observes in the opening lines that it's obvious that NRD had done less than half the required exploration and development works for a company that spent 30% of its initial budget.
He can't even possibly know that without visiting the company. He never interviewed anybody. He never talked to anybody. He never came.
Well, Mr. Marshall, that's not how these applications work, is it? These applications work by the company submitting material that said to justify the license. The conclusion that he drew correctly from the material submitted by the company was that it was obvious they had done less than 50% of the required exploration and mine development works. And that, of course, fits with Dr. Professor Ripaya's own analysis, correct?
No, that is not how these application processes work. In every case, they go and visit the company. Rutongo has had dozens and dozens of visits looking at any number of things to see whether there's been what they expected or what investments had been made or any number of items. They never once visited our concessions or our offices.
Professor Ripaya explained that only superficial exploratory work had been done, and that's obvious on the face of the 2010 application. You can't dispute that, can you?
Yeah, I certainly do.
And all Mr. Immoner is doing is drawing the same conclusions as NRD itself drew and as the application demonstrates, correct?
This is not the way this review process works in Rwanda. You don't just read the document, you sit down with the people and you find out what's going on, what's real and what's not. And if there are views to be shared, it gives you an opportunity to share the views.
Underneath that, Mr. Immoner goes on to explain that the major objective of these hybrid permits was to delineate the resources and evaluate the reserves. And he then explains the work done in exploration. And then he says NRD did only some significant preliminary exploration work, but failed to realize the objective of delineating the resources and evaluating the reserves. And that's a fair conclusion, isn't it?
No, it certainly is not. And that's an editorial comment, which I reject.
And then Mr. Immoner refers to the review provided by Dr. Biriabarema, which he refers to as the DDG RNRA GMD. Yes?
Yes, I'm sorry. Can you tell me the date of this document again?
This was May 2012.
Okay.
And the point that follows from that is that just as Mr. Minister Kamanzi said in his August 2011 letter to you, the obligations under Article 2 of the contract had not been satisfied.
Yeah. Sorry, I believe this to be a fraudulent document.
Mr. Immoner then goes on to deal with NRD's production figures, which he lists, and you can see the decline in production from those figures. Do you see that?
I don't believe those production figures to be correct.
And he then goes over the page, he makes an observation about NRD's production. If you just look over the page, please. He says, it should be noted that Nemba is responsible for more than 3/5 of the total cassiterite production. These figures show a very low production compared to any other company of this caliber operating in Rwanda. The NRD's total production per number of mine sites is probably the lowest in the country. Most of the cooperatives have recorded greater production compared to NRD, and that's accurate too, isn't it?
No, it's not. I don't recognize these numbers, and I find it impossible to believe.
NRD's production levels were not considered impressive by the government representatives, were they?
For example, in 2011, 62 tons is really only 2 containers. We were producing, in 2011, we were producing 1,000 kilos a day. That's a number for 2 months of production in 2011.
Well, just to be clear, if you scroll up a little bit, and if FGI could scroll up a little bit, Mr. Minister Immoner is making it clear, fairly, that production for 2011 is only January to June. So that might be what's confusing you.
Yeah,
That doesn't affect his conclusion he makes on the next page, which is what I'm interested in,
okay.
which is that the level of production is not considered impressive by the government geologists.
I dispute those production numbers, but let's go ahead.
Mr. Immoner then deals with the work plan and budget in the 2010 application, which includes the 382, pause there please FTI, includes the €382,000 budget for research and exploration. And his conclusion, you can see below that, is that the plan provided by NRD is neither clear nor detailed, no time frame, no budget. The planned exploration budget is unrealistic, small, compared to the planned activities. And that again chimes with Dr. Biriabarema's conclusions that he had reached earlier in his report, correct?
I fully agree that they colluded to write these reports. This 9,960,000 is the ministry's number. We never were asked any of these events for information about any of these items. In my opinion is that if they had wanted information which was substantive, they should have come and asked us. If this number 9,960,000 is from the draft long-term agreement, and so it's sort of a mishmash. He's criticizing the information that was given to us by the ministry and plugged into that document.
He's making it clear, isn't he, that the application you've made is neither clear nor detailed, and the exploration budget in particular is unrealistic at €382,000, and that's exactly the point made by Dr. Biriabarema. Yes?
Well, this is a hodgepodge, though. I'm not understanding what you're evaluating now.
And then if you look at his, well, we'll move on then. Let's look at his conclusions under, we go on to go further down. He says, in order to avoid granting mining permits to companies without financial and technical capabilities, in order to...
Hold on a second. This management section is interesting. During the last 5 years, NRD showed poor, weak management. This, apart from being noticed by Metadata and GMD, is also admitted clearly by NRD's chairman in its letter of October 14th, 2012. Well, that would suggest that this was written after October 14th, not March 2012, right?
Do you think there is a chairman's letter of October 14th, 2012?
I would guess. We can find out.
Well, let's do that.
I think this is the kind of thing that I find very disappointing. Is he's caught himself. He's referring to, he writes this perhaps as recent as 6 months ago, and he's forgotten that the date of the document is March, and then he quotes a letter from October. This is the kind of thing that I think is really unpleasant.
Now, looking at the substance of what he's actually saying here, during the last 5 years, NRD shows signs of poor, weak management. You don't disagree with that, do you?
Of course I do.
Well, wasn't that inherent in the November 2010 application itself? Because the application itself explained the change in financial expenditure on the basis that the previous management didn't understand mining.
Yeah, no, look, you really need to compare it to what the other mining companies are doing and all the challenges of operating in that environment. I believe that other than Rotungo, we were the best efficient, most professional run operation in the country.
And let's look at his
The fact that
conclusion.
he never came to even talk to us about any of these items suggests to me that this is fraudulent.
Let's look at his conclusion. In order to avoid granting mining permits to companies without financial and technical capabilities, in order to avoid companies that let dormant rich mining areas, we should not renew the 5 mining exploration mining permits applied for by NRD. The company has failed to its contractual obligations, hasn't demonstrated enough managerial, financial and technical competence. We shall allow them to select 1 or 2 areas within the 5 and request them to prepare relevant financial and technical plans that would be evaluated for eventual conditional licenses. And it's a fair conclusion that NRD hadn't met up to its contractual obligations, yes?
Sure.
And a fair conclusion are also Dr. Michael's
We've been
conclusions.
repeatedly told, other than Dr. Kamanzi's letter, Mr. Kamanzi's letter, been repeatedly told that we were by far the best application, by far the most professional managed company, other than Rotungo in the country.
But we've already seen a number of letters to you not making that point, and it wasn't just Mr. Kamanzi's letter. We've seen a number of letters already.
No, I think we were better than any other mining company in that country.
But your suggestion that that was what you were repeatedly told is at odds with all the correspondence that we can see about what you were told.
You know, my first comeback to that is, please give us our documents back and we can show it to you. There's nobody in the country who's going to say that we were not behaving professionally, did not have more equipment than anybody else. Of the supposed 395 mining companies in the country, 1 has a car. We had 18 cars and trucks. 18.
Now, this was in May 2012, and in July 2012, the NRD was notified that mining activities in Ritsiro were being suspended because of environmental concerns. You recall that?
Yeah, I don't recall what was the allegation though.
Don't worry, we'll come back to that. First, I want to just make sure we're both following in time so we don't get lost.
What's the date?
I'm trying to do it sequentially. So we've just looked at May 2012. July 2012, NRD notified that mining activities in Ritsiro being suspended. Just placing you in time.
Okay.
Before we go to that topic, I want to first go to an incident in early August 2012 involving Mr. Benzingi, which forms part of your complaint. Yes, so you know, so we're going to deal with the issue of Mr. Benzingi in early August 2012.
Yes.
And can I just see if we can start by agreeing on some of the steps in the story? First, Mr. Benzingi was one of the original shareholders of NRD. Yes, you accept that?
No, he was given an opportunity to purchase 15% share, and under Rwanda law, if you don't pay within, I think it's 2 years, you are not a shareholder.
Well, the allotment that he was entitled to was 15%. Yes.
He was given an option to purchase 15%. Yes.
And we agree, don't we, that around 2nd of August 2012, Mr. Benzingi was able to persuade people at the RDB that their corporate registration information for NRD should be updated on the basis that there were no legal documents justifying your appointment and Moroskova's appointment as directors. Yes?
No, we were told by the RDB when he was able, he appeared at our office and said, waved a corporate registration at us and said, I am the 100% owner of NRD. This was the first we'd heard of it. There was no notice. First thing we did was we went to the US Embassy and what do we do? And they said, well, please go down to the registry and find out what this is about. We went to the registry. The registry said, we don't have any documents for you. So under the guise of Ben claiming whatever he was claiming, he claimed to be 100% owner for reasons we couldn't understand and were not articulated, except that he had made a criminal threat according to the commercial registrar. And
I think you may be agreeing with me. Do you agree he was able to persuade people at the RDB to update corporate registration information?
I wouldn't call it update. I would call it defraud our investors.
Well, he was able. You're not suggesting that the RDP personnel that he persuaded were themselves fraudulent, are you?
No, I would say, according to their explanation, he threatened them with bodily harm, and so they did it.
Well, that's also not what they said, is it?
It is what they said.
Something
That's
else
what
that
I'm
you've
telling
just made up, isn't it?
you. No, you can ask Zuzana. She was there. She heard the same explanation.
The truth is much more prosaic.
That's what they
He
told
was
me.
able to persuade them that the information for NRD should record him and not you, correct?
All I know is that she said she had been threatened with bodily harm and that she made him the sole shareholder of the company. And he was claiming to be a cousin of President Kagame, and so they better pay attention.
Now, that led to a response from you to the RDB, including a letter to the RDB CEO the next day, 3rd of August, saying that Mr. Benzingi had misinformed the RDB and that the company should be changed, company information should be changed back. Yes?
Probably. I don't recall the letter, but that sounds like something I would have said.
I'm going to try. I don't think we need to go to the detail of the letter, but for everyone's notice, at R231, and amongst other things, you suggested there was a dispute about whether Mr. Benzingi was a shareholder at all, your
Yes.
position being that he wasn't. Yes?
For the reason I explained.
Do you suggest today that Mr. Benzingi is not a shareholder at all of the company to any extent?
Mr. Benzingi's lawyer has admitted several times in official proceedings that Benzingi did not pay for his 15% shares. So we had understood under Rwanda law, and maybe your expert can say something different, I don't know, but we had understood under Rwanda law, that means that you cannot later pay for the shares.
And your position at the time was that the RDB must have been misinformed or misled by Benzingi. Yes?
If I was being polite, that's the way I would put it. But the commercial registrar told us that she had been criminally threatened, and that's why she went along with it. And all of the documentation for the firm was at that point missing. There were no documents of any kind.
Well, as we see, and we'll continue to see, you don't hold back in your letters. And if you really thought that this had happened as a result of some physical threat from Mr. Benzingi, you certainly would have been trumpeting that loud and clear in your letters, and you didn't.
I think every circumstance is different. The criminal threat was not against me. This was the commercial registrar's excuse. She's a nice woman. Did I accept it at face value? Yes, I did. I don't know that she was corrupt. I think Ben Benzingi was scamming. He had no right to claim 100% ownership of our company. I certainly was upset, and that's why the first thing I did was went to the embassy.
Give me one moment. Thank you. But your position at the time, what you were saying to the RDB, was that they must have been misinformed or misled. Never suggested that there was some physical threat, did you? Never have suggested that before.
You know,
5 minutes,
the
2
thing
minutes.
that I learned from the very beginning about Rwanda was, unless the circumstances require it, don't do anything precipitous. Give people a face-saving way of getting out of something.
Mr. Marshall, your letters, we are going to see lots of them, are absolutely full of you doing things precipitous and making the most serious allegations all the time.
Yeah, but in what context? You know, if what you're saying, for example, is Ben Benzingi is now today taken your company, you own nothing. You've lost all the property you have and you have no recourse. That's upsetting. So what I do is I give the commercial registrar a way out, saying, okay, yes, there was a misunderstanding, and now the investment group from the United States has been returned to their ownership position. But it took 12 days. It was not quick, and we didn't get the bank accounts back for almost a month after that.
Let's look at R231.
Could I intervene?
Yes.
We're 5 minutes from
Yes.
closing time. I'd like to raise one matter of housekeeping. The tribunal have been provided with USBs with the documents on them, but we don't find them very user-friendly, in that the form in which the documents are presented are folders too small to identify individually. And to go to a particular document, you first had to go to the folder of the pleading in which the document was first introduced. Would it be possible at some stage, perhaps before we start at midday, so before that, for somebody to come to help put on our laptops the documents in a more user-friendly way? I think that can be done, but we would need some help with that. So that's the first point. The second point is that we've agreed that it would be extremely helpful at some stage if we could have an index with hyperlinks of the documents in chronological order with their C and R references, and with indications of those documents which are alleged to have been fabricated.
Yes, just
I
on
don't
the
know.
last,
That may be very difficult to produce, but if it's fairly easy to put the documents into chronological order, that would be a great help.
yes, just on the last point, I know indexes or indices of that kind already exist because I've got access to one in Excel, which is extremely useful. Adding, I don't know how easy it is to asterisk or something, those that are said to be fabricated, but I imagine what you mean by that is those identified in the party's position papers as being fabricated. Mr. Marshall, as we know in cross-examination, seems to be adding to the list. I don't know if you mean us to include anything that he suggests in cross-examination is fabricated.
Well, I think the answer to that is yes.
Right.
Because
Because
a separate list would probably do for that.
because we're learning about these allegations of fabrication for the first time.
Yeah. Anyway, if you can let us know when it would be convenient for us to arrive early so that we can have this data put onto our laptops, that would be enormously useful.
Yes.
Mr. Marshall, we weren't able to say goodbye yesterday, but we are today. And it's customary to remind witnesses that they shouldn't discuss the case over the adjournment with anybody. That's usually a relief.
Yes.
Very well, we shall adjourn until midday tomorrow.
All right. All right, Mr. Marshall, I'll go ahead and log out of the 360 on your machine and log you off soon. Thank you very much, and we'll see you tomorrow.
Okay, thank you.
Mhm. One second, Alex, and I'll answer your question, or we can go into a room to, let me just log off the 360, so there's no one.
Sorry, I didn't see your note.
Okay,
Alex? You're on mute.
Yes.
I don't know, obviously, but the first time what we sent around on the disk, I put up on my computer and started looking. I went with similar, I think similar questions. I worded it differently to Brian, saying I got to be able to find something differently than it's showing up here. If you go down, because there's so many tabs, because things are organized so many different ways, such a big spreadsheet, you go down to the bottom and you scroll, you make it with the arrows, go to the right, you'll find the tab with just the claimant's exhibits, just the respondent's exhibits. And because it's Excel, you can tell it by the date column, the number column, you can organize it by choice. That's why Excel was chosen. But finding the specific tab, instead of using the way of going into a pleading and then opening a document attached to the pleading, the documents, the exhibits have their own tab. So you can't open the first spreadsheet and see all the tabs. That was my problem. I wonder if it's theirs. So I'm just asking you if you could communicate that to the tribunal. Somebody look at their laptops. What they're asking to be put on might be there.
Okay.
I don't know, but it will save time and effort for everybody if my problem is solvable the same, is their problem and is solvable the same way.
Thank you, Mr. Cowley. And I mean, also, I was asking simultaneously to James that all the exhibits should be loaded in the FTI portal as well in a very easily searchable way. It doesn't quite work in the same way as a hyperlink index, but that's a second option too. So is that true, James?
I think we've used that too, and it's very helpful.
yeah.
They can't.
Yeah,
So I can.
But like I said, I think the problem with the spreadsheet, starting with the size, if that's the same experience, there may be more there than they're finding. So because of the way the Excel works, so much is so easy once it's in there to reorganize. If you find the right column and that's still their problem, then I don't want to mislead you. Don't continue to spend time on it.
Okay.
All right.
Thank you. Thank you. And we'll get this information to the tribunal. There's lots of ways to get to the documents.
Oh yeah, it's got to find right.
Alex.
Okay.
Yes.
I think you understand.
I don't think they read.
Yes. Yes, Ms.
Alex,
Doman.
can you hear us? Can you hear
yes,
me?
I can. Can you hear me?
Oh, thank you very much. The day after tomorrow, we start with other witnesses and also with French. And I have a question. I would prefer to listen to the French in its original, not in the translation. Is there any way in which I can hear the direct evidence from French witnesses and not only hear the translation?
James from FTI is nodding and I'm nodding. The answer is yes.
Excellent.
You would need a separate connection, right? Because if the other two panel members want to listen to the English, obviously you would have to log in separately. But there is a channel you could listen to everything being translated into French, meaning the English question. There is obviously the English channel, that's everything that's not in English translated into English. And then there is what's called the floor, where everybody's in the native language. So if you hear Mr. Hill ask a question in English, you'll just hear the French being answered. So you have a couple different options.
Okay, so there will be somebody perhaps helping us to deal with
yes.
that on Thursday.
And I do believe also that the French, the French will begin now on
Thursday?
on
afternoon?
Friday. I think
Friday?
yes, I believe that the witness, we will have interpreters on Thursday, but I believe that there was a change.
Okay.
And that the witness will, all French will go on Friday and Monday now.
Okay, thank you.
Sure.
Thank
I
you.
can,
I'd be grateful to be able to listen to the original, that's all.
sure.
Of course.
Very
Alex, would you like me
Thank
to email the IT folks there, and I'll coordinate the IT folks at the IDRC to get.
Thank you. And it should be
Great.
set
Yes,
up as of Thursday in case there's sliding back. We're farther ahead in the schedule. So Thursday morning, you know, or Thursday beginning of the hearing day.
Perfect. I'll coordinate.
Thank you very much. Good night.
Thank you all. Thank you.
All right.
Thank you.
Bye, everybody.
Bye.
Aye.